Unless it is extremely urgent, please don't mention. Yes, from that side. No, sorry. Next. Yes, Mr. Halda. Not right now. Yes. Yes.
52.
No, no.
New motion added yesterday, my lord. It's a tender matter, my lord. Whether rejection was on 8th December 2023, my lord. Kindly this the matter L1 whether, my lord.
So many tender matters, not right now.
Kindly consider, my lord, it's explicitly contrary to the term.
Maybe. Yes, next.
Lord, I'm mentioning for upgradation, item number 63 of today's list. The petitioner is in custody for 25.5 years.
Tomorrow top.
My lordship, petitioner is urgently in by financial crisis, loan completed, closure letter issued, but bank is not handing over the original.
This should take time. I'll come back sometime.
My lord, it is unlisted matter, my lord. Some tender applications, my lord. The last date, lordship, they file, lordship, the last date is 15th December, my lord.
Maybe.
Lordship, kindly appreciate, my lord.
No,
Last
file it in due course, please. Yes.
I have the lordship can leave to mention a unlisted matter, not very urgent in the sense that a 102-year-old liquor shop has been closed and the temporary license.
Not unlisted. Please file it.
Yes. But some urgency may be given, my lord.
No, not right now. Yes.
Because, my lord, yesterday only
No.
has been closed.
Yes.
For upgradation of a listed matter, item number 100, my lord.
What is the urgency?
My lord, the urgency is pertaining to electricity, my lord. An estimated and a very inflated bill is on an estimate basis has been sent to.
It will appear under the heading upgraded matters.
My lord, a group 9 motion, my lord.
The particular car, has been regularly deprived from COVID.
Not short.
Not inclusion of the list.
No, not right. Urgency. Title deed, please wait for some time. Yes. Wait for some time. Yes. What is the extreme urgency in your?
The urgency is that the WDSCDC is noted on supplying me any electricity.
Hand over, upgrade. Yes, you, the lady.
In the monthly item number 2012 to 21 to 232, my lord, the matter partly to the tender process. The petitioner.
Oh, wait for some time. No urgency. Yes.
In this matter, on 24th November 2023, the respondent one publish a notice in connection with the tender notice dated 26 October 2023. This
No, for the tender matter right now. I'm sorry.
extreme urgency is that
Yes.
earlier notice also cancelled arbitrarily in this tender also second.
Maybe not right now. Yes, Mr. No, you will mention last after the advocates. Yes.
My lord, a group 9 motion running on the list since long, my lord. What happened recently? The private respondents, they are going to raise a permanent construction.
Let me dispose of some of the upgrade matters first.
Entire front
No,
portion
this
of
is
my
not
land,
so
my lord.
urgent.
The PWD
Not right now.
authority
I'll
is
dispose of
taking
these
any step.
upgraded matters. Then I'll consider these. Yes.
For extension of the interim order.
Please hand over. Yes.
Why not look very urgent? Petitioner is old lady. She is not receiving her passport since 2021. She applied.
She can travel. She is not so old. So wait for some time. Yes. Sorry. Yes.
The matter appearing in item number 234
Yes.
in the comment, where it is a public library. The approach route to the public library has been obstructed by raising an unauthorized construction. So I went to the SG. Now SG issued an order directing the block development to remove it. But he is not taking any action. The moment I have filed this application, now a notice has been given to me that you please come. I want to settle it. Now, when the matter is pending, should I go or not? That is why I am mentioning, my lord.
Hand over. This will appear as upgraded matters. Yes.
Subject matter of
All right. No further mentioning, please. This gentleman. He is appearing in person. Not every day I cannot take up so many mentions. You please. Yes.
I'm a director of a one-person company, and my director identification number has been deactivated without any notice. As a result of which, I cannot file any mandatory compliance forms.
It is appearing as item number
45 in the monthly list.
Monthly list. It will appear as an upgraded matter.
Electricity line was cut.
No further mentioning today. Come back tomorrow. Next.
Cut the electricity line, lordship.
I'll not take a single mentioning further today. Please come back tomorrow. I'll call on the list now. Yes. Call on the list.
For judgment, item number 1.
Accordingly, WPA 25906 of 2023 is allowed on contest, thereby setting aside the resolution dated September 4, 2023. The respondent authorities shall now proceed with the tender process from the stage immediately after the last date of submission of bids on the basis of and in terms of the original tender document. If necessary, corresponding changes in the schedule of subsequent dates after the submission of the bids will be duly published by the respondents for such purpose, if so necessitated by the pendency of the present writ petition. No order is to cause certain certified copies. এটা কারেক্ট করে তারপর আমি সই করব। Next.
Do we mention item number 2?
Yes. Yes. Why is it appearing as to be mentioned?
Actually, in the morning, Lord Shiva and my
Yes.
petition his mother, there was a bereavement in the family.
Yeah, what did I do?
No, but please to pay, keep it in the
Monthly January list.
January.
Yeah.
But
So
Suddenly I mentioned on the recess because
now what do you want, please?
It has been
What are you mumbling? I can't hear you. Use the microphone. Look at me. Look at me. Look at me. Yes, use the microphone and tell me.
the interim order will be vacated on 22nd December.
Very well.
So
Milord, in this matter, may I just, Milord?
I'll extend the interim order only till January
Team
23rd.
has already taken the decision. Kindly, Milord, recall this matter that pipe.
Interim order was there, Mr. Gali. It has to be extended.
22nd
No, it has
December.
been finalized. The dispute which was going on amongst the villagers
Yes.
regarding supply of pipe water supply to the household.
What was the interim order passed?
Interim order that, Milord, the respondent authorities were trying to shift the instruments and the implements to other places because there were objections raised by some of the villages.
My lord, liberty was given to the petitioner to
You
make
are
a
restrained from shifting the apparatus
Yes, Lord.
already installed.
Because on the ground that the DM shed.
So that interim order has to be extended.
But in the meantime, it has been solved. Lordship had given the opportunity to the DM to intervene in the matter and solve the issue. So DM had called the villagers, passed an order. Their objections are found to be unfounded.
After the interim order?
Yes, Lordship at the end.
That's a violation of the interim order.
No, Lordship had given the opportunity. Milord. Kindly see. Kindly see, Milord.
There was a specific injunction restraining you from shifting the apparatus already installed on the land of the.
Not done. In the meantime,
So that interim order will be extended.
Kindly see paragraph 7. Accordingly, the respondent number 5, that is the DM, is directed to interfere in the matter and make an attempt by involving all concerned to resolve the issue at the.
So the issue has been resolved.
Yes, Lordship. Now I am.
How?
I am with the report of the TM. He
Yes.
called this petitioner as well as the other villagers.
What happened? What is the resolution?
So resolution is that no, your demand is totally unfounded. You cannot object to it. And Milord, the DM was pleased to direct the authorities. You carry on with the
Please
work.
take instruction. This will appear as to be mentioned tomorrow.
Yes. Carry on.
Although the matter had been adjourned on the prayer of the petitioner, on the mentioning of the petitioner out of turn, the matter is taken up today for extension of interim order. Full stop. Learned counsel for the state submits that in the meantime, pursuant to the direction dated November 23, 2023, the district magistrate has intervened and a resolution has been reached. Full stop. Learned counsel for the state seeks to file a report in that regard. Are you ready with the report?
Has been served upon the other side also.
File
ready
it.
with it also.
File it now. File the report.
I have served upon the other
The
side.
report is accordingly filed today and is kept on record. Full stop. A copy thereof is served on the petitioner, on the learned advocate for the petitioner. Full stop. The petitioner is required to take instruction on such contention and to apprise the court of the outcome of the writ petition accordingly. Full stop. For such purpose, let the matter stand adjourned till December 15, 2023, when it will be listed under the heading to be mentioned.
My lord, there is also a repeat.
Come back on day after tomorrow to be mentioned. Apprise the court. If it is resolved, then I'll dispose of the writ petition. Yes. Next.
Top item, item 3.
Yes, Mr. Bose. Yes.
But in item similar to IPA for the respondent, but I was seeking 1 day's time because this relates to election of a body. Now, there is a difference of opinion as to whether petition is maintainable challenging election. The Honorable Division Bench of the Honorable Chief Justice and Justice HON'BLE has differed. The Chief Justice has held it is maintainable Justice
I'll go with the Chief Justice.
Justice Bhatt has made the note, but the third judge is your lordship. It has been referred to your lordship on that question.
Mr. Bush, you must have had a hand in that.
Yes, I'm armed with the judgment and other judgments that of late the Supreme Court has pronounced. Since
If you are armed, I am defenseless. But if I am the third judge, Mr. Bush, that has been done.
kindly, my lord, decide the issue together, my lord, because this.
Together with that, how can?
Because your lordship, the matter has been referred to your lordship.
Not yet formally. Not yet formally.
Yes.
It has been referred
I have not been communicated. Formally means I have not been
No, but
communicated.
may I,
It has to be communicated.
In the case status, my lord, it shows.
It is appearing in the list.
No, my junior has instructed me.
No, Mr. Bush, it has been referred to me. I'll be taking up the matter sitting singly, or it has been
singly.
But then please give that slip, give that matter, the number. Ask your learned unit.
Mat 411.
Learned senior counsel appearing for the respondents at the outset submits that there has been a difference of opinion with regard to the point involved in the present writ petition, comma, more particularly regarding the maintainability of the writ petition. First up, the matter has been referred, comma, it is submitted, comma, for the opinion of a third judge, comma, before this bench. First up, accordingly, let the said matter be listed along with WPA 27672 of 2023.
Tomorrow.
Tomorrow, the file
tomorrow,
won't come. Day after tomorrow.
Day after tomorrow.
On December 14, 2023.
I am seeking only one indulgence, my lord.
Yes.
In state of, my lord,
under the same heading.
My lord, may it be taken up on Friday, my lord. Otherwise, my lord, I'm extremely grateful. My lord.
তাহলে যেটা বললাম ডেটটা বললাম এটা ডিসেম্বর 14 না করে ডিসেম্বর 15 2023 আন্ডার দ্য সেম হেড
Deeply obliged.
3 and 6 3 and 6 সেম অর্ডার তাহলে করে great
Deeply obliged.
fine 3 6 দুটোই আসবে প্লিজ মিস্টার দত্ত প্লিজ আস্ক ইউর লার্নার জুনিয়র টু গিভ দ্য নাম্বার ওটা দিয়ে দিও অরিত্র এটার সঙ্গে শোনো দিকে যে নাম্বারটা উনি দেবেন ওটা
Item 4.
Yes.
Is that I appear for the writ petitioner in item 4.
Yes.
Lord, there is a provisional attachment order.
Yes.
Issued by under the Prevention of Money Laundering Act.
Can I take up the matter? ED. All ED matters now, an objection is being taken by default.
No, but your lordship has dealt with that objection already in one of the judgment I find. And my lord has
thereafter, I mean, it has been a clarification has been given by the Chief Justice that police includes.
This is not lord investigation at all.
ED has been served.
ED has been served.
Who is appearing for the ED?
Hand service affidavit to serve.
Mr. Court, please serve a fresh notice and come back tomorrow.
Very well.
Please, sir. None appears for the respondents at the time of call, despite service. Full affidavit of service filed today be kept on record. Full to give a last chance to the respondents to appear and contest the matter, comma. The same is adjourned till tomorrow. Full the learned advocate on record for the petitioner is requested to serve a notice on his counterpart appearing for the Enforcement Directorate, indicating that the matter shall be listed tomorrow under the same heading.
Additionally, maybe serve on the solicitor to the central government also.
আচ্ছা যেটা বললাম serve on ED, comma directly and or through the learned counsel, usually appearing for the said respondent in the meantime.
Much.
4 and 7.
Pardon?
4 and 7 same.
4 and 7 all. 4 7 দুটোতেই সেম অর্ডার
ও থাকবে কালকে থাকবে ও একদম
এগুলো অরিত্র একসঙ্গে করে দেবে 4 7
yes
3
4 and 7 can be met.
Yes.
Item 5.
Yes. Good service has been effected. Come this side. Yes.
Now, this matter, my lord.
Yes.
The petitioner has participated in the tender process.
Right.
In connection to the tender notice number, annexure P1, lordship kindly see page number
Page number 29, madam.
Yes.
In terms of the tender notice dated 11/8/2023, and page number 30 is very important, Lordship kindly see. The date of submission of the tender bid, my lord. My lord, kindly see the date of submission of the tender bid, my lord. It was open on 19/9/2023, time 15 hours. And it has opened on 5th September 2023. And it will be closed on 19th September.
Document download end date online was 19 September.
Yes, 19th September. But I have submitted the tender bid within a cut-off date and beyond the within a cut-off time. But the private respondent, who is the party in this matter, he has submitted the tender papers after the cut-off time.
When did he submit?
Marat, he has submitted, Lordship kindly see, the tender paper. That is after the cut-off time.
Give me the date.
Yes. That is, Marat, the last date.
19
after 3 hours.
No, online submission last date was, document download last date was 19th of September.
Yes. 19th of September.
Online submission, bid submission, last date was 19th of September itself. Yes, right.
15 hours.
When did he submit?
Now, the private respondent, after the time, after 15 hours, he has submitted the paper.
When did he exactly submit? If you are on that, you have to give the exact time.
The exact time after 3:44 hours, madam. Now, Lordship kindly see, I am submitting the documents in respect of submitting the tender paper by the
Show me something to substantiate what you're saying that is submitted after.
Yes, Marat. That is, Marat. They have extended the time because of the private respondents, Marat. Kindly come to my lord, page number 3 to 4. Page number 3 to 4, it has start and the relevant pages, Marat. Note number 57 and 58. Note number 57, I am submitting, I am reading, Marat. Page 3 to 4. If called tender was issued on 11/8/2023.
Page number 324.
324, madam.
Note number 57, I can't find. It has been marked beyond recognition. This is 57.
Note
It's
number 57.
completely dark in my copy.
Yeah,
You
57.
should be careful what you are filing in court.
But I am reading.
Completely dark.
Yes, madam.
Anyway, what is
If
this?
called tender was issued on 11 August 2023. The last date of bid submission was 19 September 2023. But it has been noticed that no bidders participated in this bid up to 19 September 2023. It is absolutely wrong statement has been made. So as per discussion with the CEGAP, the TIA is proposing to extend the next date of bid submission for another 15 days. Considering days taken for paper publication, one bidder has already submitted paper for extension of bid submission, so and so. Now, on the basis of that, the superintending engineer, without approval of the chief engineer, has extended the time only because of private respondents. Malad, kindly see Malad, page number 310. How they have changed.
No right of yours has substantially been affected.
No, Malad, I am submitting, Malad. I am the only bidder.
This is
As
not
per the
sufficient to
finance
prepare-
rules, Malad.
This is not sufficient to issue a writ.
I am submitting, Malad. I am a valid tender.
Maybe.
I have submitted a bid within the time, within the date. Now, as per the finance rules, Malad. As per the finance rules of Chikanisi.
Final what?
As per the government of West Bengal finance rules. Lordship kindly see.
Finance rules, yes.
Yes. Now, this rule is specifically stated, Madam.
Yes.
Kindly come to page number. Page number 2. Page number 3, Madam. Page number 2, subparagraph for the publicity.
2 or 3 or 1 or what? You are
page-
once saying 2, once saying 3. Which page?
No, page number 3, Madam.
3, yes.
Yeah,
Which clause?
I am giving a pagination, Madam. Yes.
Right.
The whether the minimum mandatory period of submission bids as per the financial rules available to bidders from the date of publication newspaper, department website, etc. Now there is a clause, page 4, my lord. Page 4, paragraph 3, subparagraph D, Roman 1, my lord. The tender inviting authority may give an opportunity to the bidders whose technical bids are found defective due to minor clerical mistake, rectifiable deficiencies to explain their position within 7 working days through email. Now, what they have done, my lord, since the private respondent did not submit the paper within the time, they have rejected my bid without giving this opportunity.
Rejected your bid?
We rejected my bid. Kindly see.
They have said that no bid was submitted during time. So
But
you
they have
can file within the extended period. Why didn't you file during the extended period?
Well, they have rejected my bid. There is no ground, no
What is the
reason.
rejection?
Your lordship, kindly see the last page. One line, one order, my lord. Kindly come to page 342. In the one sense, they have time, I have not submitted a bid. Another time, lordship, kindly see page 342, rejected. Insufficient. Now, as per the final rule, I have to give an opportunity, my lord. This is the impunity is under challenge, my lord.
I don't get your point. Initially, the time for submission of bid was extended.
Initially?
The time for submission of the bid was extended.
Not extended.
3 to 4 is what you showed to me, that it was extended. And now you're saying not extended.
It was extended by the incompetent authority without any approval.
By the incompetent authority?
Yes. He has to approve from the chief engineer. Now he has extended the time only because of
every time I ask you a question, you are making out a new point. What is your exact point? Incompetent authority extended one. Secondly, your bid has been rejected.
Yeah, my bid has been rejected.
So if your bid has been rejected otherwise, I mean, you participated till you waited for that. So how can you reopen the issue of extension of the date now?
Yeah,
you submitted yourself to that.
No, I have submitted in the original date.
Submitted yourself does not mean submission of bid.
Yes.
You submitted yourself means you participated in that bid.
Yes.
Even after that extension.
After that extension
Even after that extension, you had participated. You waited till after the extension. You did not challenge the extension. Only subsequently, when your bid was rejected, you are coming up before this court.
My bid has been rejected by not giving opportunity to the finance rules, my lord.
Acha, very well.
It has not been given any opportunity.
Let me hear, Mr. Bandhu. 2 points. One is this incompetent authority. The second is this.
As far as the tender is concerned, the entire tender process has been cancelled because there were no sufficient bidders.
It has been cancelled.
It has been cancelled on 8th of December 2023. Well, I'm handing over the memo, one for my learned.
What remains in the writ petition?
Nothing as per my understanding.
But I have challenged the cancellation.
The cancellation is because of insufficient documents being submitted by the petitioner, not for any other reason. As far as the other participant is concerned, reliable take, they have also given insufficient documents. They have both being cancelled. There were no bidders to carry forward the tender process. The insufficiency as far as the petitioner is concerned, but it has nothing to do with the extended time at all. I also don't understand why this point is being canvassed. It is because there was a system of they were allowed to participate as a consortium. In the consortium, we found that out of the 3 constituents of the consortium, one of the parties being Ozone, this Ozone had no existence as far as the consortium is concerned. The PAN card says that ADO is a proprietorship of 1 person. The GST registration says that ADO is a partnership of 2 persons. And as far as the consortium is concerned, the proposed consortium has another 3rd member, that is Ozone. We gave a letter to Ozone itself saying that what is your connection with this consortium at all? But they replied, and that reply was not sufficient. We asked from the petitioner that you kindly give us the deeds, etc., or the agreements for the consortium of 2021. They said that I had submitted in my earlier tender process. If you have lost it, then I'll give you. I'll take your lordship through the documents.
In writing, you had asked for.
Yes, absolutely. They have replied to it. Kindly see, my lord, page 338. But my lord, 338, my lord, will not, my lord.
This I have clarified.
My lord, this, my lord, will not give a appropriate picture of the entire thing. If your lordship kindly takes
Parawise.
Page 326 first. So this will show what was the complaint against the petition. We received an objection from one of the parties. My lord will kindly take from 326, last paragraph onward, and marked as A. As per tender, the proposed consortium needs to be formed in future after selection of the bid and not to use existing consortium firm credentials. That is why the tender form says intend to form the consortium. But in the current case, the intended partners are not forming new consortium, but using old consortium name and papers, which was formed in 2021 to satisfy the credentials. The bidder has kept the name of the proposed consortium same as the name of the existing firm, Messrs. ADO Consortium, to create confusion and use the credential of already existing firm, which cannot be accepted as the tender requirement. Then next page. As per the tender, lead partner of the proposed consortium needs to satisfy the requirement, that is, the lead partner must have credential and satisfactory completion of the same nature of work of not less than 50% of the qualifying capacity as asked for the present tender in a single contract under any government or semi-government organization, autonomous body, as principal employer within 5 years. And the bidders need to provide information under the forms of form so and so and so and so in support of the lead member satisfying the required credential. However, in the current case, lead members of the proposed consortium, Messrs. AS Enterprise, declared under Form 2 that the qualifying condition is satisfied by a separate firm, Messrs. ADO Consortium only, and not provided anything for Messrs. AS Enterprise. We would like to highlight that Messrs. ADO Consortium is totally a separate entity which was formed in so and so. So, Malad, on the basis of these complaints, we asked for a clarification. They gave a reply to that. That is at page 328. Malad, I am not going into those queries because Malad, he has not placed it. Malad, your lordship will then come to page 333. This we wrote to Ozone directly. Kindly takes from 334, second paragraph of the letter.
Yes.
Starting with now.
Now,
during document verification, it has been noticed that as per the trade license, the firm, namely ADO Consortium, is a proprietorship firm of Mr. Swapon Mishra, is the proprietor, and on the other hand, as per GST documentation submitted by you, the same firm, Mrs. ADO Consortium, has been mentioned as the partnership firm, where Swapon Mishra is one partner and Dhiman Sarkar is the other partner. Both the government document, GST and trade license submitted for Messrs. ADO Consortium does not have any evidence of representation of the third company, Messrs. Ozone Research and Application Private Limited. So the submitted document pose a question on the legitimacy of the formation of the previous consortium firm, namely ADO Consortium, which was supposedly formed with 3 partner firms after getting LOA work order in the year 2021. But in view of this, we asked for a response from Ozone. Now, Malad, Ozone gave a reply. Malad, your lordship kindly takes 336. Second paragraph, starting with initially we. Initially, we entered into an agreement signed on 1st February 2021 for the project titled Rejuvenation of so-and-so, so-and-so, reference clause number 7, page 6, NIT number so-and-so, which was duly accepted from you. Subsequently, a current agreement was executed on 11th of September 23 for the project titled so-and-so. After 3 lines, the quotation ends in accordance with the tender norms as specified in clause 6F, page 3 of 7 of NIT so-and-so, dated so-and-so. Therefore, it is evident from your tender clause that the consortium firm is required to have an individual agreement for each work, and the document did not explicitly mention any restriction on the use of the existing consortium name. Secondly, the documents referred to you in your letter were accepted by your department, including the Office of the Superintending Engineer and the Office of the Executive Engineer and the sector accounts, all of which fall under the GAP wing of the W and S sector, KMDA, 2 years ago, as the state government department under the control of Urban Development Department has acknowledged by acknowledged the validity of this document and processed the payment with successfully deduction of GST, income tax, security deposit accordingly. So, Mala, their reply is that in an earlier tender you accepted these documents. So, in the new process you cannot question. But my query was, what is your role in the consortium? Because none of the government documents refer your name as Ozone. So, they completely bypass this answer. Then, my lord, kindly take 338, which is our letter to the petitioner directly, where we ask for these documents and numbered as 1 to 4. Now, kindly see the very interesting reply. Then page 339. Can I take the second double sentence paragraph? In consideration of the above, should the relevant documents be misplaced on your end, we kindly request you to inform us. We will then proceed to submit the required documents. But during a technical evaluation, my lord, we are entitled to call for the documents. We have called for the documents, but kindly sees every time they reply, they are bypassing the subject. First, they are saying that you have accepted 2 years back. Then they are saying if you have lost it, like the onus is on us. If you have lost it, then I'll give you. So, Malad, the subject matter is completely different. That what they are doing, they are supposed to make a consortium. They are bringing in people who, even otherwise, we have seen that they have no role in the consortium at all. But this is a government work which is to be executed. Malad, next, your lordship will find at 341 the rejection on 7th of December. Your lordship will find both AS Enterprise, which is the lead partner, and Radical Engineering. That is not the private respondent. Both, my lord, they were the participants, both for insufficient supporting documents, both technical bid has been rejected. And on 8th December, I have handed over the document. So this is the crux of the matter. No prejudice has been caused to him. Again, if the tender is invited, they can participate, my lord.
Malad,
Yes.
page number 30, 339, Malad. I have well explained that all the documents we have submitted in proper time, and they have accepted my credential. They have accepted the earnest money, Malad. Now, as per the final rules, I am the only one successful bidder. I have deposited all the papers along with the earnest money. But they have accepted the bid. Now, they have cancelled the one by not following the finance rules, Malad. And not only that, Malad, there is another memorandum is there issued by the government of West Bengal.
No further document in reply.
Malad, in these documents, Malad, there is a provision. After accepting the bid, there is a provision for rectification of any defect in respect of the papers.
Provision you have already handed over.
But I have submitted the defect.
Learned counsel for the
But, Malad,
petitioner contents.
only I am paying, Malad, I may be allowed to challenge the cancellation order. Malad.
Learned counsel for the petitioner contents that the petitioner was unlawfully shut out from a tender process by rejection of the petitioner's bid. Pusap, it is argued that although the petitioner submitted his bid duly within the time as stipulated in the tender document, along with all documents, subsequently the time for filing the bids was extended by an incompetent authority. Pusap, not stopping there, thereafter the petitioner's bid was rejected on technical ground without granting opportunity to the petitioner to rectify the deficiency. Pusap, learned counsel places reliance on a memorandum dated June 7, 2022. All of you, please take your seats. June 27, 2022, issued by the Government of West Bengal Finance Department, where it is stipulated, inter alia, that the tender inviting authority may give an opportunity to the bidders whose technical bids are found defective due to mistakes, rectifiable deficiencies, to explain their position within 7 working days through email. Push up next para. Thus, the impugned rejection of the petitioner's bid be set aside. Push up next para. Learned counsel appearing for the respondent authorities contents that the petitioner participated even after the extension of the last date for submission of bids. Thereafter, the petitioner was given ample opportunity to explain the deficiencies in the petitioner's bid. It is contended that the tender contemplated the formation of a consortium. However, the respondents were not satisfied with the documents submitted by the petitioners, which did not clearly disclose that all the alleged constituents of the consortium were actually part of it. After writing to the petitioner, when the petitioner was evasive in his reply, inasmuch as the petitioner insisted that due documents had previously been filed in a different tender, the respondents directly contacted the said constituent of the purported consortium, that is one ozone. However, being not satisfied there, the respondents wrote further to the petitioner. Next para, it is submitted that the petitioner then insisted that documents had already been submitted with the respondents in a previous tender, and again asked the respondents to let the petitioner know in the event such documents had been misplaced with the respondents. Full stop, it is argued that it is not the onus of the tender issuing authority to repeatedly satisfy a bidder regarding the deficiency of documents, full stop, since the respondents clearly disclosed the deficiency and gave opportunity to the petitioner, comma, the question of violation of the uh, finance rules do not apply. Push up next para. In any event, comma, it is submitted that subsequently, since all the participants had submitted deficient documents, comma, the tender process itself has been cancelled on December 8, 2023. Push up the petitioner, comma, in any event, comma, if otherwise eligible, comma, can participate in the fresh tender if and when floated by the respondents. Push up next para. Upon hearing learned counsel for the parties, comma, it is evident that the petitioner continued to participate in the process of tender even after the impugned extension of the last date of submission of bids. As such, comma, the petitioner cannot be heard to challenge the said uh, component of the tender process. Next para, insofar as alleged violation of the finance rules by not giving opportunity to the petitioner is concerned, comma, the same also cannot be accepted, comma, since ample correspondence was exchanged between the parties, comma, which have been annexed to the writ petition, comma, which go on to show that the petitioner was given sufficient opportunity to make good the deficiency. Next para. In any event, comma, since ultimately the tender process itself has been cancelled, comma, the petitioner always has the liberty to participate in a fresh tender, comma, if and when floated by the respondent authorities for the same work. Next para. From the materials which have been placed before this court, comma, I do not find sufficient ground to interfere with either the petitioner's bid rejection or the cancellation of the tender process. Next para. At this juncture, comma, learned counsel for the petitioner seeks leave to prefer a challenge against the cancellation of the tender process by the respondent authorities. However, comma, in view of the above discussions, comma, no sufficient ground has been made out by the petitioner on such count as well. Hence, such leave is also refused to the petitioner. Accordingly, WPA 27807 of 2023 is disposed of as infructuous, comma, in the light of the above observations on the merits of the case. However, comma, nothing in this order shall preclude the petitioner from participating in a fresh tender, comma, if floated by the respondent authorities on the self same work. If found otherwise eligible, comma, nothing in this order will prevent the respondents from granting the work order to the petitioner, comma, if the petitioner turns out successful in the said tender. No order is to cause urgency. Thank you.
Upgraded matter, item 8.
Yes.
Item 8.
Lordship, I appear for the petitioner.
Mr. Banerjee, you're for the bank. Oh, you're for?
I'm for the bank.
Yes. What is the case, Ms. Ghosh?
Lordship, the case is that, Your Lordship, I had entered into an agreement with SBI. Lordship, it's a body corporate, Your Lordship, and SBI thereafter decided to withhold an amount of rupees 20 lakhs and odd. Lordship, thereafter
Withhold means on what?
withhold, Your Lordship, on the ground that there was shortfall of payment of the Provident Fund, EPF and PF. But unfortunately and fortunately, they could not produce even till date that any proceeding was ever initiated by the Provident Fund authorities or there was any shortfall as such. Immediately that amount was withheld and thereafter my agreement was terminated. This was the entire conduct. I may be allowed to place, Lordship.
Affidavits are not directed in this matter.
Lordship, affidavits are complete.
Complete, right.
Lordship.
What is their stand? What is the stand there?
Lordship, their stand is, Lordship, their stand was in the affidavit in opposition. they had stick to the stand that there was shortfall in payment of the PF dues, but could not annex a single document. The first stand. Lordship, thereafter, they have referred to few clauses wherein they have stated that raising bills for its worker, the petitioner as proprietor also raised bills as supervisor, whereas the agreement provides that the supervisor is entitled to receive payment. Your Lordship, there are certain terms and conditions of the agreement, Your Lordship. And they have justified their stand of withholding rupees 20 lakhs and odd. Lordship, we had earlier moved the matter, Your Lordship, and thereafter the Honorable Court directed that the matter should be heard after exchange of pleadings and the amount beyond rupees 20 lakhs to be disbursed. I've received that balance amount.
What is the extreme urgency, Ms. Ghosh?
Lordship, the extreme urgency is that, Your Lordship, this 20 lakh rupees
But this is a
still
full-fledged
withheld.
hearing matter. So many other matters are pending which are extremely urgent, cannot wait even for a week probably. And if I withhold the court on this hearing matter,
Lordship,
what's the fun of
Lordship can take
I think I'll take it up after the vacation.
this side of the vacation.
This
any
side of
date?
vacation not possible, Ms. Ghosh. This is not such an urgent matter. This requires full-fledged hearing.
Lordship.
Definitely I have to hear them also.
Lordship.
Although the matter is appearing under the upgraded matters heading, comma, in view of no immediate urgency being involved, comma, let the matter stand adjourned and shall be listed in the monthly list of January 2024 for hearing.
Lordship, any date, Your Lordship, kindly.
Very well. Not
Lordship,
in the
kindly
monthly
give-
list, shall be listed on January 4, 2024,
Grateful to
fairly at the top of the list for hearing.
Grateful to Your Lordship.
Whatever.
Item 9.
For the petitioner, my lord, this is a case, my lord. The respondent authority, my lord, they cut down the tree more than 80 trees, my lord, without informing the petitioner, my lord. The petitioner is a very poor man, and the source of
Without
income-
informing you means you are the owner of that plot.
Yes, my lord. I am the owner of the land, my lord.
Right.
My lord, 2 simul tree, 3 shishu tree, 18 mango trees, my lord, without informing the petitioner, my lord. Thereafter, my lord, the petitioner made a representation, my lord, page number, my lord. Page
Any
number,
law,
my lord.
legal violation? What is the law which has been violated? If there is no legal right infringed, then we cannot pass any order in writ court.
My lord,
Either it has to be
my land-
constitutional right or has to be a legal right. What is your legal right on that? As the owner of the land, you have a right.
My lord, I am the owner of
That you have in a civil court, you have to file the suit. You have to file a suit that they have caused damage to your property and
my
you
lord, kindly
can
see
claim
the page
damages.
number 14, my lord, my representation.
14, yes.
And then, my lord, reply, my lord.
Compensation you are asking for. So they are doing some project there.
Yes, my lord. My lord, kindly see the page number 14, my lord. The
Page
high
14, yes.
voltage electricity project, my lord,
Right.
has been run over the mentioned civil bureau land, my land.
Now you are wanting only the compensation?
Compensation.
Yes, Mr. Padre.
Here we offered this.
So calculate within a reasonable time and what time would be reasonable?
Calculated.
What is the calculation?
59.
Can I direct you to file a short report with only that calculation? The breakup and the calculation, please file it to day after tomorrow with a copy to him. I'll record that they have calculated. A copy will be given to you. A copy will be filed in court. I'll take it up day after tomorrow under the same heading. If you have any objection, I'll give you liberty to challenge before the appropriate forum. Otherwise, I'll dispose it. Yes. Can't hear you, Mr. Pandey. You have to switch it on probably.
Switch off.
No, switch it on. It's better. Hearing you shout.
Now, my lord, one indulgence. My lord, if the report is signed by my officer, obviously, then 1 or 2 days more.
Otherwise, who will sign it?
We have
Your
no-
officer obviously has to sign it.
So Miller, my
When should I keep it? Day after tomorrow? No, after that. I'll keep it on Friday.
Friday.
The petitioner submits that several trees of the petitioner's property have been felled, FELLED, by the distribution licensee while electrifying the locality. Pushed up next para. It is submitted that high tension line has been taken over the petitioner's property. Pushed up, the petitioners seek damages / compensation for such damage caused to the petitioners. Full stop, next para, learned counsel appearing for the WBSCTCL submits on instruction that the WBSCTCL has already made due calculations regarding the compensation payable to the respondents, to the petitioner. Full stop, next para.
I am for the WBSCD.
Who are you?
ACTCL.
TCL. তাহলে DCL না করে ওটা TCL করে দাও। পুরোটা TCL করে দাও। Accordingly, to resolve the issue, the WBSETCL TCL transmissioner is directed to file a short report indicating the breakup of the calculations and the total quantum of compensation payable to the petitioners according to the WBSETCL with an advance copy to the learned advocate for the petitioner. Push up. The matter shall next be placed under the same heading in the list on December 15, 2023, when such report will be filed. Push up. It is kept open for the petitioner to make their contentions regarding whether they accept such compensation or not. Push up. Let the matter be listed as directed above for passing further orders. If you agree, then I'll direct that to be paid within a limited time. If you don't agree, I'll give you that liberty to challenge it before the appropriate.
It would be pleasure for your lordship fix the matter on 14th because my underfriend won't be able to come.
Very well.
14th.
14th is day after tomorrow. I was going to place on that date in the first place.
Yes.
14th thale kore daw, not 15th, 14th.
Sorry to disturb you.
No question.
But in this matter, we have no role.
No, you have not role. Apart from earning fees. So that's why I have not deleted your name.
Item 10.
10. You are for the respondent?
Yes,
My lord, I am appearing for the respondent this matter.
Yes.
My lord, this is a virus to Rule 8. My lord, this matter, my lord, what I find, my lord, erstwhile Advocate General had completed his submission. My lord would find in the order dated 2nd December 2022.
Second December 22.
Yes, my lord. Yes.
Very well. Then it should be heard by Justice Bhattacharya.
No, my lord, thereafter, my lord, when the petitioner's turn came, my lord would find the order at page 13 February 2023.
Yes. What happened?
My lord, kindly, I'll not say anything. My lord would kindly see.
What is the meaning of this, Mr. Chakraborty? What happened actually on that day?
My lord, I was not there in the matter. 2023 at this stage, I was not there. But what I find, my lord, the virus, my lord, at this stage, subject.
Mr. Chakraborty, let me hear Mr. Sinara. Yes.
Yes. Actually,
What happened?
I was directed to give a short list of dates, my lord.
Which you did not. Obviously, you did not.
No, my lord, I have prepared, and when I was prepared with this short list of dates still with me, my lord, short notes of argument still with me, my lord. And then on the crux of my argument, my lord.
It has been substantially heard by Justice Bhattacharya. So why should I hear it at all? Go before Justice Bhattacharya.
My lord, if your lordship.
It transpires from the order sheet that the matter was substantially heard by the Honorable Justice Moushumi Bhattacharya and the learned advocate general had concluded his arguments on the virus of Rule 8 of the West Bengal Excise within bracket selection of new sites and grant of license for retail sale of liquor and certain other intoxicants bracket close rules 2003. Full stop, next para. As such, for the sake of propriety, the hearing of the matter should be concluded by the said bench. Full stop. Accordingly, the matter is released from my list with liberty to the parties to seek an assignment before the bench comprised of the Honorable Justice Moushumi Bhattacharya for conclusion of hearing.
Madam.
In such cases, please point out at the outset that it was substantially heard before some other bench.
My lord, I tendered apology for
Apology accepted, Mr. Chakraborty. Yes.
11.
I'm grateful.
11.
Lordship, I am appearing for from behalf.
Service.
Service.
Why do you have to remind in every matter about service? What do the envelopes say?
It says
Okay, though.
refused.
Check up. You're not
Refused.
sure. Check out at least random at random one or two. All
This is
refused.
refused. This also refused.
Your client was there. He was signing. He was refusing on behalf of the other side.
There is private
You decide
respondent.
together in the same place. Petitioner and
In same
respondent.
place.
So your client must have been refusing on behalf of the respondent.
No, no. No such
File it.
communication was there.
Yes, what is the matter?
My lord, matter is about the petitioner have landed property beside PWD land.
No, the government, the authorities you have not served. They have received. They must have
Yes.
They received.
Authority has already received, and after receiving this writ application,
Yes.
my lord, the authority has sent a document. Lordship, it is with my application.
Tell me what is the matter about. Tell me what is the matter.
The matter is the private respondents are encroaching the PWD roadside area and thus blocking my ingress egress from my property.
Any proceeding has been initiated? You wanted a proceeding to be initiated against them.
Lordship.
What happened after that? What has been written to you?
No proceedings.
What has been written to you by the authorities? You are saying something?
Authority said that a demarcation program is needed adjoining of Dag number
I'll dispose of
so
the writ petition, direct the authorities to immediately take steps on that.
to determine the government of
I'll dispose of directing them to take steps for removal of encroachment, first to ascertain, then to take steps.
Lordship.
None
Otherwise,
appears for the respondents at the time of call, despite service, full-stop affidavit of service filed to be kept on record, full-stop. Although the private respondents have refused to accept service, comma, it is deemed that such refusal tantamounts to good service. Full-stop, the matter is taken up for hearing. Stop. The limited grievance of the petitioner is that the private respondents have been encroaching on government property for which the petitioner complained before the respondent authorities, comma, but to no effect. Full stop. Although it has been intimated by the respondents to the petitioner that demarcation program is going on, comma, the same apparently has not yet been fruitful insofar as no proceedings have been taken out against the private respondents. Full stop. Next para. In view of the innocuous nature of the prayer, comma, no further service is being directed. Full stop. Next para. WPA 21483 of 2022 is disposed of by directing the respondent number 2 to ascertain, comma, if necessary, by calling for a report from respondent number 4, that is the block development officer, comma, Shampur Roman 1, comma, as to whether any encroachment has been made on government property by the private respondents. Full stop. Next para. Such exercise shall be completed at the earliest, comma, positively by February 10, 2024. Sorry, positively by January 10, 2024. Full stop. Next para. Immediately thereafter, comma, in the event it is found that there has been any encroachment, comma, the respondent authorities shall initiate proceedings for eviction of the illegal encroachers under the appropriate provision of law. Full stop. It is expected that such proceedings shall be initiated within a fortnight from the date of within a fortnight thereafter. Full stop. Next para. The parties shall act on the communication of the learned advocate for the petitioner coupled with a server copy of this order for the purpose of compliance with the above directions without insisting upon prior production of a certified copy. Full stop. The learned advocate for the petitioner shall communicate this order to the concerned respondents stroke authorities within a week from date. This will be on the server by tomorrow. Communicate within a week so that they can start proceedings.
Smile. I'm great.
Huh? Can such and such is accordingly disposed of as well.
Great.
Item 12.
I appear for the
Lordship,
petitioner in
before
this matter.
proceeding, Lordship, I have been handed over with a supplementary affidavit.
Copy.
This is on 7th, on 7th of this month, Lordship. So this is something new information which is not in the REIT, Lordship.
Obviously, that's why
Yes, Lordship.
Yes.
I do
No,
not
one
have the
thing, my lord, I
instruction
tell
in
you,
regard to that because there a hearing was conducted and they are saying that the hearing they have received the notice after the date of the hearing. Lordship, I do not have
My
any.
my term after service of the writ petition,
yes,
they have not given me any notice. 12th of September hearing date.
What did you challenge in the writ petition in the first place?
Show cause notice. Show cause notice, my lord, for the purpose of conduct of the hearing. And my lord, we also file an interlocutory application also praying that that proceeding should not be taken away further. 4th of December on mobile of some other friend, I came to know about the order. I have not been communicated the order even. 12th of September order was passed terminating my certificate, SC certificate, and I was served with the said copy on 13th of September by registered post. The document I have annexed.
All this has been done during pendency of the proceeding.
During pendency of the proceeding. Malad, kindly pay look to this for once in my annexure. My cousin brother made a complaint. Page 10, Lordship will kindly come. The notice that was scheduled date is 12th of September 2023 in the supplementary affidavit.
This is because for the purpose of what?
For the
Cancellation of SC certificate.
Cancellation. Entire cancellation has been
It
done.
has now been cancelled in the meantime.
It has been cancelled in the meantime. And that notice was given for hearing on 12th September at page 10. And I have received it on 13th of September.
Mr. Bhattacharya, satisfy me on the merits of a writ petition. If I am satisfied, I'll set aside everything consequential.
First of all, I have
not, then I'll dismiss the writ petition.
Further, very first point I am taking that I have not been heard. Ex parte order, whether you can maintain an ex parte order or not. The authority, I am looking.
So subsequently, notice of hearing was given to you.
No subsequent hearing. Final order.
You have said you came to know that a hearing has been done.
Yes, over the mobile I came to know. On that day, hearing was over. Order was passed on 22nd September.
That was annexed.
That on that day, hearing was over and order has been annexed to a lordship's petition.
What was the initial ground of challenge?
Initial ground that I belong to a SC category. My father is SC. My family is totally SC.
Mr. Bhattacharya, since the order has been passed, challenge that order.
I am challenging that order is expressly illegal because it is passed in my absence. First of all, Lordship will kindly come. I have taken the point in my supplementary affidavit. May I place it for your Lordship? For my satisfaction, I will not trouble your Lordship.
No.
Lordship, kindly come to my page 2. A notice of hearing was page 2, paragraph 2, yes. ABC. First, a notice of hearing was issued on SDO directing the matter to be heard on 12 September regarding the legality of the caste certificate issued in favor of the petitioner. Petitioners were not served with the notice before the date of hearing. Petitioner received the said notice 13/9, day after the hearing was over by registered post. Till date, no order has been served upon us, but the Facebook on one named Udayan Sinha shared an order of 22nd September passed by the SDO in our case, which I collected from the Facebook online social media on 4th of December 2023. Malad, kindly come to B. Hearing of the proceeding behind the back of the petitioner without affording an opportunity to the petitioner to defend the case is expressly illegal and patently bad. But I am not to repeat further. C. Order of SDO is bad in law as no copy of the alleged complaint. First of all, no copy of the alleged complaint made against the petitioner by their cousin brother was ever served on the petitioner, and the tenet of such complaint and the scope thereof is totally unknown to the petitioners. Moreover, the inquiry as was held by the Joint Block Development Officer, Kharagpur Local, as depicted from the said copy of the order dated 22nd September 23 was not ever served upon the petitioners.
Mr. Bhattacharya, first let me ask you, learned friend, why I should not set aside this order on the ground of non-service. If I set aside, then I'll relegate it back to the
Lordship, as far as my instruction goes, the last instruction which I have received was in the month of April. So till at that point of time, another hearing notice was given to my learned friend.
After this order is passed?
Prior to this order was passed. So this is the second notice what he has been referring
but the
to.
order does not reflect any contention of theirs. It only says
Yes,
complaint
because
dated
in
such and such, these materials, no proof that it has been, the documents have been served on them or that they were even heard.
Yes, Lordship, this is a subsequent event which I do not have the instruction. I have the
Would have had
instruction.
instruction. They have served you on 7th.
Lordship,
Today we are on 12th, 5 days ago.
yes, the matter, they have mentioned the matter yesterday and today the matter was in the list. Lordship, I sought for the instruction. Lordship kindly keeps it. Tomorrow I'll come back with
I am
instruction.
going prosecuting the
And
courts of
Lordship-
MD.
Lordship,
But I have passed
One other
Then
thing, Mr.
Lordship, one-
Bhattacharya, regarding the main challenge. I mean, show cause, what was the ground of challenge? On merits, show cause stage, why should you interfere?
in the writ petition. But
Yes.
which Suka's point was taken, the scrutiny committee should have the power.
Yes.
You cannot, SDO has no power. That is why
Lordship,
the Suka's was the
Very
here
take
I have
instruction.
got the notification wherein the SDO has got the power, Lordship. He can appoint a
I'll hear
committee.
it comprehensively tomorrow. Take instruction on whether notice was given to them.
Yes.
If notice
Yes.
was not given,
Then
then in any
Lordship,
event,
they
I'll
have a
satisfy.
valid ground. I understand, Lordship. I'll come back
Very
with
well.
the instruction tomorrow.
The petitioner has challenged in the writ petition the issue, a show cause notice issued as to why the petitioner's schedule caste certificate shall not be cancelled, pushed up during pendency of the writ petition, comma, allegedly without giving any notice of hearing to the petitioner, comma, an order has been passed by the concerned authority cancelling the said certificate of the petitioner. Push up, learned counsel for the petitioner files a supplementary affidavit with leave of court, which is kept on record.
grateful.
Pushed up, in the supplementary affidavit, comma, a challenge has been thrown to the subsequent order passed during pendency of the writ petition. Push up, next para. Learned counsel appearing for the state seeks a day apostrophe time to take instruction on whether due notice was served on the petitioner prior to hearing, prior to passing the order cancelling the petitioner's schedule caste certificate. Push up. For such limited purpose, comma, the matter is adjourned for the day and shall be taken up tomorrow under the same heading.
Great.
Come back tomorrow with instruction.
Yes, Lord. Grateful, Lord.
সেটা তো জজ সাহেব জিজ্ঞেস করছেন ওইটাই
I'll hear out the entire matter, lock, stock, barrel.
Entire matter, but other
If you cannot satisfy me on that notice, service of
Yes,
notice,
Lord.
maybe I set aside the order also.
if the side, if any notice is they satisfy us, my lord.
Show cause notice also I'll have to hear you on that.
Other point, my lord, I shall be
Show cause notice point remains. Yes.
grateful to you. Lord.
Item 13.
13, my lord, I am appearing
Yes.
on behalf of the petitioner, my lord. My lord, she is one acid attack victim, lady, my lord, 100% disabled.
Please come closer to the microphone, Mr. Chatterjee.
Sorry, my lord.
What about service on the state?
My lord, yes.
Good service?
Yes, my lord.
Regarding upgradation, have you served?
Regarding upgradation, we
Yes, what is the
my lord, what happened in this case? She has received rupees 3 lakhs till date, but she is 100% disabled. Her face has completely.
Chatterjee, isn't there a scheme for this?
My lord, yes. I have annexed that scheme, my lord. Page 51 onwards. But the most relevant portion.
The Legal Services Authority
Yes.
also has a scheme.
My lord, this is victim compensation scheme for sexual assault and acid attack victims. And
This is under the Criminal Procedure Code.
my lord,
This is under which act?
my lord, this is a compensation scheme, NALSA scheme, my lord.
Yes, NALSA, right.
NALSA
NALSA,
scheme.
yes.
Page 49 onwards.
Right.
And the most relevant portion is page 61.
Right.
Schedule applicable to women victim of crimes. Column number 13, victims of acid attack. In case of disfigurement of face, rupees 7 lakhs minimum. Upper limit of compensation rupees 8 lakhs. But my lord, your lordship knows on several occasions, Honorable Apex Court as well as our Honorable High Court also has expressed their desire to not to limit the upper, my lord.
What has been done in your case?
My lord, only 3 lakhs given. But my lord,
That is even below the minimum limit.
yes, my lord, and not.
Yes.
I
sorry.
have stated in paragraph 19 that I have day-to-day expenditure, eye drops, and my lord, several surgeries were done. Several more surgeries are required. At least, my lord, I have my prayer is up to presently 8 lakhs, my lord. Presently.
Mr. Chatterjee, what any reason has been given by them for giving such a low amount?
No, my lord. Generally, what happens?
What is the order?
Yes, my lord. Page 47, the last page 47 is the order.
What is page 64?
Page 64 is, my lord, page 64.
There was an appeal?
Yes, no, page 64, 2 acid attack victims, they received more than 7 lakhs. That order I have given.
Very well. Let us
this
come back
can
to
be done.
Let us come back to 47. Yes.
Page 47.
Have they said that there is no total disfigurement?
No, my lord, that has not been said. Fund sanctioned, my lord, sanction is hereby accorded to the allotment of rupees fund 3 lakhs only under various heads of accounts in favor of sub-allotting officer so and so, so and so. Fund sanctioned above is being placed in the disposal of district magistrate. Why they have given rupees 3 lakhs? There is no, my lord, explanation. Initially, as per Honorable Apex Court's order, they disbursed 3 lakhs because Honorable Apex Court stated that pay 3 lakhs first. Thereafter, we'll see how much they required. My lord, thereafter, my lord, on Prime Minister scheme also, my lord, pays 1 lakh, but I have not received that also.
Show me something, discharge, the discharge summary is there, something in writing to show that the relevant medical authorities have said that it's total disfigurement or something. I'm seeing the photograph,
I
obviously.
have disability certificate, my lord, 100%
Just show me that.
disability.
Yes, show me that.
It's page 45. Page 45. Column 3.
At order record corner. Despite service, none appears for the respondent authorities. Full stop. Affidavit of service filed to be kept on record. Stop. This is an open and shut case. Full stop. The petitioner, as evident from the photograph of the petitioner annexed at page 19 of the writ petition, as well as the disability certificate at page 45 of the writ petition, is suffering from 100% disability due to complete disfigurement in view of acid attack. Full stop. Next para. The documents annexed to the writ petition sufficiently establish such fact. Full stop. Learned counsel for the petitioner places reliance on the compensation scheme for women victims stroke survivors of sexual assault stroke other crimes, in particular the schedule applicable to women victim of crimes, to argue that in case of disfigurement of face for victims of acid attack, the minimum limit of compensation is rupees 7 lakh and the upper limit is rupees 8 lakh. Full stop. Next para. However, a meager amount of rupees 3 lakh was awarded to the petitioner in terms of the order dated August 22, 2016, annexed at page 47, which is merely an allotment order, without any iota of reason as to why the minimum sum was not given to the petitioner. Full stop. Next para. Upon considering the materials annexed to the writ petition, this court is completely satisfied that there is no reason why the maximum upper limit of compensation for victims of acid attack suffering from disfigurement of face should not be given to the petitioner. Full stop. Next para. Since the petitioner comes squarely within the purview of such victims, the only course of action for the respondent authorities was to disburse the entire amount of rupees 8 lakh to the petitioner, of course, under the aegis of the concerned scheme. Full stop. Next para. Accordingly, WPA 9960 of 2023 is allowed, thereby directing whom should I direct? The state generally.
My lord, this
Who has to pay, and
yes,
state obviously has to release the amount.
SLSA.
Right.
SLSA.
Directing the respondent number 1 to directly respondent number who should disburse the amount? 3.
6. No, my lord, sorry.
Release the
Principal Secretary Home. Yes. Principal
by
Secretary.
directing the respondent number 3 to ensure that the total amount of rupees 8 lakh is immediately released to the respondent number 6 for the purpose of disbursal to the petitioner. Push up. Such release shall take place at as expeditiously as possible, positively within January 15, no, within January 15, 2024. To the petitioner, in terms of the provisions of the compensation scheme for women victims stroke survivors of sexual assault stroke other crimes, comma, 2018 as annexed to the present writ petition. Full stop. Yes, no rest to question.
Lord, I have two small prayers, my Lord. I have given in my prayer portion, though there is no rule has been formulated, but if a pension can be granted, because my Lord, day to day, they will not get any job anywhere.
Is there any provision in the scheme?
My Lord, no.
Should I have to carve out that? I mean, is there any provision in the scheme? No.
No, my Lord, there is no provision in the
Article line
scheme.
add করে দাও। As rightly pointed out as rightly pointed out by learned counsel for the petitioner, comma, the respondent number 1 state, comma, in tandem with respondent number 6 shall also formulate a comprehensive scheme for grant of a regular pension to victims of acid attack similarly placed as the petitioner. Full stop. It is expected that a formulation of such a scheme shall be effected at the earliest, comma, positively by January 31, 2024. Full stop. As and when formulated, comma, the petitioner's case shall also be considered, comma, subject to the petitioner applying for such scheme, comma, under the said pension scheme.
Grateful, my Lord, grateful.
Next.
14.
Yes.
My lord, I'm petitioner in person.
Yes.
My lord,
Your Miss Suleiman.
Shagufta Suleiman, yes.
Yes, Miss Suleiman, what is your case?
My lord, I have served the copy to state only, not to the opposite party. When
Opposite parties are unnecessary parties. Let
My
us see
lord.
who they are. What is your, but they have to be served also.
My lord, when actually I have got several orders for protection, and after the
What is your case? Tell me that.
my lord, I am staying with my sister alone. Our parents are not alive, and I have filed one petition for the police in action for unauthorized construction. There are several unauthorized construction going on in our locality. Our house is surrounded with unauthorized construction, my lord. And these builders are utilizing drug peddlers, and they are also torturing us from very long time.
Please file an affidavit of service at least to show that the writ petition has been served on these persons.
Yes. Sure.
That is, private respondents have been served.
No, my lord.
Why?
Because when I approached to LD court for 144, when I was not getting any favor from anywhere, I approached 144 on 15th of March. The police took no initiative to stop them, even not implemented the order of
Ma'am,
144.
you are making serious allegations against those people, which may be correct, may not be correct. Now, unless those people are heard or given an opportunity of being heard, I cannot pass an order in your favor.
My lord,
You at least have to serve the writ petition. They won't know an order will be passed
my
against
lord,
them.
I am requesting to give this order to the police so that they can serve the notice to them, because they are attacking us, my lord.
No, serve through through the postal service.
When we have served the, when the police came to serve the, show cause notice, when it was show cause notice, was the order.
No, you can put it in course of service through through the post office. Served by registered speed post with AD.
My
Do
lord,
that.
when the police came on 14th of April to serve the show cause notice, they attacked us and went to the police station and make two fabricated FIR against me, my sister, and my elder brother, who stays far away since his
You
childhood.
have lodged complaints with the police.
My lord, I am an accused, so I do not have any right to give any complaint.
Who told you that? Any accused person is also.
Yes, my lord, IO told me, and the IO told me also, if you will keep your mouth shut, withdraw all the cases which are pending in court, and we will make FRT for the both cases. But I approach later on, I approach for the public interest litigation on July 27th, which was restored again, and I got the judgment on beating of drum, my lord. Then they have seen that I approached for the, public interest litigation. They submitted charge sheet also. These people are attacking again and again verbally. We can't see when they are staying in our premises, my lord. It is very difficult to
You
say.
have to serve copies on them. In the meantime, if you want, I can grant you police protection. That I can grant you.
My
But
lord,
you will have to serve on them before I pass final orders on.
my lord, I will serve. My lord, I want to say one more thing, my lord.
Yes.
Police are sitting, if police are giving, but they are inactive. They are not allowed to act. Even in front of the police, they are torturing us, humiliating.
Which is the police station?
Park Street.
Pardon?
Park Street
Park
Police
Street.
Station. My lord, kindly just see the can petition I have given. I got the order on in page number 29 to 32 and 34. Armed picket was provided for 2 months. But my lord, they were inactive. They were not allowed to act.
What is the accusation against you? What is the allegation against you?
Molestation and
Against you? How can you molest?
my brother. Before that, my lord, two fake. This is the 4 FIR has been done against me, my lord. Before that, 2 FIR has been done. One was quashed.
So your case is that you protested against the drug peddling.
Yes, my lord, they are getting inside our premises. Just kindly see in page the order 23366, my lord.
Which page?
In can petition, my lord, page number 27.
Yes. This is a police report at page 27. Not an order, it's a police report.
My lord, just I have made.
Let me see this.
I'm sorry, I'm talking about can petition, my
I'm
lord.
looking into the can only.
Maybe I have done
Please
mistakes.
take your seat, ma'am. Let me go through this. I'll call upon you. Take your seat for 5 minutes. I'll call up. So what is the relief you seek in the writ petition? Please stand up. What is the relief you seek here? Police protection.
My lord, not police protection. I'm seeking for justice, my lord. This is
Justice in what form?
This
Justice may come in many forms.
injustice going on.
What do you want exactly? What is the relief you are seeking?
Police is torturing us. One thing, my lord. My lord, I just want to this. After armed picket, which was removed on 24th of February 2022, I approached LD court. I was not getting any relief. Then I approached for 144. The magistrate has given order for implementing no breach of peace, but police take no initiative. Later on, and he made one fabricated statement, my lord. Just kindly see the affidavit of Dr. S.S. Day. He made his statement so that I will not get any 144 or 107. Him witness.
This is entirely in your favor.
Yes, my lord.
Yes, what do you say?
No.
Her allegation is that the private respondents are drug peddlers. She has been protesting and they are harassing like anything.
That I think.
What is the action taken by the police on her complaint?
I'm telling if he served the other private respondent, I have already collect the latest report within.
This does not have anything to you have your own report. I don't want this is not about the private respondents. Why is she not getting police protection?
Typically give the I give that protection to you as your lordship.
My lord, they are giving fabricated case so that they can.
What are the present cases pending against you? What allegations have been made against you?
My lord, case 30 FIR 34 and 35 GR 4.
What is the accusation against you? What are you doing according to them?
My lord, molestation. I am giving allegation. They are saying
What allegations are they giving against you?
molestation. One, my lord. I just one moment, my lord. Respondent number 8.
Where is their complaint? You have annexed their complaint. Have you annexed their complaint against you? For the time being, I am wanting what allegations have been made against you.
My lord, give me some time. I will serve the copy to them and I will annex all the FIR and everything, my lord.
So take this back.
Yes,
I'll
my lord.
grant you leave to file a supplementary affidavit. How soon can you come back? We are closing on 22nd December. Today we are on 12th. How soon can you come back with your?
My lord, before
Before that,
vacation.
can you serve them? Send immediately today itself. Send by registered speed post with AD and file an affidavit of service on the next date.
Lordship.
So although an affidavit of service has been filed today, comma, it does not appear that the private respondents have been served properly. The petitioner and the state are represented. The petitioner, comma, appearing in person with leave of court, comma, contends that she is being harassed by the private respondents who are drug peddlers and antisocials in the area. When the petitioner went to complaint before the police, comma, it was given out to her that since certain criminal cases were pending against her and her sister, comma, the complaint at her behest would not be accepted. It is also alleged that the allegations made against the petitioner are false and merely to harass and intimidate the petitioner. Next para, the petitioner also complains that she is under constant threat of life and limb from the private respondents and their men and agents. Next para, learned counsel for the state seeks some time to take appropriate instructions on the issue. In the meantime, comma, the petitioner shall serve copies of the writ petition on the private respondents by registered speed post with acknowledgement due and file an affidavit of service in that regard on the next date of hearing. Next para, leave is also granted to the petitioner on her prayer to file a supplementary affidavit containing all relevant further documents, comma, if any, comma, with an advance copy to the learned advocate appearing for the state. Next para, the learned counsel for the state shall, comma, in the meantime, comma, take appropriate instruction regarding the allegations made by the petitioner and the counter allegations made by the private respondents against her and give a short report in that regard, comma, including therein the criminal cases at present pending against the petitioner as well as the private respondents. Such report shall also be filed on the next returnable date, comma, with an advance copy on the petitioner appearing in person. The matter shall next be listed on December 21, 2023 under the heading top. Under the heading top.
My lord, I want to make a prayer. I want to submit, video footages. I'm having video footages.
You put
my
it
lord.
in a pen drive and bring it to court. But give a copy, then you have to crave leave for that. Bring extra copies, 2 or 3 extra copies for them and the state also.
My lord.
আরেকটা line add করে দিন. The petitioner is also granted leave to use a pen drive incorporating relevant video footage, comma, if she wants to rely on the same on the next returnable date, comma, also upon handing over copies of the same to the respondents.
Because
in the meantime, আরেকটা line add করে দাও. In the meantime, comma, in the event the petitioner is under any threat issued from the end of the private respondents and or their men and agents, comma, it will be open to the petitioner to approach the respondent number 4, that is the officer in charge of the Park Street Police Station, who will immediately grant adequate protection to the petitioner and her family in order to ensure that no harm comes to the petitioner or her family in the meantime. Full stop. Next para. For compliance of such direction, comma, the respondent number 4 shall act on a server copy of this order without insisting upon prior production of a certified copy. This order will be, my order will be on the server latest by tonight or at best by tomorrow afternoon.
My lord, I want to say something. My lord, whenever I'm calling PS, they are not taking any steps. And whenever I'm calling to the Lal Bazaar control room, after taking one or twice call, they are saying, "Amra bole diyechi." They are just disconnecting the call. They
Do this. Do it in a mobile phone. Call them in a mobile phone, on a mobile phone. And in the mobile phone, just there's a facility of recording. Just get acquainted yourself with that. When you call the police station, put it on recording mode and have a recording. Put
Yes,
that
my lord.
also, if necessary, on the next day. Put it on the pen drive and hand it over.
I'm having, my lord, that's what I'm saying.
Then put that also in the
Yes,
there.
even police are saying, "Oh, to pagli ache," openly in the area, my lord.
Yes, produce that audio recording to me as well, and also I have given you further liberty. You use that certificate, the server copy of the order, and you approach the police station if need be. If they don't give you assistance, mention that on the next occasion. The server copy will be, the order will be on the server by tomorrow.
Grateful, my lord,
Thank you.
grateful.
Thank you. Please take care that appropriate steps are taken. Just inform the Park Street Police Station that they are sensitive on this issue. Whatever may be the allegations against her, if she approaches for protection, anyway, call on this matter. But I'll be very rude on the next occasion if the police does not give help. I'm being very candid. I can be very rude on that.
I inform you.
And I'll call all your top brasses from respondent number 1 to 2 onwards. I'm telling you, if police help is not given to her. Thank you. Next.
Grateful, my lord. Grateful.
Yes.
15.
My lord, I shall appear on behalf
Yes,
of
Mr.
the
Chatterjee, what is
petitioner,
the
my
matter?
lord.
My lord,
This is another acid attack victim.
my lord,
case. But my
I
lord,
pray some time to take
my lord,
instruction.
all right. But my lord, he is a male person. My lord,
so what? Oh,
the scheme is
He
only
comes
for
within the
women.
scheme.
Yes, my lord. My lord,
He has prayed for wow. He has prayed for 1 lakh. In addition, he has received
no.
3 lakhs. His prayer, his
1 lakh from PM fund. First, no, 1 lakh.
Mr.
Your
Chatterjee,
kindly
please,
come to
please
page
make a short
106.
compilation of the the schemes, relevant schemes, and bring that on the next occasion. Keep an extra copy handy for him also. Come back on Friday. Please take instruction. And an adjournment is sought by learned counsel for the state to take appropriate instructions on the allegations made in the writ petition. So accordingly, the matter is adjourned till December 15, 2023, when it will be placed under the same heading in the list. Mr. Chatterjee, please come with whatever scheme helps you.
Scheme and other judgments also, my lord.
Different judgments always
grateful,
there.
my lord. Grateful, my lord. No, there is no scheme for male person. This
We'll
is
try
very
to extend that,
Grateful, my
but
lord.
give me some handle for that.
My lord, grateful, my lord. Grateful.
I'll come again 10 minutes for the next matter.
Grateful.
16.
I appear on behalf of the CS.
I'm the petitioner. I am praying unconditional apology on behalf of my client. I could not appear yesterday. My client appeared. I do not know what she has submitted. I am praying apology once again on behalf of my client.
Yes. What is the matter?
Here matter relates to new electricity connection.
Please come closer to the microphone, Mr. Badi.
Matter relates to the new electricity connection
Yes.
applied by the private respondent. I am opposing the same. Here, the two independent premises are there.
Electric connection has been given.
No, he
Is
applied
being
for,
given.
Yes, he applied for that has not been given because I objected. The two independent premises, 72 and 72A. 72 is my premises and 72A is his premises. Initially, 72 is a three-storied building. Initially, there was three separate owner. I purchased the entire property from them, and now I became the absolute owner of the entire property. And subsequently, the private respondent purchased from the erstwhile owner. Before the erstwhile owner, in respect of the private respondent property, erstwhile owner applied for electricity connection. That was not given. He filed a writ application, which was pending. During that period, the private respondent purchased the property from the erstwhile owner. That property 72A is a landlocked property because it has no egress and ingress, no passage surrounded the property. That observation is also there in the law. I will show. He applied for electricity. That was not given. He approached this honorable court, and your lordship directed the CSO authority to conduct an inquiry and file a report. Kindly see the report first, what they have stated in the report. That is at page 77. I am not placing the entire report, the relevant portion, page 80, last two paragraph only.
Yes.
But in view of the above, to provide service connection at any of the proposed service position, service cable would be required to travel across along the sewerage system to intersect the same at one point, and also to intersect water mains connection near manhole number 2, which is not at all technically feasible. Under the circumstances as stated herein above, the petitioner applicant was requested to identify any other alternative place, but the petitioner applicant failed to identify any such technically suitable place. We also tried to explore any other alternative route for laying underground cable, but due to existing water reservoir, underground water pipeline and sewerage system within the entire plot of land, no other alternative route could be traced out. Now, considering that report, your lordship dismiss the writ application, but your lordship's observation is very vital. On page 84, your lordship's order, and page 85, I'm placing the page 85.
This is division bench against my order, probably. Yes.
No, not against this one. Oh, sorry. This is your lordship's order is not annexed. This is the order. Kindly see. This is the order. Page 2, can you say only the relevant
yes.
What? Page 2, second line. The said report has been annexed to the affidavit in opposition and indicates clearly that there are several impediments to give electricity connection, particularly a separate connection, a service connection at the premises in question. There are the last two lines. As such, it is not possible to give electricity service connection to the petitioner. Next page, second paragraph. It is argued by the learned counsel for the CSC Limited that despite having explored all possibilities, no alternative route could be identified for giving service connection to the petitioner.
So I expressed sympathy, relied on caveat emptor, and said that he cannot get electricity.
Yes. Now last page, kindly see the last page. Let me place.
No, I'm seeing that only. Yes.
Only one paragraph. Although the court expressed full sympathy for the petitioner, who is allegedly a heart patient, the petitioner is also governed by the doctrine of caveat emptor and ought to have scrutinized the property prior to purchase. Since the pendency of the prior writ petition at the behest of the erstwhile owner clearly shows that there was no electricity service connection with the premises in question at any point of time. Accordingly, the
appellate court said cannot apply for service connection, but they can apply for a metered connection.
Yes.
But from when will that be given?
Yes, thereafter they preferred an appeal. Then the appeal court clarified the order that they can apply for fresh meter connection.
We have applied.
They applied. They applied. Malad, that was
That meter connection was given from your premises?
No meter connection was given. Thereafter, they again approached this honorable court.
Due to their objection.
Yes, due to my objection, Malad, your lordship passed an order, page 86. Malad, can you see? Page 86.
Yes.
It starts from page 86, relevant for Malad, only place only 2-3 paragraph. Page 87, last paragraph. In order to explore such opportunity and if possible to find an agreed alternative location, striking a balance between the right of the petitioner and of the private respondent, the CSC Limited is directed to hold a joint inspection upon prior notice to the petitioner as well as the private respondent to ascertain whether it is possible to give the electricity connection to the petitioner at any manner, either by giving the same from an alternative location than the existing meter board position, or can you see the alternate location than the existing meter board position, or by shifting the existing meter board position to a common area which will not directly hamper the privacy of the private respondent, and to file a report in regard on the next reasonable date. Now, thereafter, inquiry was conducted in my presence.
You are enjoying from that existing meter board?
Yes, that is just this is my personal meter board. And the meter board is located in my bedroom. My meter board service connection is located inside my bedroom. It's all.
So that's why this hampering privacy question.
Yes, now they prepared a report while conducting the inspection. But I was repeatedly pointed out them that there is at least 3 alternate location where from electric connection can be given to the private respondent. I will show the sketch map also, my lord. Let me play the report, my lord. What they have, page 89. They have given 3 alternate suggestions. There is no other. Can you see the page?
Yes,
2 alternate suggestion.
Yes.
By installing a new loop meter at the existing service located in portion of the private respondents at the premises in question, subject to free access of the existing meter board position with the police assistance, including breaking of padlock if required, and by shifting the existing service at a common portion. That was the 2 suggestions.
Shown in the sketch map provided.
Yes, well, they have shown the sketch map. I will show the sketch map. That I have said, Malat. I will show the sketch map. Now, thereafter, the writ application came up for final hearing. When I objected, your lordship, Malat, relegated the matter to the district magistrate to decide the issue, Malat. Malat, before the district magistrate, Malat, they filed petition. I also raised a specific objection where I have specifically stated, Malat, kindly see the page 111 of my objection. 1 paragraph only I will show, Malat. 111. Last paragraph. That considering the aforesaid facts and circumstances, it is crystal clear that there is at least 3 alternate locations where from new electricity meter connection can be effected at the premises number 72A. Since meter board of all those 3 alternate locations are lying outside their building, and to ascertain such connection of the undersigned, a physical inspection may be conducted in presence of all the parties to resolve the dispute in question. It was specifically pointed out with the sketch map. That was not at all considered either by the CSU authority or by the district magistrate. Kindly see the sketch map.
No, this is a part of what? Page 111?
This is the objection before the file before the district magistrate.
This is your objection?
Yes, my objection.
Okay.
It's my objection.
The order of the district magistrate at page 140.
144. 144 is the again question.
No, 140.
Kindly consider this a sketch map once.
The CSC had apparently produced a sketch map.
Yes.
This is that.
No.
Yes, Malad. This is my sketch map. Malad, kindly see.
Their sketch map.
This is the
magistrate has already adjudicated, Mr. Bari. How? Where is
no,
the
Malad,
scope of the
see
report in the query?
This particular
you cannot reopen on and on and on and on and on.
No,
Malad, this has attained finality. Magistrate had decided.
That issue has not been considered at all. Malad, why? Kindly see, Malad, once.
Yes.
Well, this is the sketch map. Malad, left hand plot is my 72 is my premises, and next is 72 is private respondent premises. Malad, I have Malad marked 2 portion. Malad, logic got Malad red mark. Malad.
There is no red mark here. Black and white and only yellow. 2 portions are yellow.
Red mark to name.
Yes, Malad, kindly. So extremely sorry, Malad. This one is
red mark.
Yellow mark.
No red mark there.
Yellow mark is there.
Here at least yellow is there.
Yes, Malad, in yellow.
No, red but yellow. But there neither one is there.
Sorry, Tama. That yellow mark, Malad. There is Malad.
Somnath Guchait is your client or them?
This is the erstwhile
owner.
who has
Now,
filed
my
the
lord,
first
surrounding these premises, excluding my premises, there are 3 other separate premises. Just beside, my lord, just beside the 72A.
What are you challenging now? The magistrate's order?
Yes, ma'am.
What has the magistrate held?
He
They have
has
said
given
what-
the
what
alternative.
that's- What stated by the CSC authority, same thing has been stated by the district magistrate.
Why should the writ court interfere by looking into a map now? New fact finding.
Because there is 3 alternate location where from they
That
can
is your
easily,
statement, sir.
my lord, they are
May I-
taking connection from my bedroom, my lord.
May I with
From
He
my
may not do
bedroom.
anything. Let me hear him. I'm hearing him.
My bedroom, my lord, kindly see this map. My lord, from this map, it is crystal
He
clear.
cannot look
There is
into any
only-
further factual.
Plus three alternate locations, my lord, as they are at least where from they can affect the electricity connection more easily, my lord, because from my connection to their, my lord, distance is 40 feet. And from these 2 alternate locations, only one is 8 feet, and other is 20 feet. And their meter board is outside the room. So my prayer is, well, let there be a fresh inspection.
The entire existing service is being sought to be removed to some suitable, convenient place.
But there is no such convenient place at all.
CSC says yes, there is.
No, Malak, can you see the sketch map? Picture, Malak, can you see the picture? This picture, Malak, can you see?
You are going on relying on documents which are not annexed. I won't look into it, Mr. Bhatt.
This picture, Malak,
No picture.
Then can you allow me to file supplementary affidavit?
No,
to that effect,
not
Malak?
now after hearing.
Only 4 feet wide road.
Maybe.
Only 4 feet wide road, and there is no.
Better than your bedroom.
Yes.
If you want, I can direct the connection to be given from your bedroom to them. If you want that, I'll definitely direct it. There has to be a limit to everything, Mr. Bhatt. You cannot go on raising their electricity. No.
Malak, I am not against the electricity.
Absolutely, you are doing that. You are repeatedly harassing them on and on before 4 forums it has been decided. You cannot reopen the issue now. Magistrate has decided, rightly so. Only one option is being given to you. It can be from your bedroom to them. If you agree to that, I'll give it from your bedroom.
There is no.
Just to help you out, Mr. Badi, to help your client out, we had directed shifting to a common location. If you want it to be given from your bedroom, I'll readily direct that.
There is no common
No,
location.
then
at
let
all.
it be from your bedroom.
Malak, there is no.
I'll
common
modify the order, I'll make it from your bedroom. Definitely not.
There is no common.
There is a limit to everything.
Malak,
There is a
I am
finality to some these orders of course.
If there is alternate location,
No,
why
no.
from my
You cannot
premises?
have it both ways. No. It has been decided finally, conclusively. This is not a fact-finding forum.
Malak, that issue
Even if I pass an order now, you'll go to the appellate court, you'll go to the Supreme Court, again it will start afresh. I'll impose costs on your client, Mr. Bari, actually. No, it has attained finality. You cannot reopen the issue again. This is barred by res judicata.
But when there
How
is
can we reopen the issue at all? No.
alternate provision, why
That is your saying. All the authorities say there is no alternative occasion.
there is no whisper? They never
No, sir.
says there is
I'll
no
impose
alternate
exemplary costs on your client. I'm
Kindly,
telling you
Malak,
that absolutely.
Malak,
You know, you must know where to, not you. I mean, your client must know where to stop.
Certainly, Malak.
Definitely, your client must know where to stop. You have explored 5 forums and again reopening the issue. Let them get electricity immediately. I'll direct that to be given within 48 hours.
We have also complied.
And
with
if
the
necessary, from your bedroom. What is this? This person is without electricity, is going on without electricity. You have some acrimony with him. You are resisting electricity on and on and on and on. 5 forums have decided. Let it attain finality, Mr. Bhatt.
Nobody considered that issue. Malak, if there is 3 alternate.
I will also not consider then. Act order record.
Lordship, another thing, after the order of the district magistrate, we have paid the security deposit for the shifting of the.
And we have
Who
tried,
says you haven't?
and we have tried, my lord, to for the implementation. We have been
Lordship,
opted.
police assistance is.
Learned
required
counsel
otherwise-
for the petitioner contends that despite previous orders of different forums, none of the forums considered the aspect that there are at least 3 alternative locations from which electricity connection can be given to the private respondent without disturbing the petitioner's possession in respect of premises number 72
A, my lord.
capital A. What is the name of the road, Mr. Bari? Ram Mohan something.
Raja Ram Mohan Rai.
Raja Ram Mohan Rai.
Raja
Road,
Ram
my lord.
Mohan.
Raja,
Thank you. Raja Ram Mohan Rai Road. Push up. It transpires from the materials that there has been previous rounds of litigation. Push up. Initially, the petitioner had sought for electricity connection by way of a writ petition, which was turned down by this court on the premise that the private respondents by the petitioner, No, sentence, sir. Initially, the private respondent has sought for electricity connection, which had been turned down by this court on the premise that the private respondent apostrophes purchased property at premises number 72 Raja Rammohon Roy Road is a landlocked property and no electricity connection was feasible to be given thereto. Push up next para. The matter went up to the division bench, which observed that although service connection could not be given to the private respondent, comma, the CSC Limited was to consider as to whether metered connection could be given to the private respondent. Push up upon a subsequent exercise, comma, the CSC Limited held inspection and in a report, comma, disclosed that there were two feasible options, comma, one was to give an electricity connection from the existing meter board position, and the second is that the existing meter board position, which is located at premises number 72 capital A, comma, to be shifted to a more convenient place nearer to premises number 72. For sub next para, the present petitioner,
Near this is within the 72. The service
the
connection
petitioner objected on the ground that the existing meter board position is located in the bedroom of the petitioner, and as such, the privacy of the petitioner would be hampered in the event connection was given therefrom. Push up. After several rounds of litigation, comma, the matter ultimately was referred by this court to the concerned district magistrate, that is the district magistrate, South 24 Parganas, who, comma, in tune with the orders passed by this court, comma, and the opinion of the CSC Limited, comma, directed the electricity metered connection to be given to the petitioner by installing a new loop meter in the position earmarked by the CSC Limited for shifting in the name of the present private respondent. Full stop. Next para, the petitioner challenges the said order of the district magistrate. Full stop. Learned counsel for the petitioner hands over a copy of a hand sketch map which indicates that there are several other alternative locations for giving electricity connection to the petitioner, to the private respondent. Full stop. Learned counsel for the petitioner argues that such options were overlooked by all the previous forums. Puts up next para. Learned counsel for the private respondent controverts the submissions and contends that despite having deposited the quotation amount and complied with formalities, comma, electricity connection is not being given to the petitioner due to, given to the private respondent due to resistance by the petitioner. Push up next para. Learned counsel for the CSC Limited also contends that the CSC Limited, comma, on inspection had submitted its previous report where it was clearly disclosed that the only options were as per the said report and there was no other alternative location to give electricity connection. Push up next para. Upon a perusal of the materials annexed to the writ petition, comma, it is evident that the matter has suffered two previous rounds of litigation before this court, and ultimately the matter was relegated on the basis of a report filed by the CSC Limited disclosing the clear alternatives for giving electricity connection to the private respondent. Pushed up. Upon due hearing, in accordance with law, comma, the district magistrate, comma, by the impugned order has come to the conclusion that the only feasible way to give connection to the private respondent is to give a loop metered connection in the earmarked position for shifting in the name of the petitioner in the private respondent. Pushed up next para. As such, comma, since there have been several previous fact-finding exercises by all the authorities concerned, comma, there is no scope for the writ court to enter into the factual inquiry again by looking into alternative proposals given at this belated juncture by the petitioner. Pushed up. There has to be a finality to every proceeding. Pushed up. Since the parties have explored all possible forums up to the district magistrate, after several rounds of litigation before this court, comma, it would be unreasonable to reopen the issue afresh without any perversity having been made out palpably from the face of the impugned order of the district magistrate. Full stop. Next para. As such, comma, there is no scope for interference in the present writ petition. Accordingly, WPA 13402 of 2023 is dismissed on contest. Full stop. The CSC Limited shall give the electricity connection to the petition to the private respondent in terms of the direction of the impugned of the district magistrate in the impugned order at the earliest, comma, if necessary, with police help at the cost of the private respondent. No orders to cost urgency.
Any padlock
No, that this is not your writ petition.
I'm grateful.
Thank you.
Have a nice day.
Sorry, Mr. Bari. রেফার করেছি কি করে ফেরত দেবে?
Grateful.
Sorry, Mr. Bari, but
It's all right.
next.
17.
17.
Well, I am for the petitioner.
Yes, Mr. Chatterjee, what is the matter?
My lord,
I am appearing for the
the writ petitioner is the widow
I am for the
of
private
someone who died.
File the affidavit of service, Mr. Do it in the meantime and start your argument. Yes.
Now,
Writ petition
her
is a widow.
husband died
Yes.
in a national calamities in Uttarakhand. There is an avalanche calamity which took place. Now, after that, she made an application to the Uttarakhand government for disbursement of some compensation amount, ex gratia compensation amount, towards her and her minor daughter, 6 years old daughter. Now, that ex gratia compensation amount has been disbursed through the district magistrate Howrah.
All right.
Now that check had come. Check was issued and given to her. 4 lakhs. Now check, once it came to her, she got a call from the office of the district magistrates that do not drop the check. By the time it was dropped, however, the payment was stopped. She receives a notice for a hearing. In view of one case which is pending for the issuance of the succession certificate in respect of the LIC of her husband, filed by the mother-in-law and others against her. That is pending before the learned district judge Howrah. In the meantime, this proceeding took place, and in view of that interim order, that 7 except 2/3 of that property, that
interim order passed by whom?
District Judge Howrah in respect of those matters, bank accounts and others. This particular payment has been stopped. And she got again reminder for this. My humble submission is that now after filing of this, they have stopped that proceeding. They said that is withheld. Now my humble submission is that this is an ex gratia payment towards the wife, widow and the
Is there any written order by the Uttarakhand government?
Lordship, this has come.
Or anything to show that?
No, Lordship, kindly come to page 37 once.
37.
This is the communication which comes from additional district magistrate.
Yes.
This is to inform you that the payment of check bearing number such and such amounting rupees 4 lakh only issued in favor of you as the ex gratia compensation has been withheld due to the injunction dated such and such. Now, this is one. Prior to that, Lordship.
Have you annexed the injunction order?
Yes, my lord.
Show me that.
34. The ordering portion, Lordship.
Yes.
That the prayer for temporary injunction filed by the petition is hereby allowed on contest restraining OP number 1, that is the petitioner, from withdrawing any amount from any bank or insurance company lying in the account of the deceased Shorit Shekhar Das, 7 except to the extent of 2/3 legitimate share of the opposite party number 1 and 2 till disposal. So it is covering that area. My lord, my humble submission is that law of succession operates in the field of the property of the person. Now, this is not an ex gratia payment made to that person when that person was living, because Lordship, dead man cannot access the property. Now, this is an ex gratia payment made on the basis of the applications of the petitioner.
Mr. Chatterjee, only one thing against you apparently, that ex gratia payment definitely, but the ex gratia payment is for the demise of your husband on the premise that you are the legal heirs of the husband.
No.
Why do you say that?
Kindly come to my application, Lord. Show me that. This is annexed, Lordship, in page 18. Application for the financial help of the family demised expired to Uttarakhand Avalanche. With due respect, I would like to inform you that my husband, late Chorichekar Das, resident of such and such, Bagnan, unfortunately expired in Uttarakhand avalanche disaster happened during October 2021. Understanding from reliable sources that your good office is extending big hands to help the family of the demised in collaboration with the government of Uttarakhand, I, such and such, pray to your kind honor for arranging the said financial support to my favor so that I may survive with our only 6 years old daughter. I shall be highly obliged.
What are you doing now? How are you surviving, obviously. How are you maintaining yourself now?
Nothing. Doing some work in lawyer's office. Doing some contractual teaching job.
Let me hear them. Who is for the private respondent first?
My lord,
What is
I have a judgment to show, Lordship.
Cite your judgment first, then Ali.
Lordship, this is a judgment of Delhi High Court deciding on the issues quite similar to this. This was regarding the rehabilitation package of 1984, this riot victims.
Right.
And Lordship, the concept which was, I will be relying on this paragraph number 12 and Lordship 16. The compensation in question has to be viewed from this perspective: standard compensation and compensation for pecuniary loss. Insofar as both these elements are concerned, there is no difficulty in straightway coming to the conclusion that the position of the petitioner is no different from that the respondent number 3. The petitioner lost her daughter and her grandchildren, as also her son-in-law, Kishan Singh, lost her son. The grandchildren as also the daughter-in-law. The extent of the pain of the heart could be suffered by both would not be any different. The agony of the loss of the daughter cannot be less than the agony of the son. Similarly, Lordship, the question is, I do not see how it can even be contended that the right of the respondent number 3 to receive compensation is on higher footing than the petitioner. Reliance placed on the personal law of succession is of no consequence in this case. This is a matter of compensation being awarded by the state, which does not function under any personal law. It only functions under the Constitution of India, which has established it is a secular state. Whatever the relationship between the state of a citizen in the issue, the personal law of the citizen has little or no relevance. Personal law operate mostly in the domain of the citizen versus citizen content. So, Lordship, this was a claim. Suddenly, this has stopped me. And Lordship, then Lordship knows that judgments called Jodh Singh and others in 1980. This was related to the family pensions. Lordship, family pensions, and kindly come to this paragraph.
Give the citations for your learned friends.
Yes, 1984 SCC 306. Lordship, paragraph 11. It was, however, settled. It was, however, said that not all widows are entitled to the special family pension, but only the dependent wife who becomes widow on the death of the officer alone becomes eligible for pension. And in this case, the deceased had not shown his wife as one of the dependents, but on contrary, the parents, the sisters and brothers were shown as dependents of the officer. Rule 74 envisages family pension rules such and such. Now, Lordship, I am coming to this. Thus, whether a widow has qualified to the special family pension, gratuity, and ordinary family pension is the matter to be determined by the President. If the President is satisfied that the widow is eligible for pension and cannot be denied benefit of some other dependents of the deceased, claiming that instead of widow or she should have been held eligible for the special family pension. Now, Lordship, my only submission is that when a person, because law of succession operates in the field of the property accrued by the person when the person was living. When the person is dead, this is something which has been accrued by her after the death of the husband. Now, Lordship, this is payment towards her. This cannot be, again, directed to be divided on the basis of the law of succession. Moreover, Lordship, the order itself shows that it is in view of the interim order this has been withheld. This interim order does not covers the area, Lordship.
Yes.
My lord, private respondent is the mother of the deceased. Belongs to class 1 here. My lord, in their main application at page 18, the petitioner applied for the ex gratia compensation for the family, not for only for the petitioner and minor daughter, my lord. At the second paragraph at page 80, understanding from reliable sources that your good office is extending big hands to help the family of the demise, my lord. Now, my lord, as per the office memorandum at subsequent page, at page 19, my lord, the ex gratia compensation is for the families, the subject special benefit in cases of death and disability in services, payment of ex gratia lump sum compensation to the families. My lord, word used in the plurality, family. My lord, I am the also family member in related by blood connection, my lord. And as per the class 1 here, I am entitled to one.
What is the concept of family in this office memorandum? Let us see that.
Yes.
If something is there.
First of all, this has been annexed for the
Chatterjee,
concept.
please, don't disturb.
This family word has not been defined by.
No, naturally. Yes.
Not defined.
So only this.
Yes.
All right. So you say within family, you also come in because you are a class 1.
Yes, my lord, I am connected by blood. That is the family, a group of persons united by the ties of marriage, blood, or adoption constitute.
What is this?
I am
Dictionary?
collected from the net searching, my lord.
Achha, one other thing, you are residing with the deceased.
No.
There is no averment regarding that.
No.
No, my lord.
I'm just asking you. I mean,
Yes, my lord. The petitioner is not residing.
you were residing.
I am.
The mother was residing with the deceased at the time of the accident.
Yes, my lord. Actually, the deceased is my son of the private respondent.
Just because he's your son does not mean that he was residing with you.
Yes, my lord, residing, my lord. There is no other address, separate address of the son and the private respondent mother, my
lord. One more thing, may I?
No, take your seat. You have finished your argument? No, nothing else. Yes, please continue. Anything else? This is all. What does the state have to say?
My lord, the magistrate is ready, always ready to discuss the same. My lord, unless my lord.
Is the 6 magistrate are always ready?
Unless private case was, yes, my lord decided.
Very
Because
good.
my lord, there was my lord, matrimonial suit was also going on from the notice of the learned advocate, my lord, of the private respondent sent, my lord, to the department, my lord. And distinguished always ready.
Suit? Matrimonial suit? No
Yes,
suit number is given?
During the lifetime of the deceased.
No matrimonial suit has been mentioned here. 498A case was going on. She had initiated a 498A case.
Yes.
That is different from a matrimonial suit.
We have no problem. my lord.
Very let us hear him in reply. Yes, Ms. Chatterjee.
Only one thing, one more thing. I have made my
No
submission.
judgment.
No, it's not judgment, Lordship.
What is this?
Regarding the concept, Lordship, I got one memo, circular number 766. It's like taxability of the ex gratia payment by central government, which only says that it is noted there can be situations in which a person or his or her receives ex gratia payment from the central government, state government, local authority, public sector undertaking consequent upon injury to the person, death of a family member while on duty. This is Lordship because it talks about the person who
This
receives.
also in the previous paragraph says provided the lump sum ex gratia payment made to the widow or other legal heirs of an estate.
It's a widow or legal heirs of this second part, Lordship. That is for the central government. Second part, it in the
It may
case
be either widow or legal heirs. This does
legal
not
heirs
help
of
you.
the person.
This does not help you. This is not in your favor.
Is it from
at order record? Madhavu? The petitioner is the wife of a deceased person who met his sad demise in an accident in Uttarakhand. Push-up. On the prayer of on the application of the petitioner for ex gratia compensation for herself and her then 6-year-old daughter, the Uttarakhand government released funds for payment of ex gratia compensation to the tune of rupees
4 lakhs.
4 lakh to the petitioner. Push up. Although initially the respondent number 2, that is the district magistrate Howrah, intimated the petitioner that the fund was going to be disbursed to the petitioner, comma, subsequently the same was withheld, citing an order of injunction obtained by the private respondent number 4, who is the mother of the deceased husband of the petitioner. Push up. Learned Counsel submits that in terms of circular number 776 dated June 8, 1999, comma, lump sum ex gratia payment may be made to the widow or other legal heirs. So it is submitted that the injunction order which has been annexed to the present writ petition does not restrain, does not cover the ex gratia payment now sought to be made to the petitioner, but deals with the bank account and other properties which are the subject matter of the said succession proceeding. Push up. Learned Counsel for the petitioner also places reliance on a judgment of the division bench of the Supreme Court in Jodh Singh versus the Union of India and another, reported at 1980, volume 4, SCC 306, for the proposition that the family pension is required to be given irrespective of whether the deceased has shown his wife as his dependent or not. Pushed up. Next para. Learned Counsel also cites a judgment of a learned single judge of the Delhi High Court in Srimati Ganni Kaur versus the state within bracket NCT bracket close and others, reported at AIR 2007 Delhi 273, for the proposition that the compensation has to be paid in view of the agony or loss of a family member, comma, in the said case, comma, a daughter stroke son. Puts up. It was observed by the learned single judge that reliance placed on personal law of succession is of no consequence in such case, as this is a matter of compensation being awarded by the state which does not function under any personal law but under the Constitution of India in a secular state. Pushed up. The Delhi High Court went on to observe that wherever the relationship between the state and the citizen is in issue, comma, the personal law of the citizen has little or no relevance, which the personal laws operate mostly in the domain of citizen versus citizen contests. Push up. Next para. Learned Counsel appearing for the private respondent contends that the private respondent is the mother of the deceased person and is also a class 1 heir in the same bracket as the petitioner stroke widow. Push up. Hence, comma, the private respondent is equally entitled to the ex gratia payment of compensation disbursed on the demise of the son of the private respondent. Pushed up. It is argued that the private respondent comes within the concept of family and that the application made by the petitioner wife, petitioner widow, was on the premise that such compensation was to be given to the family of the demised, comma, which also includes the private respondent. Push up. Next para. Learned Counsel for the state submits that the district magistrate's hands are bound by law and the district magistrate shall disburse the amount as per the direction of the court. Pushed up. However, comma, it is pointed out that there was a pending proceeding under section 498 capital A of the Indian Penal Code at the instance of the petitioner against her in-laws during the lifetime of the husband. Pushed up. Next para. It is seen from the office memorandum dated September 11, 1998 of the Government of India annexed to the writ petition that the concept of ex gratia lump sum compensation was for families of central government civilian employees. Full stop, next para. The same principle, comma, it has been argued, comma, has also been applied in the present case. Full stop, next para. The application of the petitioner for grant of ex gratia compensation annexed at page 18 of the writ petition undoubtedly mentioned that the good office of the additional district magistrate Howrah was extending its hands to help the within double inverted family double inverted clause of the demised in collaboration with the government of West Bengal. Push up next para. However, comma, the very next sentence of the said application mentions the petitioner herself and her 6-year-old daughter as the within single inverted family of the deceased. Pushed up. Next para. The manner in which the application was made clearly shows that the same was for financial support to the petitioner and her 6-year-old daughter, comma, who were and are in financial distress on the demise of the petitioner's husband. Push up. It is evident from the said application that the petitioner has been a dependent of her husband during his lifetime. Push up, next para. Insofar as the pendency of an application under section 498 capital A of the IPC during the lifetime of the husband is concerned, comma, the same does not per se take away anything from the contention of the petitioner that she was entitled to ex gratia compensation as the widow, comma, being in financial distress on the demise of her husband. Push up, rather, comma, the filing of the application under section 498 capital A also operates as an assertion of the right of the petitioner as the wife of the deceased, comma, which also entitles her to maintenance on the from the estate of her deceased husband. Full stop, next para. Thus, comma, seen from the perspective of the petitioner, comma, the application for ex gratia compensation was not in the nature of a declaration of the petitioner's right of succession on the demise of her husband, but by way of her right of maintenance from the estate of the husband, comma, on his demise. Pushed up. If the petitioner's husband was alive as on today, comma, and the petitioner had made an application for maintenance from her deceased from her husband, comma, the said amount as granted by the competent court would not be distributed among all the heirs of the husband merely on the premise that in view of the personal law, comma, all the heirs are entitled to the estate of the husband. Pushed up. Similarly, comma, the ex gratia compensation sought by the petitioner was a posthumous extension of her right to claim maintenance from her husband's estate and cannot be equated with a right of succession as such. Pushed up. In such light of the matter, comma, the private respondent, comma, despite being a class 1 heir as well, comma, cannot claim a share in such ex gratia compensation payment to the petitioner and her 6-year-old daughter, comma, which was disbursed in their favor on their application, comma, merely as an ad hoc measure to meet the financial distress which the petitioner and her daughter are suffering due to her husband's demise. Full stop, next para. With regard to the other component of the challenge, comma, the petitioner is justified in arguing that the order of temporary injunction passed in a succession certificate proceeding by the private respondent mother of the deceased only pertained to the subject matter of the said dispute and as per the order itself, comma, was restricted to withdrawing any amount from any bank or insurance company lying in the account of the deceased husband of the petitioner to the extent as indicated therein. Full stop. Hence, comma, the petitioner not being a party there and the subject matter of the ex gratia compensation not being a subject matter of the succession proceeding, comma, the said order cannot restrain the district magistrate from disbursing the entire amount in favor of the petitioner. Pushed up. Having held so, comma, I do not find any impediment on the part of the district magistrate Howrah to disburse the entire amount of rupees 4 lakh, comma, intended at the outset to be disbursed to the petitioner and a 6-year-old daughter, comma, from the petitioner. Full stop. Next para. Accordingly, WPA 22882 of 2023 is allowed on contest, comma, directing respondent number 2, the district magistrate at Howrah, to immediately disburse the entire amount of rupees 4 lakh to the petitioner for use by the petitioner and her 6-year-old daughter in lieu of ex gratia compensation on the demise of the petitioner's husband. Full stop. Such disbursal shall be made by respondent number 2 at the earliest, comma, positively within a week from date by acting on the server copy of this order. Full stop. No orders to cause.
Grateful, my lord.
Yeah.
18.
18.
Lordship, I am for the petitioner, Lordship.
Right. What is the matter?
Lordship, is a Lordship, grievance is at page 30, Lordship. Petitioner preferred the second appeal, Lordship, in the month of July, Lordship.
Information, right to information.
Yes, Lordship.
What happened to the
They have
information
not
was
been,
given?
not been given any information.
What did the
Lordship.
SPIO say? Refused.
Yes, no, Lordship. First, SPIO, no. Information we have made prefer the second appeal before the second information commission, Lordship.
First, you made an
First,
application for
yes,
information.
Lordship.
What
We
happened
have
to
got
that?
the information, Lordship, but not full
The information was refused,
No,
or
no,
the application was
we have
kept
received.
pending.
We have received the information, but not
They are
received the
providing
full
the-
information, Lordship. There something is missing, Lordship.
The information which they sought was not provided to them.
Not full information,
So
Lordship.
what
We have
happened in
received
the
Thereafter,
second appeal?
we have preferred the first appeal, and thereafter we prefer the second appeal, Lordship. They are not been given any information till now, Lordship. Second appeal is pending, Lordship.
Second appeal has to be decided.
Yes, Your Lordship. That is my
You want a
grievance.
direction to decide the second appeal?
Yes, Your Lordship.
When did you file it?
Lordship, file in the month of July, Lordship.
No, July 2023.
Yes, Your Lordship.
July 2023.
Yes, Your Lordship.
Second appellate authority is hard pressed.
Yes, Lord.
Yes, Your Lordship.
How can it decide within this period?
Lordship, earlier we have preferred the second appeal before the wrong forum, Lordship. The time period is expired, Lordship. Thereafter, we have preferred the writ petition, and Lordship grant me liberty, Lordship, to file afresh before the second appeal. Lordship, we have preferred the right forum, Lordship. Now, the period is over, Lordship.
Kindly
Because
see
that
his
is-
fair, Lordship. Kindly see his fair, Lordship. He sought for information to the
Provide the information and supply, Lordship.
to the second appellate authority. We
Yes,
are not
Lordship.
trying to provide the
I'll direct the
information.
second appeal to be
Yes, Your
decided
Lordship. Yes, Your
within a
Lordship. Yes,
reasonable period.
Yes, sir.
Lordship.
The petitioner had applied for an information and had obtained partial information, push up in the perception of the petitioner, comma, full information was not furnished, for which the petitioner preferred a first appeal, push up thereafter, by virtue of an order of this court dated July 7, 2023, passed in WPA 15285 of 2023, comma, the petitioner preferred a second appeal. Push up, it is argued that the said second appeal is still pending. Push up, learned counsel, you are for? You, sir, you are for whom? You,
I am from the respondent number 5, second appellate authority.
learned counsel for the second appellate authority stroke respondent number 5 points out that the appeal has only been filed recently and is still pending. Push up, that apart, comma, the petitioner has sought for the information, comma, which is the subject matter of the second appeal itself, comma, by way of a relief in the present writ petition. Push up, next para, irrespective of the relief sought in the writ petition, comma, the crux of the prayer of the petitioner is that the second appeal has been pending since long, full stop. Although the second appeal has been filed only after July 2023, comma, for the ends of justice, comma, it would be appropriate that the second appellate authority decides the dispute at the earliest. Full stop. Accordingly, WPA 23120 of 2023 is disposed of by directing respondent of 5, the second appellate authority, to decide the petitioner's appeal pending before it as expeditiously as possible, comma, positively within February 15, 2024.
Grateful, Lordship.
No rest of us.
Grateful.
Thank you.
19.
Yes. What is the matter?
My lord, the petitioner before your lordship is convicted under section 302 for murder
That explains your
charges.
presence. Yes.
I'm 19 years in custody. 19 years. Now, my lord, the petitioner through the appropriate authorities, had prayed for the remission of sentence. Now, my lord, lordship has already dealt with that 67th meeting, the 67th meeting of the State Sentence Review Board.
Yes.
My lord, that 67th meeting did not comply with the constitution of the board as provided by the National Human Rights Commission. I have that judgment covered by the judgment passed by your lordship. The board did not have the district judge. The board did not have the did not take opinion of the convicting court. The courts, according to section 432, subsection 2. My lord, those were not complied. And in a cryptic order, my lord, that cryptic lordship will find the reasoning at page 98. I am the number 38, Narayan Mahato, page 98, last one.
Yes.
At the top, my lord, we'll see views with grounds of rejection. And then kindly see what is recorded against me.
What is your age?
My lord, age is 56 years. Now, this was in the year 2022. Now I am 57.
What is the composition of your family? Where do you go back?
My lord, I am from Purulia.
Is there any family members still there?
Yes, my lord. The family members are dependent on me. Means now they are surviving in hand-to-mouth situation. Wife,
For
child.
18 years?
Yes, my lord.
Anyway.
But my lord, now, my lord, I am relying on this judgment of your lordship. My lord, this is reported in AIR. I have an online copy, AIR Online 2022, Calcutta 2520.
Can you give a copy
My
to
lord,
Mr. Galikos?
I'm just
share it with him. Yes.
Yes, sir. Kindly. Oh.
Oh,
My lord,
Gopal, sir.
lordship in detail in this judgment has taken the pain to go through each of the provisions one by one. Kindly sees, my lord, first lordship has recorded from paragraph 8 onwards the judgments of the Honorable Supreme Court pertaining to the nature of consideration to be made for the purpose of remission. And secondly, my lord, from paragraph 4-5, lordship will see the reflection of section 432, subsection 2, as I pointed out before your lordship, that the convicting court's opinion is paramount in case of consideration of a remission. Now, my lord, then comes to, my lord, there are in paragraph 8 to 14, lordship, the judgments are recorded. My lord, then lordship has recorded in paragraph 18 the constitution of the this is SSRB, the State Sentence Review Board. Paragraph 18, my lord, will see
this has not been complied with.
No, the district judge is not a party. My lord, also the as I pointed out to my lord, to your lordship, my lord, section 432 subsection 2 has also not been complied with. The convicting court's opinion has not been taken. Now, my lord, thirdly, my lord, the in paragraph 19, my lord, the clause 6.3 of that NHRC circular, the commission observed that while considering the case of premature release, it is recorded in paragraph 19, my lord. Particular prisoner board shall keep in view the general principles of amnesty remission of the sentence as laid down by the state government or by courts, as also the earlier precedents in the matter. The paramount consideration before the court was to be the welfare of the prisoner and the society at large. More specifically, the board shall not ordinarily declare a premature release of the prisoner merely on the ground that the police has not recommended his release on certain far-fetched and hypothetical premises. My lord, we are completely in the dark as to what report was sent by the relevant police officers that my learned friend would be able to point out to your lordship, but in the cryptic order which has been reflected, it is a generalized, kindly my lord sees the manner in which they have recorded offenses of grave in nature for which the petitioner has already suffered 19 years of imprisonment, chances of deterioration of law and order situation, not recommended by police authorities, considering potentiality of the convict and apprehension on chances of further organized by convict, premature release is not recommended. My lord, my instruction is, lordship has also recorded in this judgment, as I am reiterating that submission before your lordship, there is not a single report for the past 19 years in respect of the petitioner in jail that the petitioner
Were
has.
you ever on parole?
My lord, I was briefly, I am I have been instructed after filing of this application before your lordship, for a brief period, I was released on parole for a few days.
Not
But
before that.
no, not before that. While this application was pending before your lordship, finally has directed release of this the petitioner in that case, which I am relying
That
upon.
was an extreme case because he
My
had
lord,
repeated.
yes, my lord, what I am on mainly, my lord, as far as this petitioner is concerned, my lord, on both on the count of reasoning, on the constitution of the state sentence review board, and my lord, thirdly, non-compliance with section 438(2) subsection 2, and my lord, also on the point that there is no adverse report against the petitioner in his conduct while being in jail. My lord, the paramount importance, my lord, will see in respect of remission. Lordship has already dealt with it in detail. A person's conduct while being in jail. Jail's purpose is to keep a person in incarceration. Now it is not only a deterrent issue. It is a concern of reformation. If there is no adverse report regarding his conduct while being in jail, and my lord, in 67th meeting, lordship will be shocked. In 67th meeting, there is no distinction created by the board regarding the persons who have been released in that 67th meeting, directed to be released. It's not that all the prisoners who were considered in the 67th meeting, if I am not wrong, about 400 prisoners were considered. My lord, my instruction is people having political affiliation have been treated in a completely different manner, and they have been directed to be released. And the persons who are, I can only speak about the petitioner in this cryptic orders, they have been kept behind the bar. Now, my lord, there is no, this is arbitrary. The order is arbitrary because there's no distinction created between this petition, no meaningful distinction created between the petitioner's position and the persons who have been released by the self-same meeting. Lordship had an occasion, I have annexed to the petition also, Lordship had an occasion to consider the 67th meetings, different page 100, my lord. This was on 67th meeting only, in which my prayer was also rejected. Although, my lord, here Lordship directed the State Sentence Review Board to be reconstituted in accordance with the NHRC guideline, and
after the 67th meeting, there was no meeting.
No, as far as the petitioner is concerned, there has been nothing.
Yes, Mr. Gali, what do you say?
My lord, my learned friend, my lord, has stated in paragraph 8, my lord, at page 13. May I respectfully invite your lordship to page 13 of
What
the
does it say? Yes.
Page 13, my lord, the paragraph 8 kindly sees the sentence under such circumstances, it is warranted the reliefs granted to the applicant in connection with WPA number 14257 of 2023, the Biresh Poddar, be also granted to the petitioner. Here in connection with the instant writ petition. So, my lord, my learned friend is praying for a benefit, my lord, that your lordship was pleased to grant in, my lord. He wants to get the benefit of the judgment, my lord, delivered by your lordship, that is annexed at page 100.
My lord, my prayer clauses are there. Asking for release, my lord.
My lord, in this, my lord, matter, in this, while delivering this judgment, your lordship, the 67th meeting itself was under the judicial scanner before your lordship. And the 67 meeting, this petition is also part and parcel of that 67 meeting, along with this Biresh Poddar, who was the petitioner. Lordship, upon appreciation of the entire materials, lordship was pleased to give two findings. One, that your composition of the state review board was not in accordance with the NIC guidelines. And point number 2, that the parameters which are to be considered for remission of a prisoner in accordance with the guidelines of the National Human Rights Commission have been done away with. Hence, I hereby remand the matter back to the state review board. So, my learned friend, wants, benefit of this particular judgment or remand, because 67 meeting, he is a part and parcel of the 67 meeting, which was indeed under the judicial scanner before your lordship, and lordship was pleased to set aside. So, nothing more to be said on 67 meeting. Merit of the legality of the.
When is the next SSRB meeting scheduled, Mr. Gali? Do you have any idea?
Next, my lord, lordship, I don't have any update on that, lordship. And my lord, the judgment which my learned friend, my lord, yes, my learned friend has also prayed for one. Yes, in addition to mandamus A, B for reconsideration, my learned friend has also made one prayer in prayer C, that to especially the respondent to release the petition here from custody. That means, my learned friend wants the benefit of this judgment also, which your lordship was pleased to pass, reported in AIR 2022. Here, kindly sees the, yes, your lordship, High Court, has the power under section 102 of the West Bengal Correctional Services Act, that yes, High Court has the power to write pardon and direct release of the prisoner. Section 102 was pressed into service. But here, kindly sees, the background of the case. May I just respectfully invite to two paragraphs at the, beginning. It was, that there was a writ petition directed to be considered in the light of 432 CRPC. The state did not do it. Hence, the writ petition had to go for appeal. Appeal also order was, not, complied with. Thereafter, it was a third round of litigation which came before your lordship. Lordship was pleased to exercise, that power of, release forthwith, lordship. In the background, lordship, I don't have much to say in this kind of cases, I don't regard this as an adversarial nature of litigation, Lordship, he should get the benefit of, this judgment of 20th July 2023 in Biresh Poddar. Kindly remand it, give a time frame, so it can be, considered.
What do you say?
May I read? My lord, first, it has to be ascertained, my lord, subject to lordship's kind correction, whether lordship's order has been complied with. Taking a note from my learned senior friend's submission, I am submitting before your lordship, according to NHRC guideline, lordship's direction was there. Whether that direction has at all been complied with, because there was a, my lord, will
I'll
see
direct
at
your
page-
case to be reconsidered
My
by
lord,
the next SSRB. I'll give you a
my lord,
limited time.
SSRB has to be considered.
Orally, I am told
That I'll take care of.
And my lord,
Properly constitute SSRB, and that
my
will
lord,
take
kindly
care.
sees page-
Because
From now on,
directly
from now on,
directly
there is-
releasing you from here would be a tall order, because I am not in a position to ascertain what are the report's current conduct and all this. I'll just give the guidelines and direct this law to be followed. Properly constitute SSRB. Your case will be considered within a limit.
My lord, only one thing, my lord, at page 97, lordship will find that there was another meeting of the SSRB, not for the petitioner. Petitioner's case was not considered.
No, no, I
At page
directly
90,
consider you.
97, there is a 68th meeting,
Yes.
which was held on 6th of June 2022. So, my lord, 67th, it did not end with 67th meeting. There are meetings being held. So, my lord, today, as on today, SSRB is continuing holding
You don't know
meetings.
whether the same constitution is continuing.
No, I am
My lord,
told
that has to
was
be ascertained. My lord, whether they have complied with the lordship's order.
That's what I was willing to apprise your lordship. As on date, I have been told orally that this composition as directed by your lordship, that in compliance with the national, is being carried out. That
Has to be.
Yes.
The petitioner has been in custody, being convicted primarily under section 302 of the Indian Penal Code, for a period of 19 years, seeks remission. It is contended that on the application of the petitioner on such count, the State Sentence Review Board within bracket SSRB, which was improperly constituted, took a decision of refusing the petitioner's prayer. It is contended that since the composition of the board was not in consonance with the existing guidelines, the said decision ought to be set aside on such score alone. Next para. Secondly, the convicting court apostrophe's opinion was not taken within the purview of section 432 within bracket 2 of the Code of Criminal Procedure. Thirdly, the well-settled yardsticks which are required to be adverted to were not taken into consideration by the SSRB in refusing the petitioner's request for remission. In such context, Learned Counsel places reliance on Gopal Sarkar versus State of West Bengal, a judgment of this court reported at AIR Online 2022 Cal 2520, where under similar circumstances, a release of the convict in question was directed. Learned Counsel also submits that in Biresh Poddar's case, dated July 28, 2023, passed in WPA 14257 of 2023, this court had categorically deprecated the composition of the SSRB and had directed a reconstitution of the board. However, since the petitioner was also refused remission by the same board which was the subject matter of scrutiny in Biresh Poddar, the impugned refusal ought to be set aside. Full stop. Next para. Learned counsel for the state submits that in deference to the direction passed in Biresh Poddar, the SSRB is being reconstituted. Full stop. It is submitted that all the relevant considerations are required to be adhered to while considering cases of remission, and for such purpose the matter be remanded to the newly constituted SSRB. Full stop. Next para. A perusal of the impugned decision refusing the petitioner's request for remission shows that the same is palpably cryptic and does not take into account any of the relevant yardsticks for considering a case of remission. Full stop. The authorities merely placed undue stress on the fact that the offense was grave in nature. Full stop. In a cryptic manner, it was observed that the chances of deterioration of law and order situation would come in the way of releasing the petitioner. Full stop. It was also observed that considering potentiality of the petitioner and apprehension on chances of further organized crime by the convict, such premature relief was not recommended. Full stop. Next para. I find that there is nothing whatsoever to corroborate the conclusion that the petitioner had sufficient potential to reorganize a similar crime, or that the petitioner would, even after 19 years of incarceration, be of such a threat to society that it would tilt the law and order situation of the petitioner's village. Full stop. Next para. The mere gravity of the offense, for which the petitioner was convicted in the first place, cannot be a ground for refusal of remission by itself. Full stop. In fact, one of the major yardsticks which is to be looked into for such purpose is the present conduct of the petitioner stroke convict in incarceration. Full stop. No report whatsoever is found to have been relied on while refusing the petitioner's request for remission. Full stop. Hence, it is palpable that the present conduct of the petitioner in custody has not been entered into at all. Full stop. There is no adverse report against the petitioner as apparent from the records. Full stop. That apart, the potentiality of the petitioner cannot merely be determined by the current age of the petitioner, but also has to take into account the actual and tangible chance of the petitioner stroke convict of reorganizing such a crime if he is reverted back to the mainstream. Full stop. Next para. It is well settled that in modern jurisprudence, one of the cardinal considerations of punishment is reformation and not retribution. Full stop. The said aspect has been altogether negated by the impugned refusal. Full stop. Moreover, the respondent authorities also were required to consider the opinion of the convicting court in terms of section 432 of the Code of Criminal Procedure as held in Gopal Sarkar Supra. Full stop. Moreover, since it was already held in Biresh Poddar Supra that the composition of the board which refused the petitioner's request for remission was faulty, the said board is also required to be reconstituted for taking a proper decision. Full stop. Next para. In such view of the matter, WPA 24276 of 2023 is disposed of by directing the respondent authorities to reconstitute properly and in terms of law, a state sentence review board within 1 month from date. Full stop. Immediately thereafter, the case of the petitioner shall be reconsidered on the basis of the request already made by the petitioner along with other similarly placed convicts, if their requests are still pending. Full stop. Such consideration shall be in the light of the above observations as well as the yardstick stipulated in Gopal Sarkar versus State of West Bengal, reported at AIR Online 2022 Cal 2520. Full stop. Next para. Such reconsideration shall be conducted by the newly constituted State Sentence Review Board within 2 months, within 1 month from the date of its reconstitution in terms of the above direction. Full stop. It is made clear that the case of the petitioner for premature release has not been considered by this court on merits, but the SSRB has to keep in mind that the relevant yardsticks as indicated above are mandatorily required to be adverted to by it before taking a decision on the petitioner's request for premature release.
The impugned order may be quashed, madam. The order which is impugned before your lordship, passed by the SSR.
No,
The previous SSR.
quashing would be
My lord has made that observation in the last line. So, my lord,
quashing, I'll not quash it. Quashing may be constitute to mean that I have released you.
lordship. But
আচ্ছা একটা লাইন অ্যাড করে দিন, হি ইজ রাইট। In view of the unlawful constitution of the SSRB, which passed the impugned order of refusal of the petitioner's prayer for remission, comma, the said order is deemed to be rendered null and void.
deep.
they are proceeding with the matter yesterday, my lord. They didn't receive the letter, and tomorrow is another date for hearing. Kindly ask them to stay their hand until the judgment is passed. And I'm awaiting the judgment. This is very unfair.
Long back. They should have asked for stay of the proceedings.
Petition to the
The order, it was fixed the 23rd November, the last day.
Lord,
What was the challenge against?
Yes,
Jurisdiction.
the jurisdiction time has expired, number one, and secondly
That matter.
Yeah, that matter, and secondly that there is no scope to hear the matter on maintainability.
Mr. Chatterjee, my judgment has been dictated. I'll dictate it tomorrow.
Tomorrow is the date. Tomorrow is another date fixed.
Tomorrow 10:30 I'll deliver my judgment.
Sorry to bother your lordship. Then
No,
I
no
take
question of bother.
and not one thing. Not my name should be. I am Ajoy Krishna Chatterjee.
Yes.
not
What has been typed there?
Ajoy Chatterjee, Lord, and then JOY.
Mr. Chatterjee, these are generally done
Yes, I follow.
on the basis because they take down
yes.
the orders as per the slips handed over.
The slips handed over.
I am not consulted while typing the names.
I am with Krishna, Lord. Don't take me away from Krishna. Grateful, Lord.
Yes.
Item 20.
তুমি একটা ইয়েকে পল্লবকে কাউকে দিয়ে ফোন করে দাও তো যে আমি বার কাউন্সিলে ম্যাটারটা না দিয়েছে আমার
Well, I'm for the state response.
yes. You're for the petition.
Before your lordship, my lord, takes up the petition for hearing, I admit that there is a delay on my part in affirmation of affidavit. My lord, may I be permitted to file this? But I don't know the reason my learned friend is not accepting service of such.
Because you are late.
My lord, opposition.
Obviously.
So, my lord,
11 p.m. yesterday. May I please, my lord? Yesterday night at around 11:30, we received that in WhatsApp. A scanned copy, even though I am ready, my lord.
Take the copy and come
I am
back.
ready. I am always ready.
So can you prepare a reply? How soon can you prepare a reply?
Reply is not required, but I am ready. My full
reply is not. Oh, you are ready right now?
Yes.
Very well. I'll take on record the affidavit now.
my lord, the affidavit in opposition.
Yes. What is the matter?
My lord, this is a matter relating to the exotic live species.
Yes.
That is a non-native of Indian origin. The Wildlife Protection Act 1972, from the date of that enactment till 2020, the exotic live species has been totally exempted and it is not covered under Wildlife Protection Act 1972.
Right.
What happened, my lord, during 2020, the Union government, in order to streamline the process of import and export, and they want to get the database and collection of the persons and the holders of exotic live species, those who are being an Indian citizen and living inside the Indian territory, for which they have introduced one amnesty scheme in the name of advisory for declaration of stocks. That was a notification was issued to that effect by the Union government. That is in annexure P1, page number 24, annexure P2.
You deal with exotic species?
Yes.
I mean, you trade with those. You sell and...
Yes, I used to breed it. I'm a breeder.
You are a breeder. So what sort of exotic species? I mean, give me one or two examples.
Macaw birds.
Macaw birds. So you say those are not protected by the Wildlife Protection Act?
Absolutely.
So you have a right to do that?
Yes.
Let us see. Page 22, yes, P1.
24, my lord. Sorry, page
24.
24. In page 24.
Yes.
In page 24, there is a official notification of the Union Government of India. In there, they have declared this notification as a voluntary disclosure scheme. That date starts from 16th of June 2020. It is available in the left-hand side corner. And the date ends by 1 year. First, it has been introduced for 6 months. Then later, it has been extended till 2021. Based on the several requests, it has been extended. while introducing this amnesty scheme, the Union government had voluntarily gave a set of rules that is partially called as Parvesh Rules 2020. I will circulate that rules now. This is called as Parvesh Rules.
Yes. Have you got a copy of this? Parivesh rules. Please give a copy to him also. So that he can argue. I mean.
Yes. Yes. According to this amnesty scheme,
yes,
in 1B, I have marked it there. They have given a full immunity from any criminal prosecution to the persons or the breeders or the holders, those who are dealing with exotic live species.
If declared within 6 months.
Yes, that is 1 year. Right now it is 1 year from 2021 till 2021.
Yes.
So after issuing this immunity from legal prosecution, all the breeders and traders, those who are having their exotics, started making a Parvesh registration. It is an online registration done in a portal called as Parvesh portal.
All right.
That Parvesh portal belongs to the Ministry of Environment, Forest, Climate Change. And in which what we have to do, the process is that I have to open a page. It is called as a single window system. The single window system means once a declarer makes his declaration, even the declarer cannot be changed after putting their inputs. So that is called a single window system. So rightly, I have also and all.
You did that within 15th December 2020?
Absolutely, my lord.
Then?
Meanwhile, one person filed a writ petition before the Honorable Supreme Court, challenging the Parvesh rules. While deciding that matter in Swetap Kumar case, the Supreme Court clearly upheld the decision of the Union government and clearly observed, yes, it is right. The Union government want to make a streamline of this process that cannot be quashed and cannot be challenged. But whereas the immunity granted under this rule, Parvesh rule, should sustain always.
Very well.
To that effect, that petition was disposed of. Then the petitioner herein, my lord, he is a pure breeder. He registered all his exotic live species within the caption of Parvesh portal. In page number 22, my lord, you can see that Parvesh registrations.
What is your cause of action now?
My lord. In this case, my lord, what happened? I am praying before this court for two relief. One, in contrast to these Parvesh rules and the immunity granted by them, without having any reason, they have rejected my submissions. That is the declarations what I have made in the Parvesh portal. I request your lordship to take.
My lord, may I intervene? My learned friend has made an application for breeder's license. Now, my lord, his case is this after amendment of Wildlife Protection Act, there is a rule. Lordship may kindly takes up the affidavit in opposition.
Let him conclude. Let him conclude. Yes.
Because without showing this background of this case, I cannot go to that part.
So you see your registration application has been rejected?
Yes, absolutely my registration was
Why do I get that?
I will show it.
Page 22 is something else.
I will take you.
What is the application?
Page number 29 to 63 it is. The page number 29.
The proposal is approved. Page 29.
This is the parental board which I have declared. The top you can see 2020, the year 2020. This board is approved by the Chief Wildlife Warden. I take your lordship to page number 35. Page number 35. The 35 in the top, you can see the registration of progeny of previously held exotic livestock. That means the parent bird which I have already registered gave birth to the subsequent chicks. It should also be declared. So rightly, I have also declared that. Then next over the page number 36, when I transfer that chick to some other person, that paper was rejected without any cause of reason. When the parent bird is literally approved and its progeny was also rightly declared by the petitioner, and it has been rightly declared for the transfer of possession also, that was rejected. Right from till page 63, these kind of complete rejections has been done without any reason. It is totally an unlawful act.
Now the transfer is what you want to register.
Yes, everything according to that. According to that,
because you have already put in the register. You have already registered regarding those species.
Yes,
which are in your stock.
Yes,
but subsequently, what was the occasion of further registration?
Let me explain. According to these Parvesh rules,
yes,
the parent bird should be declared.
You have declared.
If it gives to a chick, then
Yes,
it
the
should,
progeny, yes.
progeny has to be registered. If there is any transfer,
Yes.
trade, or death, then it should also be registered according to 1G in Parvesh rules.
I
Over
want
the
to
page.
see that also. Yes.
It is over the page. 1G. It should be declared within a period of 30 days.
So you have done that.
I have done.
That has been rejected now.
Yes.
That is your cause of action.
Yes, that is one point.
Yes. What is the other?
Another one is, my lord, regarding the breeders of license rules 2023. After this enactment of this Parvesh rules, a subsequent amendment was happened in Wildlife Protection Act 2022. It came into force on 1st April of 2023. In that, my lord, specifically there is one provision, section 49M. N. So. If your lordship permits, I can circulate the book.
Thank you. Yes.
The bottom line.
Yes.
Section 49 says that those who are being in possession of this exotic life species, which is newly included in the Wildlife Protection Amendment Act 2022 in Schedule 4. More particularly, Appendix 1 birds. There are 3 appendix there, out of which certain birds and animals which are being listed in Appendix 1. So those who are in possession and want to breed the exotic life species which is listed in Appendix 1 of Schedule 4, then they have to make an application for getting a breeder's license to the concerned Chief Wildlife Warden. That is what Section 49 says.
Right.
Then Section 49Q says that if anything goes wrong, then the exotic birds will be forfeited by the government. Under such case,
this is in 49?
49Q. This is 49Q,
right?
Yes. 49Q says that if anything goes wrong, then the birds will be seized and declared as a government property.
Anything goes wrong means, let us see the language. If you contravene the
Yes, contravene the provisions of this. Under this junction, my lord, as I told earlier, the earlier writ petition person Swetha Kumar again filed a second clarification petition before the Honorable Supreme Court. What they have challenged, need clarity is that once already a immunity has been granted by the Union government through these Parvesh rules, now the subsequent amendment act says that it will be taken away by the government. So it is totally in contra. So it has to be clarified. That Supreme Court again on 24th of March 2023 gave a clarification order stating that no, according to 49Q, the government officials cannot take back the birds from the concerned holders because already immunity has been granted. So once the immunity is availed by the breeder, no criminal action can be taken either by the center or the state. So once again, the Supreme Court assured the immunity granted by the Union government.
Assured the immunity, but read that provision into 49Q.
Yes, absolutely.
That if Parvesh rules have been adhered to, then 49Q does not apply.
Yes, absolutely.
So it has been read down, brother.
Yes.
Very well.
So my issue is that I have applied for the breeders of license rule.
You have availed of Parivesh rules.
Yes, already I have, because right from 2020, I am putting my all my birds and my progenies and
So therefore,
depreciation,
49
everything
Q cannot apply to you.
Yes, absolutely, it cannot be
cease.
done. But it is not the matter of fact to be decided here, because I'm telling a little bit of something.
That is premature, probably.
Yes.
It has not yet been done to you.
No, it's not been done. Now the matter is, I have applied for breeders license rule.
Acha, that has been rejected also.
That has been rejected.
Where is that?
In page number 25, Your Honor.
The Supreme Court judgments, have you got copies of those?
Yes.
Yes.
Supreme Court judgments.
The Supreme Court judgments, have you got copy? Oh, yes. Justice Krishna Murari one.
This is called as a breeders of license rule. The second one is called the breeders of license rule.
No, this is the last clarification order.
Yes. The top it is the date is the 27th.
Very good, yes. So where is the rejection? Page 25.
25, my lord.
25, 26, 27.
It starts from 25. I will explain the facts.
Oh, acha, they have relied on the Wildlife Protection Act itself, contrary to this judgment.
Yes. I will put you some.
So your challenge is two-pronged. One, you have challenged the transfer registration, which has not been done, and this refusal of your breeder's
In the
license.
refusal, there is one crucial, very simple point to be clarified. If it is so, the entire problem will be solved.
Yes. An exception granted to those who have abided by the
Absolutely.
That is it.
I will circulate this government e-notification. According to section 49N, I have already informed you that there should be application filed before the Chief Wildlife Warden. In that provision, it says that the manner of filling the application and the application form and the amount what should be payable to the government will be prescribed by the subsequent notification. Based on that provision, my lord, on 24th of April, a specific rule has been introduced. It is called as Breeders of License Rules 2023 that I have circulated to your lordship. So in that rule, section 2 says that
this is in terms of justice, this Supreme Court's order.
Yes.
Yes, 2 is there.
In section 2, it says that it shall come into force from the date of official publication. When your lordship go through the official publication, it states that it has been published only on 28th of April. But again, I will take your lordship to page number 27, 25.
This is after that.
In page number 25.
Your rejection is after that.
Yes. I have submitted my application fully. But there is no such advertisement, or they are common people having a normal birds and breeding. They are not aware of this kind of rules and regulations. They have simply filled the entire form and they have submitted. After receiving that application, this notice was served to me stating that it is not in accordance with the provision of rules. But there is no such reason or any statement has been mentioned there. What wrong has been committed by me in filling this application?
They have given you liberty to apply in proper form. Do that.
Yes. After rectifying all these things, I have once again filed exclusively Form 1. I will show that differentiation. According to the Breeders of License rule, those who are already engaged in breeding should only fill Form 1. Those who are intent to breed in future, they should fill the Form 2. So the first part, wrongly, I have filled all the applications without knowing the application provisions. So that I have received this notice. Then subsequently, I have submitted my Form 1 application. Yes. It is there in your affidavit. In page number 28, my lord. Sorry, 26. In 26, in contrary to the Breeders of License rule, they have stated that your last date has been lapsed. So you fill Form 2 as if I am starting afresh.
What was the last date?
That is the major dispute. What they are claiming, the forest officers are claiming, the 90 days has been mentioned in the act. According to the act, it says 90 days.
Act means 49N.
Yes. So the date of enactment is on 1/4/2023. So if they take that date, it will end on 29/6/2023. But according to the Union government, they have issued this breeders of license rule. More particularly, the form was introduced to me only on 24 April. That is after a lapse of 23 days from 1/4/2023, they have issued this application form. This is the first time the application form has been issued. So the doubt is that from which date the application starts. That is the only.
So according to you, the starting point should be 24th April.
No, it should be on 27th because the official government notification says that it has been published only on 28th. So my request is that I have submitted an application. So you have calculated a wrong date. So my
application was within 90 days from April 2023. It was within that.
Yes. So I made a representation personally. Then I said, no, sir, it is a wrong calculation some wrong calculation has been done. Because from the date of issuance of application only, the 90 days should be starting count. So as if it ends on 26th of July, 2023. That was not accepted by the respondents. Hence, my application is rejected. This is the only ground for rejection.
Achha, Mr. Kumar, the first ground which you are arguing first, that your transfer has not been registered.
Yes, that is relating to
transfer to whom? To you?
No, I can. For example, I am selling my bird to him.
Yes.
Then he should have a Parivesh ID in his own name. I should make a transfer of paper from my name to his name.
So you are to make that disclosure.
Yes, it is a voluntary disclosure scheme. So I have to make it voluntary. It is an amnesty scheme. So the purpose of that introduction of scheme is that those who are needed of immunity, they themselves voluntarily go and make the
although it's termed as voluntary, if you don't comply with that, then the rigors of wildlife.
Absolutely.
So that voluntary has a
yes. So that is why the immunity was assured once again by the Supreme Court. So it is my voluntary submission. I am stating that I have got a check that was registered duly within 30 days. Within 30 days, again the transfer should be done from the date of transfer. From the date of transfer, I have rightly declared my transfer. That was also registered. He, being a person, buyer, innocent person, he also make his acquisition based on this transfer paper in his name. Now, what happens is that when my transfer paper is rejected, automatically his paper will also be rejected. The consequential effect is the most serious thing happening right now in Kolkata, not in Kolkata, in the entire West Bengal. Based on these rejections, criminal cases has been registered against the exotic breeders and traders.
Naturally, under the Wildlife Act.
It cannot be done because they are registering a provision under 39. I request your lordship to take section 39. It is in the Wildlife Protection Act.
Yes.
Section 39 says that related to only wild animals.
Yes.
It is not relevant to this exotic life species. Exotic life species cannot come under the definition of wild animals. But now what they are registering cases regularly is the violation of section 39(1), section 39D and section 39 subclass 3 is being continuously registered by the respondent in entire Kolkata.
Wild animal as per the definition in this act is also schedule 1 and schedule 2.
But exotic life species comes under schedule 4.
Exactly.
So this is my grievance, my lord. According to the Parivesh rules, provision 1G, the respondent authority not at all having the right either to accept or to reject any submissions made voluntarily by the breeder, very particularly to the death, transfer and acquisition and change of possession.
Mr. Kumar, can you file a very short, brief written notes of arguments? I'll give you 2 days time to do that if you want.
Sorry to say, my lord, As I told in the last occasion, I'm from the state of Tamil Nadu.
Pardon? Oh, no difficulty. Send it by email. He will file it.
Last 2-3 days back, one very big natural disaster happened in the state of Tamil Nadu. My entire office lost. I lost everything there. Still now I am standing. Before that, I am also an aviculturist. I am a pet lover. I am in more deep concern about this. My fellow breeders were chased away by the criminal prosecution based on these provisions of law. Only because of this reason of unlawful rejection, when they have no right to reject. According to section 1G, they have no right at all. The law clearly says that they should give an acknowledgement. That is it. Whereas in the voluntary disclosure, they have to go for physical verification. But in 1G, there is nothing stated regarding physical verification, either to accept or to reject. So when they don't have the right except to either accept or reject, then how they can immediately claim a power by themselves in contravention
No,
to the
just
provision?
put your arguments on paper. Need not be a longish thing. Just put in the sections you have just argued before me, so that it's comprehensive before me.
If
Just
your
do it
lordship,
tomorrow, you can do it tomorrow.
if your lordship please, I will make it by tomorrow itself.
Tomorrow itself, I'll keep it at the top as to be mentioned only for that purpose.
Greatly obliged.
Thank you. Yeah, let me hear them. Yes.
No, my lord,
Take your arguments now.
Yes, my
and
lord,
I'll take your
regarding petitioner's my lord, grievance of rejection of his application, lordship may kindly be pleased to take up my affidavit in opposition. Now, my lord, page 24. My lord, this is the rules. The rules may be called Breeders of Species License Rules 2023. In terms of this, they have to apply. Now, lordship kindly sees rule 3, procedures of filing application for license. Any person who is engaged in breeding in captivity or artificially propagating a scheduled specimen listed in Appendix 1 shall, within a period of 90 days of the commencement of the Wildlife Protection Act 2022. My lord, pausing here for a moment. This act came into force on 19th of December 2022. So petitioner made an application after expiry of 90 days. That is the stand of the state respondents. That's why his application for breeders of species license has been rejected. My lord, kindly takes up the writ petition and the rejection. Page 25 onwards.
Mr.
My lord,
if the this rule itself comes in force,
no, my lord, yes, there is. My lord,
my lord,
I understand there is an ambiguity.
Already 90
Lordship,
days are over.
Yes, my lord, kindly sees page 20 of the affidavit in opposition. My lord, it's a rule by the central government. They are a party. So, my lord, kindly sees page 20.
20 years.
Yes, my lord, there is a communication from the office of the CCF, West Bengal, to the Additional Director General of Forest Wildlife, my lord, with a communication that this ambiguity may be taken care of. My lord, kindly appreciate, my lord, this 90 days period. My lord,
taken care of means?
My lord, 90 days means that as occurring in the rule, after the Wildlife Amendment Act came into
taken
force.
Care of means what? I mean,
yes.
how will you take care of it?
My lord, there may be some amendment or something, because there is some difficulty, some ambiguity.
We'll
But
interpret it. We'll have to interpret it.
My lord,
cannot be. I mean, I issue a rule today, I issue a form today, and say it has to be retrospective.
my lord, subject to
This is
correction.
ridiculous.
My lord, subject to correction on the face of this, since this specific rule is here and rule 3 is here.
So therefore,
my lord,
your
my
take
lord,
is that you are complying
yes,
with
yes,
the rules.
my lord, the respondent, the concerned respondent rejected, my lord,
This is
on the basis of rule 3.
This is the reason for rejecting their breeder's license application.
My lord, that is the ground.
That.
My lord.
And what about the transfer registration?
My lord, my instruction is this: that has to be looked into, the transfer application by the authority concerned.
You should have had instructions. You're appearing today. We are hearing the matter. It's appearing for some time. This is not the first occasion it is appearing. And the grounds were enumerated on the last occasion also, more or less at least. Affidavits are exchanged. We are on hearing stage.
One humble submission, ma'am.
No, I'll come back to it.
No pleasure.
If you want to shed light on the ground of rejection, you can do that so that he can answer. If that is what you are trying to say.
Absolutely.
What is that?
My learned friend failed to circulate another copy of the internal communication that I may be permitted to submit. On the same date, your lordship can see the date of communication happened, the internal communication, both those orders are on same date. On the same date, in memo number 8, which is this is my circulation is the first and foremost communication. My learned friend's submission of document is a secondary document. It comes around 1,000 something. The memo number is this. They have clear, the chief wildlife warden had clearly instructed to take action and to receive all the applications and to send a report based on the breeders of license rule dated 24. It has been specifically stated.
This is regarding the breeding, the license.
License rules.
No, we are not on that. Now we are on the transfer not being registered.
Yes,
I'm
in that
asking why those
counter
were not
affidavit, in their counter affidavit, which was given to me last night, they have clearly stated that the reason for rejection itself, in which they have stated the source document what I have submitted at the time of making such transfer is not authenticated.
Not authentic.
Yes.
Or authenticated.
Authenticated. So I like to throw some clarity on this. And the earlier I show the papers which is being approved by the chief wildlife warden. And the female
You have
parent.
uploaded those.
Yes. But
Have
how
you
they
stated in
can
your
say?
reply?
Yes, yes.
Have you stated this in your reply?
Yes. That this is reply is not concerned with this.
Oh, sorry, reply I have not taken on.
Regarding this rejection of papers, the form itself shows that the parental birds registration and the parental birds or the source paper number also should be incorporated. Then only the entire transaction will be completed.
You have done that.
It is there on record. I will show you. I request your honor to take lordship. To take page number 35. Page number 35.
Yes.
In the column, the first column shows the species common name called as harlequin. That is a common name of the bird which is to be done. The scientific name is also there.
Yes.
It is a bird of mutation. So it was bred between two different birds. And the gender is also there. 2 females and 1 male. Then the date of birth is also stated there. Then the address of the facility is there. Then the parent stock, that is WB stock 2020 59196 and 56844. Both these documents I have already submitted as a source document, and I have uploaded the copy of that parent's board in online. The manner in which the Parivesh portal has been designed is that without uploading the parental paper, I cannot complete my submission. It cannot be done. So now my learned friend taking a different stand as if the source paper is not valid.
Page 35 is the status is proposal is pending, not
Yes.
yet rejected.
No, the back end paper, the transfer paper is rejected. That is in 36. Rejection is in 36.
36 is a 36 is a different.
No. Same.
For the same second batch. Right.
In that page number 36 also, the WBLB 172 is already stated that the source paper is already.
Be proposal pending at Chief Wildlife Warden and in the same breath rejected?
I don't know, my lord.
Is this the same for the same birds?
Yes. Page number.
No, but the details vary.
My lord, it is called as Harlequin Macau.
Harlequin Macau is same.
Yes.
But in the first page, page 35, gender and numbers, male 1, female 2.
Yes, that is progeny, my lord. Progeny.
Oh, this is. Oh.
So my parent birds were registered, approved. My progeny was also there. I have registered and I have made a valid transfer. That was rejected.
All right.
My submission before is that.
36 is regarding the parent.
Regarding the transfer.
No. Transfer, the entire thing is 35, 36, both are transferred.
No. Page number 35 is the parent pair.
All right.
Then I have enclosed the next page. That is the progeny registration.
Transfer, right. Very good. Then, yes, I'm sorry.
So my legal question before this honorable court is that according to class 1G, of the Parivesh Rules 2020,
Yes.
the forest officials did not have any power either to accept nor to reject. The rule clearly says that an acknowledgement should be given. That's it. Whereas, while I'm making a voluntary disclosure, the physical verification is there. They have to come physically verify, then only they have to issue. But for this exclusively of death, trade, transfer of possession, and change of possession, no physical verification is required, no approval, either approval nor rejected it is required. Because it is practically difficult. Let me explain. If I will take your lordship's precious time, 2 minutes.
No.
The problem is being an aviculture for more than 25 years of experience in this field. The problem, the lawmakers are more brilliant and they have enacted in a proper manner. Because at the time of introducing this, in Delhi, there was a committee was formed regarding with all other breeders and other things. I was also participating at that time. So what we have stated before that drafting party, for example, personally, I am having 150 pairs of African lovebirds in my home. Right now, still now, I am having in my home.
You?
Yes. If my one pair, obviously it will lay an egg between 6 to 18 count. We will take in short or death casualty, not hatching. We will leave other 3 and I will take example 5 chicks I got. Out of 150 pairs, your lordship can imagine how many chicks I can get for a single person. Out of which within 1 month some may die. I can transfer to some other person. 3 may be sold, 2 may be pending. Then later on it may be died, it may not be died, or I can retain. So think about the entire India, In Kolkata alone, more than 1 lakh people are involved in these exotics. So if one paper of Parivesh rejection was done, it is a chain link reaction which goes and ends to the last consumer.
That's right. Yes.
So that is why I am contending before this court when they have no right either to accept, not to reject. Only thing is they have to give an acknowledgement. That is why the reason that practically it is not possible for every breeder to register their thousands of stocks and chicks and progenies. And something may die, something may not be die. Everyone is having their job. The petitioner, my lord, he met with an accident and he cannot move his hand. He is a sole, this profession is the sole breadwinner. Many small scale persons are doing this business in a small scale manner, and some middle persons are also there. Most probably females are concerned about this because the husband used to go for a job, they will leave these birds to them. This is there for breadwinning aspect. But without applying their mind and not having such a clarity, the simple rejection leads to criminal cases, man. That too, a very hard and worst thing happening right now for the past 3 months is that the birds are being seized and kept in zoos that are dying in zoos. A normal layman, he used to pledge his wife's gold and everything, and he going and buying some bird for 50,000 rupees, and that was taken away by these forest officers, and it is dying in the zoo. Then who will calculate the damages and other things? They cannot survey in their life because of this unlawful.
Nobody pawns his wife's gold to buy a bird. Hello? Nobody pawns his wife's gold to pawn a bird, to buy a bird.
Yes.
Nobody does that.
No. It is a business.
Oh, for business purposes.
It is a pure business.
So it's
That's
obvious.
why I told you.
It has an effect across the board.
Yes.
People are doing the business, right? Get your point.
In some cases, deceased birds are also found to be missing.
Naturally, if one doesn't know how to upkeep the birds, then naturally they will die also.
Actually, this is an exotic bird.
Yes, Mr. Basu, what do you say?
Well, regarding rejection of breeder's license, I have already submitted. Now, regarding
transfer
rejection, yes, transfer, lordship may kindly seize the affidavit filed in paragraph 12 and 13. Lordship may kindly consider and pass out the record. Paragraph 12 and 13 of the affidavit in opposition that the documents required, source documents, those were not uploaded. At page 12 and 13.
Have you specified what documents? Source documents they have annexed also.
Now, paragraph 13. No proper source document were found in the application, and unless the source documents are uploaded, the stock cannot be verified and or taken cognizance of. Thus, no physical verification was required since the application was expressly defective. And my lord, accordingly, the petitioner was informed. My lord,
but difficulty is if they say you have not uploaded the source documents and you have not used a reply, then this remains uncontroverted.
My lord, that is why I have mentioned your lordship. The portal has been already designed in such a manner that without uploading my parent paper, it cannot be done.
I'll take that on record. Fair, I'll record that.
So another one I want to contest that. My learner friend says that the reason for rejection, they have informed me. Let them show any document.
Informed what?
In the top, in the 10th para, they have stated that as regard to the statement made in para 15, the writ petition answering the respondent apply for registration of species held in ownership certificate. Where they are saying that on para 12 and 13, they are saying they have informed me the reason for rejection.
But they have not said that.
No, I will take your lordship's exact para.
Yes, yes. 12 and 13, they only give the reasons that you have not uploaded.
I will take your lordship, please. I have seen some, just now I got this paper, so.
The uploaded documents they have also annexed.
Yes, I have given all the approved documents, parent
They have
documents.
also annexed, they're saying they have annexed.
Yes. In their document itself, the proposal parent source paper is there. It is.
Show me from their documents, please. They have annexed also in this.
Yes, yes, I will take your lordship. I request your lordships to take page number 31 of their counter affidavit.
31, yes.
In the 31 tabular column, it is stated the registration number of the parents. WP number 1582592 2022. The date
Number
of
has been given.
Yes.
They're saying you have not given the source document.
That is why I am again trying to explain.
Yes.
Without uploading this document in online, this registration cannot be done. Everything is an online registration. So when the portal is very strict, without uploading this document, that is exclusively the parent document, this paper submission cannot be done. It will not accept. That is the manner how they have created this portal. In that, my lord, without applying this paper, mentioning this number, so they have said that my source paper is not there. I have stated my number. I have stated my parents' registration number is there.
They can also verify.
They have the access of the portal.
Well.
They could have verified it, whether the proposal is right or wrong.
Mr. Vasu, would you like to use any affidavit because your argument is here? If you want to use any written notes, you can file it tomorrow morning. So I'll keep it at the top matter under to be mentioned tomorrow. Very well. Affidavit in opposition filed today be kept on record. First of learned counsel for the petitioner contends that since the arguments primarily revolve around questions of law, the petitioner shall not use any reply. First up, it is further submitted that several persons are suffering due to pendency of the present challenge and criminal cases are being registered under the Wildlife within bracket Protection bracket closed Act 1972, for which there is extreme urgency involved in the matter and the petitioner wants to argue the same today itself. First up, accordingly, heard learned counsel for the parties. First up, learned counsel are requested to file their brief written notes of arguments tomorrow, that is on December 13, 2023, when the matter shall be placed under the heading to be mentioned at the top of the list. Thank you.
One small correction. Lordship had stated Wildlife Protection Act 1972.
Yes.
There is a case under Wildlife Protection Amendment Act 2022. In 1972 Act, these exotic species were not included.
As amended till date. Right.
Obliged. Obliged.
ওটা ঢুকিয়ে দিও as amended till date.
21.
Yes.
I have heard the petition. This is new electric connection. No, I have deposited 12 October 2023, my lord.
10th October they have given.
After 1.5 months, I have filed with your lordship.
10th October, Lordship, there is a time limit. This is for 180 days, Lordship. I may give.
This procedure is going on, my lord.
Lordship, this low tension overhead line is not
Every
there. That has to be created. If Lordship kindly see para 8, the time limit has been amended, later which is applicable in this case given in clause 4. Regulation 57, it is stated that in case of drawing LTHT overhead line, though through paddy land at that time of period may be extended up to 180 days. Para 4 clearly says that they have deposited on 12th October 23 and there is no nearby LTH line is available near the consumer premises. Therefore, drawing of new HUL line, installation, new distribution transformer, structure on paddy field is required.
So in this case, LTHT overhead line is
It's
required.
not there. It is has to be drawn. So that's why it's.
When did they apply?
On 12th October. Filed the writ application in November. We'll try to do it expeditiously, but the time limit is that we are going to adhere the rules.
I'll record your argument and observe that you will do it by January 15th, which is more than 180. Good.
110 days is going to complete on April, Lordship.
October, you said?
October.
Oh, 180 days.
6 months.
6 months. Oh, very well. Then they have sufficient. Then it's premature, Mr.
Yes, that's
He's
what I'm
right.
saying. That
He's
makes
right.
it premature application.
Palpably, no. Palpably premature. Learned counsel for the petitioner contends that the petitioner applied for electricity connection, which has not been given by the WBSEDCL as yet, despite the petitioner having so applied on October 10, 2023. Who's of next para? Learned counsel appearing for the WBSEDCL contends that the writ petition is premature, full stop. It is argued that in terms of clause 4 of regulation 57 of the WBERC, comma, in case of drawing LT/HT overhead line through paddy field, the time period be extended up to 180 days, considering the season of cultivation. Full stop. In the present case, comma, keeping in view the season of cultivation and other corresponding factors, comma, and since there is no existing overhead line in the area, comma, the time of 180 days is yet to expire. Full stop. Next para. As such, comma, it is reiterated that the writ petition is premature. Full stop. A perusal of the concerned regulation and the averments made in the writ petition vindicate the stand taken by the WBSEDCL, full stop, since it is as yet, comma, not even a fraction of the outer limit of 180 days have elapsed since the application being made by the petitioner, comma, the writ petition is undoubtedly premature, full stop. Hence, WPA 26265 of 2023 is dismissed as premature without any orders to cost, full stop. However, comma, the petitioner will be at liberty to prefer a fresh writ petition on the self-same cause of action in the event the WBSEDCL fails to adhere to the outer limit of 180 days in drawing the LT/HT overhead line through paddy fields for the purpose of giving electricity connection to the petitioner. No rest to cost. The written instructions filed today by the WBSEDCL be kept on record.
Only 2.5 months already over, my lord.
Yes. What is the other matter?
Same.
No same matter. My this September, 11th September, I have deposited quotation amount. Not
22.
22.
September.
ওই একই অর্ডার হবে শুধু 11 সেপ্টেম্বর, ডেটটা হচ্ছে ডেট অফ অ্যাপ্লিকেশন সেপ্টেম্বর 11 অক্টোবরের বদলে।
My every service.
দেখে দাও
23.
For the petition. But here the
Again, you
petitioner applied for a new electricity connection that has been denied on the ground that the private respondent made an
service on private respondent.
but that has been returned with an endorsement insufficient address.
No good service.
But I have served in the same address which their learned advocate mentioned in the legal notice. But kindly compare these two addresses, Madam.
Where is your affidavit of service?
I'm keeping it.
Yes. Where do I find their advocate writing in the
But that is at page 27.
27.
There is an objection that a civil suit is pending. That is why the connection has been denied.
No, mailing address has been given.
That is the address of the petitioner where nobody is residing. There is no specific instruction.
No. Then you have not sent at the address which has been given. It has
But
been
mailing
stated
address-
here, Obhijit Das, son of late such and such, of number 76. Mailing
Simon
address
Sagar.
has been given, but you have sent somewhere else.
Well, mailing address is the same address which the petitioner is residing. That is the tenanted house. My specific instruction is there nobody is residing. Because the original landlord
should have served there.
Lordship. In that event, madam, may I come back on Monday, madam?
Come back on Monday.
Lordship.
By Monday, can you do it?
Lordship, I can do it. Only one thing, madam, let the matter appear under the same heading because the petitioner is living without electricity for more than 1 year.
What is the dispute? Tell me.
But I have applied for a new electricity connection that has been denied on the ground that the 2 civil suits are pending. What happened, my lord? The petitioner is a tenant in respect of the property. Now the original landlord and his wife died. They did not have any issue. Suddenly, this person come and claiming himself as the owner of the property. I filed a civil suit for permanent injunction. They filed a civil suit for eviction. Both are pending.
In their suit, what address has been given? Check up.
The plaint has not been solved. I have served only a. I have got the information from the court matter that civil suit is pending.
In your suit, they are appearing?
No, madam, they are also not appearing.
Bring the plaint tomorrow. I'll keep it in the, it will be under the same heading.
But kindly come to my lord page 15 once. This is my suit.
Yes, but unless they appear, how do I know that they have been served properly in that address?
Lordship.
You are consistent. No, 1 minute. In your suit also, the address is different from what you have, from where you have sent it now.
561 Diamond Harbour Road.
You have sent it at 76.
Because the only thing is because they are not residing there. In that event, my lord, may I serve once again in that particular resident address and come back on Monday, my lord.
Do you correct the cost title also include all the addresses? Your suit address, that address, everything. Send everywhere. And point out to me that these are the addresses I have sent everywhere.
Lordship. In both the address, I will send another notice.
I think that will be better.
Lordship.
No, this address don't send.
561 by B.
Yes. The affidavit of service and the envelope which has returned from the private respondent are kept on record. First of it transpires that the envelope sent to the private respondent has returned with the endorsement insufficient address. First up, learned counsel for the petitioner submits that the copy of the writ petition was sent at the address of the private respondent as per the letter, the advocate's letter sent by the private respondent himself. First up, although the mailing address given in such letter was the address of the petitioner himself, comma, it is contended that the private respondent, comma, within the knowledge of the petitioner, comma, does not reside there. First up, next para. However, comma, it transpires that in a suit filed by the petitioner, comma, a copy of the plaint of which is handed up for perusal of the court, comma, the address of the private respondent has been shown to be same as that of the petitioner. So moreover, the mailing address of the petitioner has been given to be the mailing address of the private respondent has been given to be the address of the petitioner. First up, accordingly, the petitioner is directed to serve a fresh copy of the writ petition at the mailing address as given in the advocate's letter of the private respondent and file an affidavit of service in that regard on the next date of hearing. First up, the matter shall next be listed on December 21, 2023 under the same heading. Same heading. First up. No, in your plaint and in their mailing address, in both places, your address has been given.
Lordship.
In your plaint also.
My lord, 76, they have mentioned. Great.
You ask your client to stand outside the door, it's the same address. When they
24?
Yes.
Milord, this is my application, Milord. I have served the copy upon the state respondent, Milord. This is the affidavit of service.
Yes. What is the matter?
Milord, this is the second round of writ petition, Milord. First round, I have sought. Correct.
Wrong number.
Wrong number. However, it is to be corrected and Milord returned.
However, it is to be corrected
by me, Milord.
In the cost title only.
Only that is.
I'll give you leave right now. Correct the cost title. একটা লাইন অ্যাড লিখে নিন leave is granted to the learned advocate on record for the petitioner to correct the cause title of the affidavit of service,
correct the number, only read
correct the
petition.
number of the writ petition in the cause title of the affidavit of service. তার পরের লাইন হচ্ছে the affidavit of service filed today be kept on record despite service none appears for the respondents. Yes, you're appealing for the state
in 24.
My lord, this is
the despite service টা বাদ যাবে. Yes, petitioner.
My lord, this is the second round of writ petition. My lord, first round I have lost because the state respondent was denying the dues of the security deposit. My lord, actually the security deposit was incurring from the work order issued in the year of 2014. No, bola nahi. This is the order sheet, my lord. This is the admitted fact because they have also appeared.
What is the writ petition about?
This is for the payment of the security deposit. my
এই
lord.
নিয়ে ফার্স্ট একটা অর্ডার অলরেডি আছে,
হ্যাঁ,
সেটা তো এখানে বলেননি, আমি কি করে জানবো?
And my lord, the entire thing was relegated before the arbitrator, my lord. I have already made an application before the competent authority, my lord, for the appointment of the arbitrator, but they have not appointed as yet, my lord. But it will be appearing from the annexure P1 of the instant.
Go before the arbitrator then.
My lord, they have already admitted the dues, so I need not to go before the arbitrator. I have
the admission. Show me the admission.
Yes, annexure P1, my lord. Please find enclosed released. This is the letter issued by the Chief Medical Officer Health Purva Bardhaman. Subject matter is released security deposit, security money for the cooked food supplied to the Katwa Subdivisional Hospital.
You did the work for the chief medical officer naturally. Yes.
Yes. So, my lord,
yes, Mr. Sen, there is a clear admission in the first annexure.
and my lord, there is another also, my lord. There are two claims, my lord, and page 17, they have said that how much claim is admitted by them, that is 8,68,500 rupees.
Page 17.
Page 17.
Challan for deposit of money.
Yes, that has been annexed with the particular annexure P1.
You have deposited this amount?
Yes. Because of certain, there are actually these are deposited with national savings certificates.
No, what amount? You are wanting back the security amount?
Yes, because I have completed my works. So that is the reason, my lord.
Where is the completion of work or no dues or something like that? Any completion certificate?
No, COMH is certifying, that is sacrosanct, because I have worked under him. And my lord, then again, my lord, at page 22, being annexure P2, release of, that is the letter, page 22, my lord, annexure P2, letter dated 4th September 2023, release of security deposit money by TR Challan number such and such.
Why is Purva Bardhaman writing to Paschim Bardhaman?
Because
before the bifurcation it happened?
Yes, before the bifurcation it has been happened. So these are the, here 4,40,500. So this amount is due and payable to me by them.
Who has to pay superintendent?
No, that is to be, this amount is paid by the respondent number 6, being the COMH Paschim Midnapur, and
Bardhaman.
And earlier
15 letter is written to superintendent. Respondent 7.
Yes, respondent 7 will pay.
You are directed to release.
Yes.
So who will release and who will disburse?
My lord, this is respondent number 6 and 7. Why that is issue prayer A. Respondent number 6 and 7 should not be directed to pay the said amount. The respondent number 7 is the superintendent of Katwa Subdivisional Hospital.
Yes, Mr. Sen, it has
been. My only submission is this. Just now, my lord, he disclosed this, my lord. The order passed by my lord Justice, my lord Rajashekar Manta on my lord 2nd September 2021.
Even without going into
Just now.
this. Even without going to this.
No. May I tell lordship?
Yes.
If the cause of action remains same, lordship, kindly consider one thing.
Achha.
If the cause of action remains same, the demand remains same, the dispute between the parties remains same.
No, this is I am disputing. Yes. Oh, sorry.
Now, my lord, this is the first time disclosure of this document. Now, my lord, taken aback me in any event.
But
Now,
Mr.
lordship,
Sen,
kindly.
one other aspect is there.
Now, I'm coming to
This is
this.
of 2021 and the admissions are of 2023, subsequent event.
I'm coming to this, lordship. When, my lord, this order was passed, my lord, the figure, lordship, kindly, my lord, take note. A sum of rupees 9,68,500 is due and payable to the petitioner. So that time, that figure is still, my lord, it appears from, my lord, paragraph number 5. Paragraph number 5, the two figures. Now, my lord, after adding the two figures, my lord, it comes to 9,68,500. Paragraph number 5.
No. There are
Arey bhai.
two separate tier challan, my lord. One
Yes,
is
I am
4
not
lakh
on
40,500.
The total amount.
Total amount is 13 lakh and odd amount.
বলতে না দেন তাহলে writ petition
Yes. বলুন।
Now, my lord, this entire thing was the subject matter in the earlier writ petition as it is disclosed right now. And in order dated 2nd September 2021, the writ petition was dismissed. But with a direction in view of the matter, writ petition dismissed with liberty reserved the petitioner to have his claim decided by of arbitration.
Right.
Now, my learned friend just now, because nothing has been disclosed here, and it was not my knowledge also. Now, my learned friend, my lord, disclosed that yes, my lord, the proceeding started on the basis of this. So, on the basis of this, my lord, arbitration proceeding or alternative relief, my lord, the methodology has been proceeded with.
It has started.
He said that I have to
No.
because
It has not been initiated.
It was not in my knowledge. Had it been in my knowledge,
So when do you want to come back, Mr. Sen?
my lord, next week.
No.
I think, my lord, within
Next Monday, my lord.
next Monday. My lord, Wednesday or Thursday.
Lord, Wednesday,
Let me have it
Thursday
in instruction.
will be too
You
late.
take instruction. Do you have a good entire week? Today we are on 12th. Today we are on Tuesday. 1 week is Monday. Learned counsel for the petitioner submits that in view of the claim of security amount of the petitioner being admitted by the respondents, the amount be directed to be disbursed in favor of the petitioner. Full stop. Next para. That counsel for the state seeks to take instruction since, as apparent from a copy of an order dated September 2, 2021, passed in WPA 6061 of 2020, handed over by the petitioner himself today at the time of hearing, it transpires that a previous writ petition for similar relief was rejected with liberty to the petitioner to go for arbitration. Full stop. Next para. Learned counsel for the state seeks additional instructions on whether the arbitration proceeding took place and on the issue of alleged admission. Full stop. Next para. Accordingly, on the prayer of the state, let the matter stand adjourned till December 2023, when it will be listed under the same heading.
Milord,
Affidavit of service filed.
Milord, one thing, Milord, from 21 to 21 and onwards, Milord, I will be not in Kolkata, Milord.
21 onwards.
Onwards.
20. Fixed on 20.
Yes, fixed on 20 is grateful. Grateful, Milord.
Thank you.
Any mentioning on the original side? Item number 1.
Yes.
My lord, I feel like a schoolboy who's being taught by competent professors, my lord. Graduating every day, my lord, from NPA, then to, my lord, willful defaulter, now, my lord, fraud. But it's like I'm being taken through lessons in, my lord, school or college.
Traversing the entire gradient.
Part 23 shows.
Now, my lord, this is challenging, my lord, declaration of fraud, order passed. My lord, your lordship will find it, number one, it's contrary to an order by the Supreme Court. Also contrary to your lordship's order, no hearing given, despite asking for a hearing. And, my lord, no reasons of any kind, besides the fact that, my lord, the show cause notice itself, but has nothing. Page 123, my lord, if your lordship would come to.
Yes.
show cause notice for declaring as fraud. Not first two paras are formal, then not the third para. Recently, a forensic audit, transaction audit investigation.
Yes.
So recently, a forensic audit, transaction audit, internal investigation was conducted on the loan account, wherein now let's see the element of fraud is identifiable. It can't get more vague than this. However, before coming to a conclusion in the matter on the basis of the forensic audit transaction report, so on the basis, please mark this on the basis of this report, you are hereby given an opportunity to furnish your representation within 21 days as to why it should not be declared classified as a fraud. So that's all that there is. Now, I'll just tell your lordship that this forensic audit report, etc., is fairly old and it actually finds that there is no fraud. I'll show that if required, but not necessary. Now, along with this is an attachment on the next page. Synopsis, not see the heading. Synopsis of conclusion of special transaction audit report. Now, your lordship can take it from me, not that it's material. The conclusion of the special audit report is certainly not this. But it, in any case, over here, your lordship sees, Milord, the vaguest of all allegations. No property mentioned, no account mentioned, says valuation of property transferred and comparison of the sale value of property to ascertain whether it has been transferred at a lower price. Now here, I've given a reply saying there has been no property sold at all. Not dealt with, nothing. Similar with all the rest, these are vague. I need not trouble your lordship. I give a reply at 125, very detailed reply with annexures and everything. I'm not troubling your lordship. Now, Milord, your lordship comes to, Milord, only thing is, Milord, if your lordship comes to page 134, in the reply I say, please give me a personal hearing. Page 134, at the end of that, I say, give me a personal hearing. Yeah. Lord, now, Milord, if your lordship comes to page 380, Milord, that's the no hearing given, nothing happens. And please see, Milord. Now, your lordship will find that the entire show cause notice is on the basis of a transaction report.
Yes.
A special audit report. There's no reference to it at all over here. Nothing. We refer to the show cause notice issued by us. We have taken cognizance of your response and other due examination of the same. It is concluded that sufficient reasons have not been provided by you to explain non-adherence to the agreed terms and conditions of loan document. That was not even a blood allegation there. Non-adherence to loan document is not even an allegation there. Or irregularities observed in the conduct of your account to the satisfaction of the bank. Accordingly, the bank has decided to classify your account as fraud for the following reasons. A, diversion of funds by not depositing. Now, that was not an allegation there. B and C, disposed of primary security and diverted funds. Now, these were not even allegations over there. And no reasons, no hearing. There's nothing to this.
Hearing, personal hearing was not given, but a representation was taken.
My lord, yes, representation was
necessarily be given a personal hearing, Mr.
No, now, my lord, that part is
taken. Your representation was detailed that had to be reflected in their order.
Nothing, right? And now, my lord, the Supreme Court has said that a personal hearing has to be read into.
Please cite that.
Yes. You have? Okay.
Obviously, he must be having. He's the worst sufferer. I mean, they are the worst sufferers.
But the same para to 81 of it now. But please take para 98, which is. It's first 79 এখানে ওটা কোনটা দেখি একবার 79 in light of কোথায় in light of কোর একটা প্যারা আছে
light of the legal position noted above
প্যারাটা বলো
95
because but please take para 95. I'm reading from a different copy. In light of the legal position noted above, we hold that the rule of audi alteram partem ought to be read into 8.9.4 and 8.9.5 of the Master Directions on Fraud. Consistent with the rules of natural justice, lender banks should provide an opportunity to a borrower by furnishing a copy of the audit reports and allow the borrower a reasonable opportunity to submit a representation before classifying it as fraud. A reasoned order has to be issued on the objections addressed by the borrower.
Right
Now-
of representation here, not personal here.
No, I'll show your lordship. I'm not, please take it from me. If I've said so, I won't mislead your lordship.
Definitely.
A reasoned order has to be issued on the objections addressed. So, reasoned order on perusal of the facts, it is indubitable that the lender banks did not provide an opportunity of hearing to the borrowers before classifying the account as fraud. Therefore, the impugned decision to classify the borrower account as fraud is vitiated by failure to observe the rules of audio alteram partem in the present batch of appeals. This court passed an ad interim order restraining the lender banks from taking any precipitate action. In pursuance of the aforesaid reasoning, we hold that the decision to classify the borrower accounts as fraud is violative of the principles of natural justice. Bank would be at liberty to take fresh steps. Now, let please see the conclusions.
Yes.
91.1, no opportunity of, that will be para 98. And no opportunity of being heard is required before an FIR is lodged and registered. That's the later stage.
Yes.
Classification of an account as fraud not only results in reporting crime in investigating agencies, but also has other penal and civil consequences. 3. Debarring the borrowers from accessing institutional finance under 8.12.1 on frauds results in civil consequences. Now, 4. Such a debarment under 8.12.1 is akin to blacklisting the borrowers for being untrustworthy and unworthy of credit by banks. This court has consistently held that an opportunity of hearing be provided before person is blacklisted. Then, let's see. The application of audio alteram partem cannot be impliedly excluded under the master direction on fraud. In view of the time frame contemplated under master direction on fraud, as well as the nature of procedure adopted, it is reasonable.
So 98.4 till 98.7, opportunity of hearing has been reiterated.
And then, provide an opportunity of hearing to the borrowers before classifying.
In all these clauses, yes. Somewhere or the other, opportunity of hearing has been.
Yes, ma'am. So, that opportunity of hearing has to be there. Now, one question arose in relation to this. One of the banks applied for a review, saying that this should at least operate prospectively. So, that review application is pending. That's about the only thing I know. And yes, ours is subsequent.
In your case, that is not.
I'm not. Yeah. And then, there's an order passed by your lordship.
Mr. Bordhan has copies of all judges' orders so that those can be cited.
By name, I don't know, what kind of software he has got.
He searches by the names of the judges. Immediately before the matter is taken up, he searches by the name of the judges and finds out matter.
But there'll be so many, I don't believe he reads all of them. But it's something more than artificial intelligence, I believe.
Maybe natural intelligence.
That's what I said.
Yes.
Now, your lordship will see again, same circular.
Yes. That audio alteram partem.
And your lordship has said,
yes,
set it aside on the same ground.
This is more cryptic. Supreme Court is elaborate.
Yes. But para 5, your lordship has said hearing is necessary.
Audio alteram partem. Yes, right. Yeah.
Para 4 and 5, your lordship has considered the Supreme Court, perhaps.
Not given a problem.
There are other factors I don't need to get into.
Let him deal with these factors first. Yes.
Very few things I will submit. Kindly state judgment, my land statement shows.
Please just take the microphone closer to you.
Hello. Kindly come to the same judgment.
Yes.
Para 29.
29, right?
And my lord, kindly come to the guideline of the RBI in 8.8.
Para 8.8.
No, the guideline 8.8, clause 8.8 of the RBI guideline.
Where is
they have annexed. It's in page number, my lord, page number 403. Starting from 382 and it's 403. Very few things to submit, my lord.
Yes.
May I read, my lord? In cases where the bank is a sole lender, the FMG will take a call on whether an account in which EWS are observed should be classified as a RFA or not. The exercise should be completed as soon as possible. And in any way,
case within a month of the EWS being noticed. In case of account is classified as RFA, the FMG will stipulate the nature and level of further investigations or remedial measures necessary to protect the bank interest within a stipulated time, which cannot be exceed 6 months. Now, let's come to the observations of the apex court. That is in paragraph 29, page 25 of the judgment.
Yes.
Malad, clause 8.8 deals with the situations where a bank is a sole lender, in which situations of FMG is entrusted with the responsibility to take a call on whether a bank account in which EWS are observed should be classified as RFA. The bank is permitted to use external auditors. External auditors, my lord, kindly take this word, external auditors, before taking a final call on RFA status. However, within 6 months, the bank is required to either lift the RFA status or classify the account as fraud in accordance with the investigation or forensic audit. Now, my lord, come to our so-called notice. Bank so-called notice.
Yes.
That is in page 123. My lord, same, the third paragraph. For recently, my lord, kindly take this word also. Recently, the so-called notice sent on 38/2023, and it said recently a forensic audit transaction audit report was conducted and the loan account wherein the element of fraud identifiable, so and so, so and so. Now, my lord, the last line, it was said that in case nothing is heard from your end within the stipulated period, bank will proceed in the matter as you have nothing to submit, which may please be noted. Now, my lord, enclosed as stated above, there is no enclosure, collective enclosure in this particular so-called notice. They are showing there in their reply, they have said that kindly refer to forensic audit report dated 8/3/2019.
No, subsequently they
My
asked
lord,
for
my
that
lord,
copy.
Yes. My lord.
They asked for that copy subsequently.
What?
Probably they asked for that copy subsequently.
Recent copy. They have asked for the recent copy. My lord, in this particular part, my lord, I kindly request your lordship to grant me 3 days time so that I'll file a report in form of affidavit. So that everything will...
No question of that. If you have not complied with at the relevant point of time, I'll have to relegate it back. You say no copy of the audit report was given along with this?
No, my lord.
But what is the enclosure as stated?
That is different thing. My lord, I am saying...
What was enclosed here? Because an enclosure has been referred to at the bottom.
What was enclosed there, I don't got the instruction from the bank. That's why I'm asking, my lord, kindly, this is a request. Grant me 3 days, 2 days time, my lord, so that I can file a report in form of affidavit.
No, you cannot.
They can go for external audit report. They are showing an escapist audit report. I am not on that.
They have to be given a hearing. Where has the hearing been given?
My lord, that is subsequent. My lord,
Supreme Court judgment says
come to that judgment only. My lord, in paragraph 66. My lord, the bank is following the guideline of RBI. It's a apex court judgment, mostly in June 2023.
So apex court judgment is not binding, but RBI is
no,
binding.
No. My lord, I'm not saying that. My lord, come to that particular paragraph. What I'm relying, my lord. Paragraph 66. RBI and the lender bank have contended that the master direction on fraud impliedly exclude the right to be heard.
Which was turned down.
No. You turned down here. I'm accepting.
Supreme Court.
As per their version, it was turned down here.
What
now,
is as per your version?
I'll not going the enter sort of the paragraph. My lord, last paragraph, my lord. My lord, can you come to the last paragraph? 98.7.
Yes.
Since the master direction on fraud do not expressly provide an opportunity of hearing to the borrowers before classifying their account as fraud, area altering pattern has to be read into the provision of the directions to save them from the vice of arbitrariness.
What is area altering pattern?
Right of hearing. Right to.
So what are you trying to impress upon?
My lord, I'm just requesting. My lord, kindly take RBI as a party in this case so that it can be clarified.
Why not the President of India? But no. I'll set it aside.
Let my lord give me one opportunity to file a
No, what opportunity?
My lord, one.
I'll record that you have asked for that opportunity. Why I have refused, I'll give me.
My lord, one opportunity, my lord, to file
No. Learned Council, yes.
2 days only.
No.
My lord, kindly.
No, what is
2
this?
days only, my lord.
The sort of Mahabharata Rabdar or something?
No, not like that.
2 days, what is happening? I mean, this should go right now.
But only one thing I'll point out, since my learned friend takes that, page 125. In the first paragraph of my reply, I say that he has given me that audit report.
Yes, but he actually did not.
Oh, he's saying he actually did not.
Did not. Learned Senior Counsel for the petitioner contends that the petitioner's account has been declared to be a fraud purportedly in terms of the governing master circular of the RBI, comma, in gross violation of the provisions of the same. Full stop, next para. It is submitted that despite the petitioner having specifically asked for a personal hearing, comma, the same was not granted to the petitioner. Full stop, that apart, comma, the petitioner took several objections in its written response to the show cause notice by the bank, comma, none of which issues were adverted to by the respondent authorities while passing the impugned declaration. Push up, next para. It is argued that a purported forensic audit report was relied on by the bank while passing the impugned declaration, comma, which did not contain any ingredient sufficient to label the petitioner's account as fraud. Push up, next para. That apart, comma, it is argued that the impugned declaration is palpably cryptic and does not contain any iota of reasons whatsoever. Push up, next para. Learned Senior Counsel appearing for the petitioner places reliance on State Bank of India and others versus Rajesh Agarwal and others reported at 2023 6 SCC 1 in support of the proposition that a right of personal hearing as enshrined in the principle of odi alteram partem has to be read into the concerned master direction on frauds issued by the RBI. Push up, next para. In the present case, comma, such hearing having not been given by the respondents, comma, the impugned declaration is required to be set aside on such score alone. Push up, next para. Learned Senior Counsel also cites judgment of this court dated October 17, 2023, passed in WPA 21123 of 2023 on the same proposition. Full stop, next para. Learned Counsel for the bank seeks to impress upon the court by placing reliance on paragraph number 29 of the judgment of the Supreme Court cited by the petitioner that the bank is permitted to use external auditors before taking a final call on RFA status, RFA block A. However, within 6 months, the bank is required to either lift the RFA status or classify the account as fraud in accordance with the investigation or forensic audits. Push up, Learned Counsel also relies on the concerned provisions of the master directions, comma, in particular clause 8.8 of the same to highlight the time constraint of an outer limit of 6 months, highlight the time constraint of the outer limit of 6 months for deciding on such issue. Push up, thus, comma, it is argued that the bank acted well within its authority under the master direction to declare the petitioner's account as fraud. Pushed up, next para. Bare perusal of the impugned declaration dated November 28, 2023 shows that the same is as cryptic as possible. Pushed up, the by the said order, comma, it was observed that the response of the petitioner to the show cause notice was taken cognizance of and within double inverted after due examination of the same double inverted clause, comma, it is concluded that sufficient reason have not been provided by the petitioner to explain the non-adherence to the agreed terms and conditions of the loan documents or the irregularities observed in the conduct of the petitioner apostrophe's account to the satisfaction of the bank. Full stop. Not only was non-adherence to the purported agreed terms and conditions of the loan document not a ground in the show cause notice, comma, no detail whatsoever as to the purported irregularities on the part of the petitioner finds place in the said order. Full stop. Next para. Even in the show cause notice, comma, it is found that sole reliance has been placed on a forensic audit report, the excerpts of which, comma, which appear from the documents annexed to the writ petition, clearly indicates that even the said report does not indict the petitioner on the high pedestal required to declare the petitioner's account as fraud under the concerned master directions. Full stop. Next para. The Supreme Court, comma, in Rajesh Agarwal's case clearly observed that the provisions of audio alternative partem have to be read into the provisions of the master directions on frauds by giving an opportunity of hearing to the borrowers before classifying their account as fraud. Pushed up in the present case, comma, the said condition has been blatantly violated as well. Pushed up next para. In view of the above considerations, আরেকটা line add করি। Learned counsel for the bank, comma, during arguments, comma, seeks 2 days time to file a report disclosing relevant facts. Full stop. Next para. However, comma, it is well settled that in the event originally sufficient grounds were not disclosed for passing an adverse or penal order against the petitioner, comma, subsequently the respondents cannot furnish such further reasons in order to support its original decision. Full stop. In the present case, comma, as observed above, comma, the classification of the petitioner's account as fraud is not in consonance with the master directions and is palpably violative of the principles of natural justice. Full stop. Hence, comma, no report or other document which can be filed by the bank at this juncture could improve the bank apostrophe's case as it stood on the date of the impugned order. Full stop. In such view of the matter, comma, such adjournment is refused to the bank. Full stop. In view of the above observations, comma, WPO 1839 of 2023 is allowed on contest, comma, thereby setting aside the declaration of the petitioner's account as fraud under the concerned master directions of the RBI, comma, dated November 28, 2023, as annexed at page 380 of the writ petition. Full stop. Next para. However, comma, the bank will be, the respondents will be at liberty to give a fresh hearing to the petitioner on the show cause notice already issued to the petitioners, and upon giving such opportunity of hearing to the petitioner, comma, take a fresh decision in accordance with law and upon furnishing appropriate reasons as regards whether the petitioner's account should be declared to be a fraud under the master directions of the RBI. No address to cause.
But two further things. But as far as the notice is concerned, but we have a but one of the grounds is that the notice is without jurisdiction issued by the wrong authority. So please leave that not open. I'll show you, Lordship. Master circular says that if it is over a certain amount, 1 crore, then the relevant authority for that is someone else. I'll show. It's a special committee that would be at page 385. Just leave that point open, Lord. Page 385, the Lordship comes to
385. Yes.
Clause 2.1.2 read with not the 2. Fraud risk management monitoring investigation must be owned by the company's CEO Audit Committee and Special Committee of the Board. Now, my lord, Lordship, my lord, comes to play clause
4.4 at
391, clause 4.4.1. While the Audit Committee of the Board shall monitor all cases of fraud in general, banks are required to constitute a special committee of the Board for monitoring and follow-up of the cases of frauds involving amounts of rupees 10 million and above exclusively. Special committee is to be constituted with 5 members of the Board of Directors consisting of MD and CEO, etc., etc.
What is the concerned amount
Now,
here?
my
More
lord,
than
here-
10 million?
Yes.
And it does not comprise of this board of directors?
No, not it's issued by the manager, a zonal manager.
It's a zonal manager, my lord. It's in 6.2.
Then I'll set aside the entire thing and direct you to give a...
My lord, kindly have a look. Just have a look, my lord. It's the same guideline 6.2. 6.2. It's in the same guideline. So 6.1.
6.1 হবে আপনার।
6.1.
Page 395.
My lord, page 395.
Yes.
If it is not considerable, we can do whatever your lordship directs. It's
it doesn't change
number
the
2,
authority.
0.
For the purpose of investigation.
Investigation, right.
আচ্ছা একটু আসুন একটু শেষটা একবার শেষ সেন্টেন্সটা প্লিজ একবার পড়ে দিন
কি বলবো
ওই যে ওই এইখান থেকে কেটে দিন এখানে হাউএভার থেকে কেটে দিন আর তার আগেটা কি বলেছি একটু একটু আরেকবার পড়ে দিন হাউএভার থেকে তো কাটবেনই ওটা এখনই কেটে দিন স্টপ তারপর থেকে 380 830 না 380 হ্যাঁ 830 তো নেই হতো 380 আর তারপরেরটা সেন্টেন্স এবার আমি যেটা বলছি সেটা করুন the show cause notice
Page
on the
123.
pardon page
123.
The show cause notice dated August 30, 2023, annexed at page 123 of the writ petition, comma, on the basis of which the said order was passed, is also set aside, comma, in view of being in contravention of
4.1.
clause 4.4.1 of the concerned master direction of the RBI. Full stop, next para. However, comma, nothing in this order shall prevent the respondent authorities from issuing a fresh show cause notice adhering to the concerned provisions of the adhering to the governing provisions of the master directions afresh. Full stop, if such a notice na ar kichu hoto if kete de bas this one
And the second thing which I was saying,
Yes.
not action, if any, taken by them pursuant to these
article add
notices.
করে দিন if any action has been taken in the meantime pursuant to and in terms of the impugned classification of the petitioner's account as fraud stands hereby automatically revoked and reversed. Next.
Item number 2 and 3.
But this one I'll take not only 2 minutes because it's covered, not well, either covered or not covered by your lordship's order. There is one difference between the two. It's a different company. Otherwise, facts are similar. Now, my lord, in your lordship's earlier order, your lordship had rejected many of the points taken by us, but allowed it on 2 grounds. Set aside the notice on 2 grounds. One does not apply to me. That not it was there was a scheme operating and all of that, not before the not NCLT. That does not apply in this case.
This is also fraud
No.
willful default.
This is willful default.
Willful
default. So, my lord, But in that case, that ground is not available to me. But what is available, my lord, is not paragraphs 35. Copy the. Actually, not identical cases, not people involved were the same, but a different company was in question. And your lordship had asked. Now, my lord, your lordship will remember during the pendency of the writ petition, they came up with the order of the review committee. Now, review committee order came, so we filed a second writ petition in both cases to take into account that. So in that case, my lord, your lordship had set it aside. Now, my lord, para 35, this is one of the grounds on which it was set aside. That applies squarely over here. However, the illegality of the RC order lies elsewhere. Clause 3C of the circular stipulates that the RC must be headed by the chairman and managing director or managing director and CEO, and consisting in addition of 2 independent directors, non-executive directors of the bank. In the present case, however, the order of the RC was not only communicated on 27 December by the zonal head, the order of the RC itself, dated 12 September, was signed solely by the zonal head, Kolkata zone of the UCO Bank. Although within parentheses it was written that the order was on behalf of the RC of willful defaulters, mere mention of the same does not bring the order within the purview of the master circular. Nothing in this master circular empowers the RC to delegate its authority to the zonal head of the concerned bank. In the present case, the order was admittedly signed only by the zonal head, who is in no way qualified to comprise of the RC within the contemplation of the master circular. Thus, such illegality hits at the very root of the order and renders the same a nullity, being palpably without jurisdiction, hence on such ground alone. But this applies squarely identical on this. But the other grounds, I tell your lordship, there is also one other small difference over here. Lord, they acted on a basis which was not there. But then, Lord, if I succeed on this, I need not go on that point, Lord.
Yes, what do you say?
There's 2 orders, my lord, which have been challenged. One is the identification committee order, and the second is the review committee order.
Lord, just one sentence, if I may add, I'm very sorry. But there is another point, Lord, like in the other one, your lordship will leave that open if I succeed on this point.
What is that point?
Lord, I tell your lordship, they have proceeded on the basis of possibly not. I'll show your lordship the notice.
First, application 165.
So please take 165 of the first writ petition. From each.
157 Street.
And I have taken the wrong one. Automatically, keep in mind, mix up.
157 show cause.
Yes. Now, please take page 36. This is the show cause notice. Yes. Now, before that, they set out the RBI circular. Please comes to page 37.
Yes.
So, there are 2 allegations. Diversion. Please see explanation. From there is the notice. The acts of the company's directors and personal guarantors coming under the purview of RBI guidelines of identifying willful defaulters are diversion, siphoning of funds. 1. End use of PC advances could not be ascertained. All disbursed PCs are either gone to their sister concern, Ratanpur, or Greenview Commercial. And B. Not the next one, disposing of assets. No stock was available with the company. No stock was available with the company. Stocks were disposed of without the key any credit proceeds with the bank account. Now, my lord, I give an explanation, which is not a detailed explanation starting from page 40. And my lord, if your lordship then comes to the order, I'll just take out my mix up the volume 1 to the But please take page.
This is the first one. So you need the second one, sir. 1729.
ঠিক আছে তো এটা now my lord please come এটাই তো so please turn to page 172 কোনটা নিয়েছি
এটা তো
yes
so this is the one, sir.
but rather my lord please come to page 170 171
So this is the one, sir.
yeah. The one I have too.
So this is the one, sir.
ভুল ধরেছি কোন জায়গাটা বল I'm sorry, I'm very sorry.
No, no, sir.
I've mixed up 3 briefs, all in the same yellow blood file. Right.
ठीक है 12 में so this is the orders observations will come.
এটা কোথায় fixed assetটা now my lord please see page 183. Now I have given detailed reasons saying that these were spoilable stock lying there for long years. Now no stock was available with the company. Stocks were disposed of without taking prior permission from our bank. Above instance of irregularities under so and so.
So this is one page
183
of the other writ petition.
Yes, 1729.
The order is common.
Yes.
That was a
So it
willful
went to
defaulter. This is the review committee.
Lord review committee. Your lord,
Review committee.
during the Lord hearing, Lord they asked for adjournments and then the review committee came in between. So Lord we filed a second writ petition now on the review committee arising out of the same.
No, the first point you took was regarding the review committee constitution.
Lord,
The first point you took was
Yes,
regarding the review committee
constitution.
constitution.
That's the first
If
point.
that is upheld, then the review committee order goes on
Yes.
that ground, on
Yes,
the ground
yes,
of.
that's good enough. That's good enough for me.
Yes.
But
And
I
this is
pointed
also
out-
the review committee order on merits you are not serving.
Yes.
Yes.
Now, my lord, please turn to clause 2. Lord, where they set out clause 2.1.3
Yes.
D of the master circular.
Yes.
The unit has defaulted in meeting its payment repayment obligations to the lender and has disposed of and or removed movable fixed assets or immovable property given for the purpose of securing a term loan without the knowledge of the lender. Now, my lord, your lordship has seen the notice. The allegation, my lord,
Stock and PC.
was stock. Stock, my lord, is not.
A fixed asset.
Stock is not a fixed asset. So, my lord, I've been knocked out on a ground which was not there.
This is about the review committee, but the willful default, the first committee remains.
It's the same. It's the same order. They have just picked it up and put it here. Your lordship will remember from the last matter. Lord, I tell you, Lord.
No, review committee constitution cannot pertain to the willful defaulter first committee. That first ground does not pertain to the first.
No.
So you are not challenging the willful defaulter order also, the first committee order.
We had.
What is the ground?
Page 170.
This comes to page
Sir, this is 1573, page 170.
170.
In the second writ petition.
First writ petition. 157.
That's 1.
First writ petition is
Identification committee. Committee observed as under.
This takes 170 minutes.
Yes.
The committee observed as under entire block of fixed assets having a net block of so and so being written now without any justification in documentary. It's T stock that they were referring to. That's not fixed asset.
Was stock and PC. Packing credit. Final order comes up.
Your lordship has seen the
stock was mentioned in this show
show
cause.
cause. Please takes the show cause, my lord.
Yes.
Please turns to page 37.
Right. Stocks.
Stocks and PC. Packing credit.
Stocks and packing credit.
PCs, yes.
But from what I've seen, not got very limited experience, but complete not non-application of mine. They probably have a format They just copy from it and put it in. And then Lord, no hearing is given. The same thing is not what is in the notice is set out in the hearing notice, and the review committee does that. But not it's too mechanical, not
Stocks and inventories are current assets, never fixed assets.
no. Well,
Not zero. It not zero. It need to be.
but these are the two small points, not which we have in this one. It's no point, Lord, I'm not arguing any other point because your lordship in the other matter has turned down or said, look, these can't be gone into a writ petition. But Lord, I thought that I'm fully covered by your lordship's order in the earlier one with regard
That is
to
only regarding the review committee order,
review committee.
not the first committee.
That order does not become final till a review committee order.
True, then, no, then I have to relegate to the, even if you win there, I have to relegate to the review committee stage then.
No. The identification committee.
First committee remains then.
But please see.
Identification committee's order suffers from the
Please.
same problem.
But please come to page.
Mr. Naik is getting perplexed.
I'm sorry, Lord.
Mr. Naik is getting perplexed.
No, Lord. The first point, he has no answer, and possibly the second point. And I tell you, Lordship,
If it does not have an answer in the first point, Mr. Bachao, then it has to go back to the review committee stage.
It may not. I'll tell you, Lordship,
Yes.
why? Because
Is
not
order the identification.
the Lord, allegation your Lordship will make. Remember, in the other one, your Lordship didn't have to go into it, but that the review committee has simply rubber stamped the findings. There's nothing new over there. There's nothing added over there. And Lord, I had pointed out that the order of the Lord identification Lord committee also Lord suffers faults.
So on that, the first committee and the review committee on merits, the stocks were mentioned in the show cause, but fixed assets.
Yes, fixed asset.
Well,
that's all I need to. এই কোনটা তোমার
Yes.
এটা তোমার এবার আমার বিলগুলো ঠিক করি
Ask him.
সব বলি
Ask Mr. Bardhan whether Mr. Bachauth is over.
Absolutely, একবার জিজ্ঞেস করে নাও। Lord, remote control.
No, definitely not.
And remote
Yes.
control.
Yes. Sir.
So there are two aspects. It's a two-pronged system. There's an identification committee order, whether by way of the willful defaulter making an application for a review, or otherwise they would have to be confirmed by the review committee. So no doubts about that. So there is an identification committee order which is passed during the pendency of the writ application because they don't move the review committee. We have to have that order confirmed. We by ourselves go before the review committee.
That other point remains that the review committee, there was no option for the review committee but to copy paste.
But to copy paste.
Because they have not given any further.
Because they haven't given any other set of facts to us in order to disprove whatever were the findings of the identification committee. But I'll come to that bit later, my lord. Would kindly consider the
In
first.
previous matter, it was relegated to the RC stage. The review
No, it was also the identification committee order was set aside on the ground that the directors were absolved because of the approval of the resolution plan.
All right.
So even so,
Which is not available here.
Which is not available here. In the other case, the proceeding had started prior to the approval.
Yes,
but because
Mr. Bachauth
during-
said that. In fact.
So that point is not available to them. So I'll take the first, I'll start with the higher committee first, which is the review committee. So the first point taken by Mr. Bachauth, which on the face of it, I'll be very candid, seems like a very plausible point,
Yes.
that the constitution, the quorum of the committee is otherwise prescribed under the master circular, and that has not been complied with.
Right.
With respect to that, my lord, I'll submit on instructions that, my lord, the order which is a part of the second writ application, my lord, which is undersigned as zonal head Kolkata zone. This does not give out the details of the quorum, as rightly pointed out by Mr. Bachauth. This is 193 of, my lord, 1729. It's in 2 volumes.
Second volume.
I'm referring to the
1729 is the review committee challenge.
Is the review committee challenge.
Yes.
So this is volume 2, my lord. Lordship kindly takes up the last page of that writ application, my lord, volume 2. Lordship looks at the bottom of the page, zonal head Kolkata zone.
193.
184.
184. I'm sorry, my lord. No, I'm not 193.
No, this is writ petition number 1729.
1729.
Yes.
Because I think there were
184 for one small, 184.
It's a
Yes, 184 in my.
the copy that I have is a differently paginated copy.
But
That
zonal
would be
head.
attributable to them.
Absolutely.
So if your Lordship looks at the bottom of the page, my lord, zonal head,
Right.
Kolkata zone on behalf of the review committee of willful defaulters. So my response to this on instruction is that the order which is impugned here, the review committee order, is not passed by the zonal head. So there is no question of this work being delegated. It's only the conveyance of that order,
Communication.
the
yes.
communication of
Took this
that
point in the last matter also.
possibly not, possibly.
Vividly remember.
Then I'll
I rarely remember something, but this is one of the matters which I remember.
So this in that
But
case
no,
I'll
that was
treat
an impromptu argument probably. That was not on instruction. This time it's on instruction.
This time it's on instruction.
Very.
But this is a communication of the order. This is not because they refer to the other judgment passed by your lordship, which refers to the point of delegation. So there is no delegation that's happening. Delegation otherwise is impermissible under the master
I get
circular.
your point. Yes.
So this is a
That
communication.
point, right.
This is with respect to that point. I
What
understand.
about stocks and these?
Which is
of stocks and fixed assets.
So before I go to that point, my lord, with respect to the show cause notice and the order pass, so I say this today, if your lordship is satisfied with my point with this one, because I'm not making an express concession of fact. So with respect to this, if your lordship is satisfied, then there's no question of an interface. But if your lordship is not satisfied, then with apropos this point, the review committee order has to go, and then this gets relegated back to the review committee. Now, with respect to the challenge to the order of the identification committee, at the very threshold with respect to the order is concerned, I would renew whatever I'd argued on the previous occasion, that when they're before a writ court, the writ court cannot replace the reasonings which is given. They cannot. There's a show.
The variation between show cause.
I'll show that. I'll
that is a relevant point.
I will indicate that. Lordship kindly takes up page number 36 of the first writ application, which is the show cause notice, 1573 of 2020.
Yes.
36 is the show cause notice, 23rd of February 2022.
Right.
This show cause notice holds good. Lordship kindly turns over to the next page, page 37. Lordship looks at the second paragraph from the top, which starts with small d. The unit has defaulted in meeting its payment, repayment obligations to the lender and has also disposed of or removed the movable fixed assets or immovable property given for the purpose of securing a term loan without the knowledge of the bank lender.
Very. So this goes into that reasoning.
That's the circular. That what he's reading is
yes.
That is not the allegation.
No. Mr. Bachawat is right.
Your allegation starts from explanation.
With explanation, yes. Mr. Bachawat is right. I apologize, Mora. That is not. She will kindly give me one moment.
Absolutely. It should actually go from the show cause stage, Mr. Nayak. It's a very cryptic show cause. I mean, nothing is disclosed here. They have to defend themselves meaningfully.
They have already assailed the identification committee order once. The identification committee order has already gone once. And at that stage, they had the liberty to challenge the show cause notice. That order was passed by your lordship, setting aside the identification committee order, which is why it goes back and the inception then happens from the stage of show cause. Whereas the show cause remains. This show cause has already stood that test once. But in my understanding, my lord, if once there's a reference to the clauses of the master circular, then it would have to necessarily be deemed that these allegations have already been made against them. No, I say this. There is a reference. All the clauses of the master circular have not been referred to in the show cause. But if your lordship looks at the paragraph that I showed, serial number D, these have been referred to. 2.13D of the RBI master circular, which reads as follows. So I don't have to give an explicit, because the purpose of the committee would be to arrive at a finding, which cannot be preempted at the show cause stage. So I can broadly give, I understand possibly on slippery territory, but I say this.
Slippery?
Territory, well, I understand.
You are on no territory at all. It's fluid.
That in my understanding, and I submit this with some amount of
definitely not in your understanding, in your argument.
In my argument, my lord, I would be required to give only the allegations apropos what are the clauses of the master circular that I seek to invoke by way of the show cause.
Like a file and eviction suit, I say that this section 6 contains the provision that if there is reasonable requirement, you should go. And therefore, that has to be there. That I say that in my plaint. Section 6 says this of premises tenancy act.
But this
And
would,
therefore, that will be constituted to be my pleading that I also have reasonable requirement and you should also go.
but this would be in the nature of a 106 notice under the TP Act, not in the nature of a plaint, because I don't have to give out all grounds in that to take that example forward. I don't. She will not be umbraged by that. But
which is the plaint in this exercise? If this is the 106 notice,
plaint, my lord, in this proceeding, my lord, it would not be a separate.
If this was the 106 notice, taking your analogy,
yes,
what would be the plaint in this proceeding?
I will say that their response would be the written statement, but there would not have to be a separate. I'll be very.
It is given to.
I understand, my lord. I understand the difficulty, but I'll be very candid, my lord. This would in my respectful submission, my lord, I'm not required to give out the exact nature of the default. I'm required to give what are the clauses under which I'm making the allegation. I have done that. I've also done that. I've also said that the acts of the company and its directors. So Bachaw's already pointed this out.
Mr. Naik, you have a point there that show cause notice was never challenged in the previous challenge. But it would be wiser probably. I don't need to advise you and I should not. I'm not. But it would be wiser on your part to renew the effort from the show cause notice stage. That would be better for you because on this show cause, every time you pass an order, there will be some difficulty. Anyway, I'll not.
No, I understand what is.
So I'll just set aside the willful defaulter order and the review committee, not the show cause.
Look, there would have to be certain improprieties to. I understand the difficulty.
Certain impropriety. What are you meaning by that? What is the propriety? There is no propriety at all in the order. I mean, stocks and all PCs and.
But if your lordship looks at lordship kindly gives me one moment.
Yes,
1 moment.
But whatever you say, give me 10 minutes time to pass the order.
Definitely.
Not even 10 minutes.
Okay. The other aspect, my lord, would kindly take up 172 of my of their application once, my lord, of the same writ petition.
172.
Lordship kindly looks at the box, my lord, serial number 1, 2, and 3.
Yes.
Lordship looks at the right-hand column of the box.
Hmm.
Lordship looks at the second two serial numbers, which are the two petitioners. Amongst the other clauses of the master circular under which the declaration has happened, 2.6 is also one of them. 2.6 is for invocation of the master circular in the capacity of a guarantor. The requirement for 2.6 is that there would have to be a demand. Based on that demand, you fail to pay the money. And then because of that, there'll be a declaration under 2.6 as willful defaulter.
But the parent act has to be there. The parent default has to be there. The guarantors have additional layers of protection on that.
No, under 2.
It's the other way around. It's against you. Guarantors have additional sheets of protection.
2.6, my lord, the threshold is non-payment of money.
Yes.
So they have failed. So I'm saying even if this, without conceding, of course, even if I go on to say that with respect to the show cause notice and the findings, there may have been
failed to establish the main default of the borrower and the guarantor is on a worse footing. I mean, guarantor, everything follows for the guarantor also. Guarantor has all those points and more.
They do. But I say this today, the threshold of what is a willful default in the case of a borrower is slightly different from what is it under 2.6.
Yes.
So 2.6, the threshold.
The default has to be there. If a default is there, borrower goes, guarantor also goes. But for guarantor to go, in addition, guarantor has a sheet of protection. In that, you have to establish that an opportunity was given to the guarantor. He has failed. Despite having means.
With the deepest of respect, in my understanding, under 2.6, the definition of a default would only relate to the refusal of the personal guarantor to repay the money and not otherwise. So when it comes to their position as directors, the threshold would be slightly different. Where your lordship is correct by saying that the willful default against the borrower would have to be established. But under 2.6 of the master circular, the requirement is only the inability to pay upon receipt of a demand. So even if this aspect of it goes without conceding, of course, the declaration of them as willful defaulters under 2.6 remains because there is a demand, they explicitly refuse to pay the money. So today, your lordship would then have to, in that case, bifurcate the order of the identification committee, which in my understanding would not be otherwise permissible. So even if certain clauses of it goes in the capacity of a guarantor, this would remain. Lordship will kindly give me one more moment. Just to sum up, just. Lordship kindly takes up. Does your Lordship have the
Master
master
circular has been annexed here anywhere. I don't think it is.
I don't think it is.
Yeah, you read out from that and just hand up.
This is my interpretation of it. Lordship will kindly test this, my lord.
Yes.
5.2 position regarding guarantors. It says banks, financial institutions may take due care to follow the provisions as set out in paragraph 3 of this circular in identifying and reporting instances of willful default. So this pertains to guarantors. 3, if your Lordship looks at, which is the reference which is made, paragraph 3 of the master circular, paragraph 3 otherwise deals with identification of willful defaulters, which refers to a borrowing company. So if the procedure is laid down, in my interpretation, again, your Lordship would kindly test this, borrowing company, the word, the phrase, would then have to be replaced by a guarantor. Because that's what 5.2 says. So I get exported 2, 3 from 5.2. So if I read this, the original phrase of the clause I'll read first. The evidence of willful default on the part of the borrowing company and its promoters, whole-time directors at the relevant time should be examined by a committee so and so. But this does not refer to a personal guarantor. By dint of 5.2, which imports the invocation of 3, I would have to necessarily read this as the evidence of willful default on the part of the personal guarantor. So when I read this, the only requirement that is otherwise mandated is under 2.6, which I'll read for your Lordship's convenience, my lord, that in connection with the guarantors in terms of 128 of the Indian Contract Act, the liability of the surety is coextensive with that of the principal debtor unless it is otherwise provided by the contract. Therefore, when a default is made in making repayment by the principal debtor, the banker will be able to proceed against the guarantor surety even without exhausting the remedies against the principal debtor. As such, where a banker has made a claim on the guarantor on account of default made by the principal debtor, the liability of the guarantor is immediate. In case the said guarantor refuses to comply with the demand made by the creditor, banker, despite having sufficient means to make payment on the dues, such guarantor would also be treated as a willful defaulter. So if your Lordship looks at this phrase, and I know this would be something that will be in the bench possibly, my lord, this says that as such, where a banker has made a claim, I'm sorry, my lord, right before that, therefore, when a default is made, Lordship will kindly note this, in making repayment by the principal debtor. So the most obvious question that the court would pose me is, unless, without conceding, of course, unless the default has first been established against the director or the company, how would that be inherited by the personal guarantor? Which is why this particular sentence does not refer to willful default. The fact that the borrower has defaulted is an admitted position of fact. Which is why this line says when a default is made in making repayment by the principal debtor, this doesn't have to come within the ambit of a willful default. So when there is a default, I make a claim against the personal guarantor. Personal guarantor fails to make payment to me. That would tantamount to willful default within the meaning of 2.6. So these would be my humble submission. This would be my Lordship will test it, of course. So just to sum up, so if that is true, even if there's a discrepancy between the show cause and the finding, the effect of the order would be the same under 2.6. So they would still be declared as a willful defaulter. Those are my submissions.
In WPO 1573, please take your seat. In WPO 1573 of 2023, the writ petitioners have challenged an order passed by the Willful Defaulter Identification Committee within bracket first committee bracket closed, declaring the petitioners to be willful defaulters, full stop. In WPO 1729 of 2023, in continuation of the same process, the review committee affirmed the findings of the first committee, which led to the filing of the second writ petition. Full stop, next para. Learned senior counsel appearing for the petitioner contends that insofar as the review committee is concerned, the master circular clearly provides in clause 3 within bracket small c as to the exact composition of the review committee. Full stop, next para. In the present case, however, the zonal manager of the concerned bank took upon himself to pass the said order of the review committee, which is thus palpably dehorse the master circular. Full stop. The zonal manager, under no stretch of imagination, could exercise the powers of the review committee as envisaged in the master circular. Full stop. Next para. Hence, the entire order of the review committee is a nullity, being devoid of jurisdiction. Full stop. In support of such proposition, learned senior counsel cites Sanjay Prakash Bansal and another versus Reserve Bank of India and others, reported at 2023 SCC Online Cal 4657, where a similar proposition was upheld by this court. Full stop. Next para. Learned senior counsel next argues that there is palpable discrepancy between the allegations made in the show cause notice and the observations of the first committee as well as the review committee, within bracket, the latter being almost an exact replica of the first committee order, bracket closed. Full stop. Whereas in the show cause notice, under the head disposing of assets, it was alleged that no stock was available with the borrower company and stocks were disposed of without any credit proceeds with the bank account, in the orders of the review committee as well as the first committee which preceded the same, it was observed that the entire block of, within double inverted, fixed assets, double inverted close, having a net block of rupees 113.80 lakh have been written off, double F, without any justification and documented evidence for writing off the assets. Full stop. The entire premise of the said declaration was such alleged writing off of the fixed assets, which is in gross variation with the allegation in the show cause regarding stocks being allegedly disposed of. Full stop. It is argued that stocks cannot, by any stretch of imagination, be equated with fixed assets, movable or otherwise. Full stop. Next para. It is, thus argued that both the orders of the first committee as well as the review committee ought to be set aside on such score as well. Full stop. Next para. Learned counsel for the respondent bank controverts the allegations made by the petitioner. Full stop. It is argued that in the show cause notice itself, the relevant clauses of the concerned RBI circular, being clause 2.1.3 within bracket small d and clause 2.6 were also quoted. Full stop. Selective quoting of the particular provisions itself indicates that the said provisions should also be read into the allegations made in the show cause notice. Full stop. Mere mention of those particular clauses of the RBI master circular itself indicates that the said language of the clauses were a component of the allegations leveled against the petitioner. Full stop. Since the relevant clause speaks about removal of movable fixed assets or immovable property, it is argued that the show cause notice was in consonance with the orders of both the committees. Full stop. Next para. That apart, it is sought to be pointed out by learned counsel for the bank that in the orders of both the committees, allegations under clause 2.6 of the RBI master circular were also leveled. Full stop. Clause 2.6, it is argued, pertains to guarantors. Full stop. In the present case, the petitioners acted in the capacity of directors as well as guarantors. Full stop. Taking into account the guarantor component of the allegations, it is argued by learned counsel for the bank that guarantors stand on a slightly different footing than directors. Full stop. A distinction is sought to be drawn by learned counsel for the bank between willful default committed by a director of the borrowing company and a guarantor. Full stop. Insofar as the guarantor is concerned, comma, the act of default, comma, it is argued, comma, commences with the guarantor failing to repay off the debts despite a demand having been made to the guarantor, comma, in spite of having sufficient means to do so. Full stop. Next para. Thus, comma, insofar as the petitioner's capacity as guarantor is concerned, comma, there is no discrepancy between the allegation made in the show cause notice and the orders of both the committees. Full stop. Next para. A consideration of the materials on record indicate that undoubtedly, comma, it is the zonal manager of the concerned bank who signed the impugned order of the review committee. Full stop. Although, comma, within brackets, comma, the zonal manager indicated that it was being done on behalf of the review committee, comma, such statement per se cannot justify the zonal manager signing the order himself. Pushed up. Next para. Contrary to the argument of the respondent bank that the said document annexed to the writ petition was a mere communication of the order of the review committee and not the order itself, comma, the very tenor of the said annexure shows that the same comprised of the order itself and was not a mere communication of the order. Full stop. In no portion of the said order of the review committee do I find mention of proper constitution of the review committee as envisaged in clause 3 within bracket small c of the governing master circular of the RBI. Full stop. Moreover, comma, the zonal manager himself was the author and signatory of the order. Full stop. Hence, comma, the order of the review committee suffers from gross contravention of clause 3 within brackets small c of the master circular. Full stop. Hence, comma, the said order is a nullity, comma, being devoid of jurisdiction. Full stop. Next para. Insofar as the order of the willful defaulter first committee is concerned, comma, the petitioners are justified in arguing that there is gross variation between the allegation made in the show cause notice and the order of the identification committee, comma, which was subsequently repeated by the review committee. Full stop. Next para. Whereas the show cause notice alleged that no stock was available with the company and stocks were disposed of without any credit proceeds with the bank account, comma, which was the plinth of the allegation, comma, the order of the first committee as well as that of the review committee spoke about fixed assets having been written off. Full stop. Such gross discrepancy between the allegations of the show cause notice and the order of the committees itself vitiates the orders, comma, since it is well settled that in a show cause notice, comma, the grounds on which the accused person is sought to be indicted are to be clearly mentioned. Full stop. Since the orders of the committees deviate from the said allegations in the show cause on cardinal aspects, comma, it cannot be said that the orders of either of the committees could be sustained on such score as well. Full stop. The last point argued by the bank is that the willful default committed by a guarantor can be differentiated from that of the borrower or its directors. Full stop. Next para. Such argument, comma, however, comma, is absurd. Full stop. The act of willful default emanates from non-payment of debt, comma, which constitutes a default on the part of the borrower. Full stop. A guarantor, comma, as indicated in clause 3 as well as clause 2.6 of the master circular, comma, has coextensive liabilities with the borrower. Full stop. Even from the language of clause 2.6, it is evident that the act of default which ultimately incriminates the guarantor is that of the borrower, comma, which is the genesis of the entire proceeding under the master circular. Full stop. Next para. The expression double inverted coextensive double inverted clause itself is a sufficient indicator of the fact that the liability of the guarantor is on an equal footing as the borrower and its director. Full stop. Next para. Thus, comma, the default committed by the guarantor for coming within the purview of the master circular is not an isolated or standalone act of default different from that committed by the borrower. Full stop. The act of willful default remains the same, comma, which is committed at the first instance by the borrower, comma, the effect of which is coextensive vis-a-vis a guarantor. Full stop. Hence, comma, the argument sought to be advanced by the bank that the act of willful default on the part of a guarantor is distinct and different from that of the borrower is not supported by the master circular or the commercial jurisprudence in general. Full stop. In such view of the matter, comma, the bank apostrophe S observations, no, sorry, the bank's observations, the observations of the first committee in its order declaring the petitioners to be willful defaulter cannot also be sustained. Full stop. In such view of the matter, comma, WPO number 1573 of 2023 and WPO number 1729 of 2023 are allowed, comma, thereby setting aside the orders of both the willful defaulter identification committee within bracket first committee bracket closed and the review committee declaring the petitioners to be willful defaulters under the concerned master circular of the RBI. Full stop. Any action, comma, if taken consequent to or in terms of such declaration also stands automatically revoked and reversed. Full stop. Next para. It is made clear, comma, however, comma, that nothing in this order shall preclude the respondents from proceeding afresh on the basis of the show cause notice, which was the genesis of the present proceeding, and stroke or at the choice of the bank of the respondents, comma, to issue a fresh show cause notice and start the proceeding de novo. Full stop. No address to cause.
Deeply obliged.
Thank you.
Okay. Item number 4.
My lord, I beg to appear on behalf of the petitioner, my lord. I am appearing virtually, my lord.
My lord, I'm for the petitioner, my lord. I'm being led by Rajshri Dutta, my lord. He's appearing virtually, my lord.
My lord, am I audible, my lord?
Dear my lord, we have filed, my lord, affidavit in opposition, my lord. WBIDC on behalf of the WBIDC.
You have given a copy to them?
Yes, my lord. If even reply is ready.
Yes, Mr. Doctor, what is the matter?
Reply to the.
My lord, this is an application, my lord, which has come up. The application is only for, my lord, expeditious disposal. I need not trouble your lordship with this, my lord.
Allowed. I'll fix it on a particular date on January, say 18th at the top.
Very well.
You have used opposition to the expeditious hearing application?
No, the writ petition, my lord.
Very well. Learned counsel for the petitioner submits it a GA1 submits that the present application is for expeditious hearing of the writ petition in view of the urgency involved, full stop. Heard learned counsel, full stop. Being satisfied that there is some urgency in the matter, comma, GA1 of 2023 is allowed, thereby directing WPO 1250 of 2023 to be placed at the top of the list for hearing on January 18, 2024. Full stop. Next para. The affidavits in opposition and reply filed in connection with the writ petition today be kept on record. Are you enjoying any interim order, Mr. Datta?
No, my lord. No, I am not enjoying any interim order. This
Right.
is, my lord, in respect of my claim, my lord, under the West Bengal incentive scheme, Lordship had prima facie held that the claim was admissible, but granted Mr. Siddiqui some time to use an appeal.
The affidavit of service, affidavit of service.
Affidavit of service be kept on record একটা লাইন অ্যাড করে দেবে প্রথমেই ওটা করুন
Grateful, my lord.
Item number 5.
For the petitioner.
Yes.
On the petitioner for lordship, he is a owner of a flat. Now a company petition was moved, praying for.
Appearing for the other side.
I think they will not, because the
Service.
company has already been dissolved. Why am before lordship? A company petition was moved, praying for winding up of the company, and that was allowed. There was a direction upon the official liquidator to take steps. Pursuant to that, my property, which were under my tenancy agreement for 11 months, leave and license agreement for 11 months. On that basis, that was, my lord, padlock was put. Thereafter, company has been liquidated, winding up, complete, everything done. That is intact till date, my property. And that has never been shown as the property of company. Even then, my lord, I had an opportunity to approach this honorable court by filing an GA application in the company petition. But unfortunately, though that's not the procedure, that has been dismissed for default. The main company petition that has been dismissed for default.
So you did not pray for restoration of that?
So I am not a party there.
No, your application was dismissed for default.
My application, the original company petition that has been made dismissed for default. After
company petition dismissed.
yes,
for
that's the fact. I have annexed that.
that has never been restored.
That has never been after winding up. No one is interested.
No, that application was for what?
My application, I was trying to make an application. So since this is not the property of the company, and
No,
that is
what was dismissed for default?
main company petition, the winding up petition.
Then how could it be wound up?
After winding up of the company petition has been, my lord, dismissed for default.
What are you saying?
Yes,
how could there be winding up if the petition itself was
kindly have a look. Kindly have a look, page 60. The first order passed in 2015. It's unusual.
Something erroneous in your.
It's unusual, my lord. Page 60, that's the order of winding up, and page 65, that's the dismiss for default. Now, the official liquidator can appraise your lordship regarding the fact. I have sub copies upon here.
You are not a party there.
No, my lord.
You are a third party to the. This is not an asset of the company.
No.
Serve another notice on the official liquidator.
Great, ma'am.
Please come back with a notice.
Great.
At the time of call, none appears for the respondents, although the petitioner is represented through counsel, full-stop. For the ends of justice, the learned advocate in record for the petitioner shall serve a fresh notice on the official liquidator indicating that the matter shall be listed fairly at the top of the list on December 14, 2023. Day after.
Great. Extremely good.
একটু উপর দিকে
Item number 6.
I appear for the petitioner, my lord.
Salve, what is the matter?
My lord, here, my lord, the petitioner, my lord, has made a complaint, my lord, under section 18(1)(e) of the RTI, my lord, before the commission, my lord, complaining of that the state information provided by the State Public Information Officer, Kolkata Municipal Corporation, is, my lord, the insufficient, my lord, and, my lord, the contradictory, my lord, incomplete, my lord. My lord, the information I sought for, my lord, that that whether in respect of particular building, my lord, sanction plan has been there, is there or not. But in their reply, they have stated, my lord, the building is existing, but so far as the sanction plan, they don't have any, my lord, the information, my lord. Against that, my lord,
Corporation does not have information.
Corporation doesn't.
Then what happened?
But against that, my lord, I filed an application under section 18(1)(e) before the Information Commissioner, that is pending for consideration.
First appeal.
Second appeal before to complain before the.
It's a complaint under section 18 directly to the, my lord, second appellate authority. My lord,
So
kindly
that-
see once, my lord, the page 28, the reply given by the corporation, my lord. Basically, they have, my lord, intent to state, my lord, that there is no sanction plan. The language is something different, but I can understand this much, my lord, from this.
But page
But
28.
they have
my lord.
very, my lord, intelligently, they have not made
The
the
premises
corporation
is
as a party respondent.
Yes, yes, it is party.
So the service close.
They're not so intelligent.
They are not so intelligent. my lord. So, my lord, let them come. I believe, my lord, they have stated if the
Premises is existing one, and as per officer, no information regarding sanction. Yes, exactly. That means there is no.
there is no sanction plan.
They should have said that.
But if
Against
it is
that,
the,
my lord,
if it is answered, there is no sanction plan. All the subsequent questions should not have any kind of answers, my lord. Since all these questions are related to that. If there is sanction plan, then all.
Your section 18, where is that?
My lord, page 32, my lord.
But he sought for some action, punishment against. That
Which is the authority before which it is pending?
But the chairperson.
Which respondent?
But respondent number 2, my lord.
1 and 2 are the same. Oh no,
The State
commissioner.
Information Commission and chairperson.
But 1, 2 is I'm
Shall direct the respondent number 2 to decide your.
But kindly appreciate and kindly see the section 18, the scope of section 18, whether at all, my lord, this the unnecessary it will. But if you lordship so direct, we will certainly do that. But kindly see once. The section 18 is something different, my lord.
For me, section 18 was
My lord.
language.
May I?
Anyone? Yes.
This is completely when there is an inaction on the part of the, my lord, SPI or the first appellate authority. Then only,
18(1)(e), my lord, says if there is a misleading and incomplete.
May be clear, may not be clear.
Misleading and incomplete.
If the answer of the first question is no, then all the, my lord, subsequent questions doesn't have any relevance or any.
Incomplete misleading comes in.
Right.
He may say that. Learned counsel for the petitioner submits that in view of insufficient information being given to the petitioner, the petitioner has preferred an application under section 18 within bracket 1 within bracket small e of the Right to Information Act 2005 before the State Chief Information Commissioner, West Bengal Information Commission. That is respondent number 2, which is pending for quite some time. First up, in view of the innocuous nature for expeditious disposal, the matter is taken up for disposal. WPO 1661 of 2023 is disposed of by directing respondent number 2. When did you file it?
On 5th April 2023.
But one thing is important here, my lord. But he is seeking now, my lord, after filing on the April 2023 my lord, expeditious disposal. But he filed this appeal after 9 months from the date of the corporate answer given by the corporation, my lord.
The respondent number 2 to dispose of the pending application of the petitioner under section 18 of the Right to Information Act as expeditiously as possible within what will be a reasonable time? Tell me.
3 months, lordship.
3 months.
But since, my lord, we are taking up all the matters chronologically. But even then, my lord, it will be, my lord, your lordship passed several orders.
I'll direct you to do it within by end of April, end of February. We're in 12th, 2.5 months. Positively by February 29, 2024. No rest to cause.
Affidavit service.
Affidavit service filed today. Be good.
Item number 7.
7, my lord, I'm led by Mr. Shuddhasatya Banerjee in the matter. So only praying for it to be stand over till
Not today
tomorrow.
only?
Not today.
Not.
Tomorrow, my lord, I have personal difficulty. Day after tomorrow, my lord, maybe. Or any other day except tomorrow, my lord.
On the prayer of learned counsel for the, you are for which respondent?
My lord, a food corporation, only sole respondent, my lord. Food corporation. of India.
Only one.
Learned counsel on the prayer of learned counsel for the respondent, the matter is adjourned till December 14, 2023. Day after tomorrow.
Deeply obliged.
Item number 8.
Mr. Shuddhasatya Banerjee is not come today, my lord.
Not today?
Item number 9.
And for the petitioner, praying for not today.
Granted. Yes.
Item number 10.
10 to holo. 10 not to column. 10 to not to column. Oh,
Item number 11.
My lords, carrying the brief on behalf of the advocate in record for the respondents. I'm being told he's unwell till the 20th. He would not be able to come to court.
You are for the petitioner.
For the respondent, number one. WB.
Well, just make it not today for the time being. Ask him to come prepared in the matter too. I mean, whoever is there. Make alternative arrangements. Still, why till 20th?
My lords, because his mother is ill, he has gone. He's not in the city. So that's why.
You are for the petitioner.
Yes,
What do you say to this?
yes, my lord. My senior advocate Vinay Shroff is in.
What do you say to the adjournment prayer? On the prayer of the respondent, the matter is adjourned till when? 20th?
20th. 21st, my lords can keep.
Till December 21, 2023.
For a state matter.
Yes.
Appearance date.
That's Adar Khan.